Good morning, ladies and gentlemen. Welcome to the public hearing for the Committee on Children. We apologize for starting a few minutes late, but as you all know, we normally don't do meetings this early. So we are all doing the best that we can. With that, we'll begin the meeting, and I believe I'm supposed to give some announcements. Please note where the exits are and follow instructions in the event of an emergency. Also, for the purposes of this hearing, we will be asking witnesses to come up to testify, but we like to we will call the name and give the two on deck so that you know when you're coming up. And as a reminder to everyone, there is a 3-minute time limit. And for members of the committee, because we have a meeting to vote on bills immediately after the public hearing, we are instituting a 2-question rule for both sides of the aisle to ask. Everyone can ask just 2 questions of each witness, and that re-ups for every other witness, for every witness that comes up. However, please note, if you are here to testify, that because of that rule, there may be written questions that will be sent to you from members of our committee. So please be on the lookout for that. Senator, would you like to say hello as my co-chair?
Just good morning to everyone. I'm looking forward to our public hearing and hearing from everyone. And I turn it back to you so we can get started. Thank you.
Thank you, Madam. A quick hello from Rep. Dauphiné.
Thank you, Madam Chair. Good morning and welcome, everybody. I just have one quick clarification, if you will, Madam Chair. The 2-question limit, if we go around and everybody asks their 2 questions and there's information that came up that a representative or senator would like to expand on a little bit, would they be allowed another opportunity to ask, as we usually do a second term? Most of the committees do that. So I just wanted to clarify that, if you will.
Right. We will not be doing second rounds in the interest of time and the respect of our colleagues, because everyone does have other places to be. So that is why we are saying that that there may be written questions after, and those written questions will be given actually to all members of the committee once we receive them.
Thank you, Madam Chair. And I just want to express that I really don't agree with that. I want everybody to have a chance to ask every question and get full details on everything in the public hearing. But I do respect that choice, but I don't agree with it. And thank you.
So noted, Madam. Thank you very much. With that, we'd like to call our first witness, our Department of Children and Families Commissioner Designate, Ms. Jody Hill-Lilly. Good morning, Madam.
Good morning. Good morning. So good morning, Senator Mar, Representative Linehan, Senator Seminar, Rep. Dauphiné, and distinguished members of the Committees on Children. My name is Jody Hill-Lilly, and I am the Commissioner Designate for the Department of Children and Families. We have submitted written testimony for 3 bills today. I will summarize my testimony, and given the fact that even though I have 35 years with the department and the last 5 years as deputy commissioner, this is only my third week in the position as commissioner. So I've asked people from my team with subject matter experts to join us at the podium to answer any questions that may arise. The first bill is Senate Bill 217, an act implementing a universal patient intake form for recipients of behavioral health services for children. We support the intent of the legislation, but have some concerns as it's currently drafted. We support the formation of a work group to review the viability of such a form and to determine what data elements should be captured. As you may or may not know, the Connecticut Behavioral Health Plan Implementation Advisory Board has been discussing the need to develop a master database of all children receiving behavioral health services in the state. Having a universal intake form would certainly assist with that endeavor. However, it is likely during the developmental stages of of that form and the working group's work, it could entail some obstacles to implementing the form, and we're a little concerned about that. For example, how will this form interact with existing electronic health records? What will be the cost of updating the database to capture the data points? Will there be fiscal challenges for the state-operated facilities to implement the form? We suggest that before the development and implementation of the form, the group should report back to the legislature so policymakers are aware of any obstacles that may need to be addressed through legislation. The next bill is HB 5263, an act requiring a report concerning the placement of children pursuant to the Interstate Compact on the Placement of Children. Connecticut has been a member of the Interstate Compact on the Placement of Children, ICPC, for over 50 years. The ICPC is a statutory agreement between all 50 states, Washington, D.C., and the U.S. Virgin Islands that provides for the movement of safe placement of children between states when children are in the custody of a state, being placed for private independent adoption, or being placed by a parent or guardian in a residential facility. The process ensures that when children are placed out of state, they are placed in a safe and nurturing environment that can meet their particular needs. As the child placing agency for Connecticut, DCF received 275 requests in 2022 and 286 in 2023. Much of the language in the bill appears to be seeking an opinion of the practice. From the perspective of DCF, it works exceptionally well to keep kids safe while protecting Connecticut financially. As a legally binding agreement between all states, the ICPC ensures that children enjoy a uniform set of protections and benefits, regardless of which state they are moving to or from. Another critical function of ICPC is to ensure that the person or entities that place a child out of state retains legal and financial responsibility for that child after placement occurs. Recently, revisions have been proposed to the Interstate Compact that DCF is reviewing. If our review is favorable, adopting those revisions will be a part of our legislative proposals next session. The last bill I will comment on is HB 5260, an act requiring an evaluation of a short-term assessment and respite group home for children. A short-term assessment and respite home, a STAR home, is a DCF licensed temporary congregate care program that provides short-term assessment and a range of clinical and nursing services to children removed from their home due to abuse and neglect or other high-risk circumstances. The Children's Assessment Services, the children receive assessment services, educational supports, structures, and care coordination related to family reunification, foster care, congregate care, and other discharge planning as appropriate. STAR home level of care is critical to ensuring that these youth receive necessary assessment and support while continuing to find the most appropriate treatment modalities to meet their needs. Evaluation of all service types, including STAR program, is ongoing and continuous. To further support stability of this level of care, the department has recently transitioned oversight of STAR programs contracts to its Behavioral Health Community Service System Division. The Behavioral Health Division staff have been meeting with STAR program leadership, and DCF leads to assess STAR programs resources, referral services, youth service planning, etc. These discussions will inform the ongoing process of identifying programs, areas in need of additional services and modification. The department will also work to provide partners to enhance the role of this service type in the larger behavioral health system of care. DCF strives to be transparent as possible, while adhering to our confidentiality statutes. Our team is in the process of working with our STAR providers to improve the operations of the facilities and ensure the well-being of the youth there. We expect to finalize those plans in the coming weeks, and we look forward to sharing our plan once completed. I'm happy to answer any questions that you may have.
Thank you very much. I greatly appreciate your testimony, and I too look forward to hearing about the plans for the Star Homes. I guess as today's co-chair, I just have two quick questions for you regarding the placement of children pursuant to the Interstate Compact on the placement of children. Am I right in my understanding that your job in this compact is simply to work with the other states from where that family is coming from, just to kind of keep eyes on and ensure the current safety of the child or children in question, and not actually anything beyond that?
Absolutely. You're absolutely correct. And all states are involved in the Interstate Compact agreement. And I have a subject matter expert here. And so we'll get a call from a receiving state to say, you know, we have a child who's moving over into this home. Instead of that state, you know, having a social worker come up and assess, the agreement allows the CPS organization to go in and assess the home for safety. And as I said, this is a nationwide practice, and it is consistent across the country. I want to pivot to my subject matter expert to see if I've left anything off. Please say your name and if there's anything else that I need to.
Good morning.
So-
My name is Carmen Fuentes. I'm the supervisor of the Interstate Compact Office, and that's correct. It works both ways. So when we get children as well, then we monitor the situation, we assess the homes, and when we want to send children out, we submit a request to the receiving state and ask that they do the same.
So it's essentially just another set of eyes. So I guess then my secondary follow-up question to that is there ever a time when you are working with another state during this compact and the execution under this compact, that the Connecticut department then takes over the case, any open case that would be originating from the other state?
In order for that to happen, there would need to be a legal transfer of jurisdiction, and that involves the courts. So the court could request that we assume jurisdiction, and then our court would have to agree to such assumption of the jurisdiction of the child.
Great. So I take that to mean that then it stays in the jurisdiction of the original state until such time that it goes through the courts, which is not something that you guys would handle, but it would be something that you would then handle after it goes through that process.
Absolutely correct.
Great. Thank you very much. Senator Marr?
Thank you. Thank you, Commissioner. It's good to see you. A question on the Star Home Bill HB 5260. You mentioned that the oversight of the Star Home program contracts have gone to Behavioral Health Community Service System Division. And I wanted to know if you could speak a little bit about where they previously had oversight.
So previously, how can I say this? I have Deputy Commissioner Williams here. I'll let him talk about this because the transfer happened under his domain, and I didn't see you sitting there, so I'm glad you're here. You can talk about the shift.
Thank you, and good morning. I'm Michael Williams, Deputy Commissioner of Operation. For years, our children's mental health oversight and program was lodged within a larger division and not a set aside, not a division of itself. And congregate care management and all congregate related kinds of programs sat within our transition and support success program. It was not a convenient fit, but the only fit we had at the time. And it was conflictual because also within that division was our licensing department. And so they had oversight of the licensing of homes and the oversight of the utilizations of the homes and the oversight of program management of the homes, which could create a potential conflict that if we had a licensing issue, but we also had a need for those beds, you could see how it can rise up to the actions that can be taken. So to give objectivity to our licensing department so that they don't have any, pressure of forming their duties upon licensure because of the placement need, we move the management of the bedded services in the programs underneath the newly elevated Children's Behavioral Health Division in the agency. And so when we elevated that division about a year ago, then we began to look at what else needs to go under there. And that was the rationale for the shift.
And if I can add, under my administration, I have made a decision to elevate that division even higher so that Dr. Frank Gregory, who is with us today, that division will be elevated to an even higher level, having a direct report to me. So we see the need for the attention that needs to be on the behavioral health crisis that we have and as such, we've elevated that division to an even higher infrastructure.
Thank you very much. A second question, Dr. Gregory. Commissioner, I'm going to go straight to him
Thank
since
you.
you pointed to him.
Yes.
Thank you. I just wanted to know how you see this change affecting the service provision at the Star Homes.
Good morning. I'm Frank Gregory. As the commissioner said, I oversee community behavioral health services. I think our intention is to provide not only the ability to enhance accountability, but really the ability to improve support, to equip the programs to do the work that we've asked them to do, and particularly recognizing that many of the children who are in those homes, the majority, have complex needs, including complex behavioral health needs. So it's our intention that we can work with the programs really to ensure that what is happening within the program is responsive to the needs of those kids. We also recognize that Star Homes don't operate in a vacuum. They're part of a broader system. So we're also looking at the systems issues that impact the programs and the kids in those programs so that we can similarly identify where we need to enhance resources.
Thank you. Thank you, Madam Chair.
Thank you very much, Madam Co-Chair. Representative Lanu.
Thank you. Good morning, Madam Chair. Nice to see you. I just want to respectfully just also note for the record, I want to echo Representative Dauphinet's comments.
So noted.
Thank you. And specifically on ICPC, this is a very complex, difficult document, agreement. We're going to hear some testimony from later on from a family, a mother and father who lost custody of their kids, of their infant children. And I think that the public definitely needs to hear this. And I think it's going to take more than 3 minutes and 2 questions to be able to dissect this in a way that the public can properly hear that. So again,
Just for the purposes of process, Representative Lanu, it's 2 questions per person. So if every member wanted to ask 2 questions, that would equal quite a bit of questions and we can get to the heart of the matter for sure.
Understood. I understand that. But again, all our minds work a little differently here. We may have different questions. So again, I'm not going to belabor the point. I would like to have that noted though for the record. And we'll hear that testimony later. Madam Commissioner Designate, good morning to you.
Good morning.
Nice to see you again. And I bet you're gonna know where I'm gonna be going with my questions. So my concern here is with the ICPC.
Mhm.
What we have with HB 5263.
Mhm.
The interstate placement, the interstate compact on the placement of children.
Mhm.
My concern with this agreement, the way that it may be currently worded, my question to you is if there is a Connecticut family that is moving here, is living here, let's say there's somebody who currently resides here, they're on vacation in another state. An allegation happens, an alleged circumstance happens or situation, the equivalent of the Children and Family Services or whatever name you want to give that in whatever other state makes a decision and says, we're going to remove, these parents are going to lose custody of their children, right? And let's say it's completely off base, completely unfounded, and it's against Connecticut residents who just happen to have their feet in another state at the time. Does Connecticut DCF have any flexibility on that underlying matter, on the underlying circumstances that this other state used to make a decision? Do we have any flexibility as a state of Connecticut, as DCF? Can you guys independently investigate the underlying matter, the underlying circumstances, and the underlying decision made by this other state?
I appreciate that question, and there are statutory questions embedded in your question. So what I'm gonna do is to ask our general counsel, Susan, our general counsel to respond to that question.
Good morning. How are you? I think in response to your
Excuse me.
question, I'm sorry, I didn't say my name. Susan Hamilton, General Counsel at DCF. Thank you, Senator. The question you're asking, I think, is outside the scope, obviously, of the ICPC. That's not something that would be handled and processed pursuant to the ICPC. But in terms of any reports that we might get, sounds like your question pertains to a family Connecticut resident family who might be traveling out of state, or was it the reverse?
Connecticut residents that are
Yeah.
out of state at the time.
Yeah. And you were posing the question about whether, if the state where they have traveled has made a report to us or has taken action in terms of a removal?
Correct.
Okay, well, the court, if they're traveling in another state, that state wouldn't necessarily have ongoing jurisdiction over that matter if they are Connecticut residents. There's jurisdictional requirements for how long a person is in a state that would allow them to continue to keep the child in placement. So that isn't something that the courts would have to work out what arrangement would be made for purposes of continuing the child in state care. But I don't want to call it the receiving state, because that's not what it would be called, because it's not an ICPC situation, but the state where the family has traveled is not, they have to be there for a period of time in order for that state to retain jurisdiction over the case.
And what period of time is that?
I think it may vary. I'd have to get back to you specifically on the jurisdictional requirements of what would allow them to do that. They have immediate jurisdiction if you're present in the state, same like we would. If a family was traveling to Connecticut, and there was an emergency that warranted some type of state intervention, we could intervene. But that state wouldn't normally retain, same if a child came here, we wouldn't retain jurisdiction over the case. But I think I can get you some additional information about that, and maybe be able to answer your question a little more directly.
Okay, so again, my concern, and I think we're going to hear some testimony a little later, is if another state, and I don't want to speak to this particular matter, but in a situation where in a hypothetical another state, a family could be traveling through, something happens, and that state makes a decision. We're essentially bound by that decision. That's the component I'm very, very concerned about. Now, I think it at least warrants, and hopefully the testimony will yield this later, is I think we need to at least have a look And again, we need to thread a very, very thin needle here. Because certainly in the same type of hypothetical that I posed to both of you. If there is a family goes to another state, a state makes a decision. There's an alleged situation that happens, that state makes a decision regarding those children, the placement of those children, that they should go with relatives and people they know, and they don't end up in a strange place, in a strange state with God knows who, God knows where. So I think that's a very important part of the ICPC. My concern is where the state makes a decision, if you're there for 5 minutes and they end up making a decision on taking away your children in the state of Connecticut, if you're a Connecticut resident or a military transfer, and they make that decision, we have to essentially enforce that, and we can't independently look at it and make our own decision based on the ICPC agreement. That's a concern I have. And I think it, at least to me, warrants a look under the current language of 5263. The chief court administrator and you, Madam Commissioner designate, assuming you become commissioner, will be charged with looking at this. Do you have any problems, Commissioner? And again, I apologize if I'm putting you on the spot, but do you have any issues with looking at this, being able to have families come in, listen to their a more advanced testimony from them, from legal counsel, to be able to make a decision and give us a report as far as with the chief court administrator, if perhaps we can modify the ICPC in some way?
So being who I am, 35 years in the field, a social worker, I would never be opposed to hearing, from constituents, families who have some concern about an agreement. I think our testimony here is to support the ICPC process that is in place right now, and that is one that is used across the country. And so that we wouldn't want to do anything that's out of sync with other jurisdictions. My suspicion is that the issues that are concerning you and others are separate and apart from the ICPC conversation. And so I would respectfully ask that we dissect that just to make sure that it's not an ICPC issue, but it's that it's a decision made based on the facts that were presented to us, separate and apart from the ICPC, because that's what I think is happening.
Okay, so for maybe for respect for as far as this language goes in 5263, would you recommend perhaps a modification and some amendment, some language change where we can expand that perhaps even beyond the ICPC, where this will give the families a chance to come in to weigh in when there's a decision made from another state, how this affects placement of children, how in Connecticut, and how Connecticut may not be, their hands may be tied as far as looking at the underlying matter that happened in another state that as it relates to Connecticut residents. So do you think we should have some kind of language modification to expand the scope of the report of what you and the chief court administrator would be looking at?
I'd have to hear more about the nuances of what you're speaking about, but as long as it's outside of the ICPC, which I think this is, again, separate and apart from that, if you're looking solely at how we respond to incidents of abuse and neglect, when there is someone who is in the state of Connecticut, has recently come to the state of Connecticut, if that's something that you like to entertain, I wouldn't oppose it, but I'm not sure that it's necessary, but I wouldn't oppose it.
Yeah, I mean, I'm sorry.
Thank you very much, Representative.
Okay.
We're going to see if any of our colleagues need to ask some questions. Are there any questions from other members of the committee? Representative Dauphiné.
Thank you, Madam Chair, and thank you, Commissioner, for being here today. We appreciate it. So as I understand it, the jurisdiction of a case can only be transferred to another state after a verdict is reached. Is that true?
I'll punt that.
I'd honestly have to look at the underlying provisions that apply in both of the states outside of the ICPC to really answer your question. And I'm going to suggest perhaps that if there are specific questions regarding either the bill or the process outside of the ICPC about how our state and I don't want to say receiving state, other states where Connecticut families may travel, so that we can give you real specific details around how the process currently works.
Okay.
And at what point, when the courts are determining which state should retain jurisdiction, at what point, and we could probably bring the courts into the conversation as well. But I think starting with an understanding of how the process works, both in Connecticut and in other states, we can perhaps answer that question with a little more specificity.
Well, yeah, we'd love that opportunity. I think what Representative Lanu talks about is something that we've experienced ourselves, where a family who resided here was visiting in another state, and there were actually accusations made, and they were only there for a very short time and back here. So you can imagine the complications that come with living here and having to deal with another state. So I appreciate that and would love to have more time to talk with you with regard to specifically to that case. And one more question. You said that the ICPC has been in place for 50 years and has worked well. And we all know that there's glitches, right? So can you just briefly tell us maybe about some of those glitches that may have occurred that you've experienced with regard to how maybe that they could be improved?
I know that federally, they're looking at some technical changes to the ICPC agreement, but I would definitely punt to my subject matter experts to talk about any, sort of hiccups that we've experienced with ICPC.
Good morning, Natalia Liriano. I'm the Director of Foster Care for DCF. In terms of the ICPC, I think when you have 50 states that probably have different processes, different forms, procedural, just operating their child protective services work, there are differences. So there are things that we require by statute, by policy, that another state might not require by policy or by statute. We all adhere to, the federal guidelines by ACF. So that's an area. There is another area in terms of data sharing, technology, and how other states collect information and report out information compared to us. There is a committee that is looking at all that work to streamline the process. There's a lot of work coming up, like the commissioner mentioned, about legislative changes that are being proposed across the country for all states to adopt. Another area is border agreements. So I would say just the differences in operations from one state to the other, and data sharing are probably, and border agreements are probably three of the main areas where, it can get a little technical term wonky, if you will.
Thank you for that. And I appreciate you being here. It sounds to me like this ICPC is federal across all states. So it, like everything else we know, when it's federal, it's much bigger. So it's a lot more difficult to make changes and nuances that need to kind of address those different states. And I think I'm starting to get to understand that, but I would love to have an opportunity to meet with you personally and discuss the case. Thank you so much.
Absolutely.
Thank you very much, Madam Ranking Member. Representative Wieslander.
Thank you, Madam Chair. Good morning and good morning to everyone. Thank you for being here today. I had a question about 5260, which is the evaluation of the congregate homes. And just, please forgive me because I don't have my notebook that I had with me when we had the hearing on the Harwinton House. Am I remembering this correctly, that the staff of the Harwinton House are actually not technically employees of, or were not technically employees of the state, that they are technically employees of a management company or staffing company?
Not a staffing company, but, and I'll let Dr. Gregory sort of chime in, but they are not our employees, correct?
Mhm.
They are employed by the nonprofit agency that oversees the programs.
And I will just add, some of the nonprofit agencies do contract with employment services
Mhm.
who can staff clinical staff or residential staff. So there may be some staff who are on contract to the provider in that way. I don't know if that's what you meant.
Yes and no. I'm concerned about, and I'm wondering if this is something that we can sort of adapt or amend this bill to look at what is the best way that we staff these facilities, because that way you are in a direct line of communication with the people who are overseeing the care of the children who are officially under your care, and whether or not that might lead to better retention. We can understand if there's concerns earlier on, things like that. Would that be something you would be open to discussing in the future, or?
Absolutely.
Okay.
Yeah, absolutely.
And the other thing that I would love to potentially discuss in this bill is looking at the length of stays. I know ideally we want children to go into the best placed facility for themselves in moments of crisis. But in certain situations, it seemed like that length of stay went far beyond what those facilities were designed for, and especially looking for children, yeah, that had higher needs. So is that also something that you would be open to potentially?
Absolutely. I mean, we've been evaluating that for ourselves. And as the needs of our children and youth sort of merge and evolve, we understand that there's a little bit of a gap in service provision. And so we are actively looking at that. So certainly open to whatever conversations you feel are necessary and appropriate.
Thank you. Thank you, Madam Chair.
Thank you very much, Representative. Do we have any questions over here? Representative Master Francesco.
Thank you, Madam Chair. Nice to see you, Madam Commissioner. Thank you for being here. I have just one, actually 1.5 brief questions, maybe 2. Might as well use it up, right? On Senate Bill 217 that you testified on, it was the universal, excuse me, patient intake form. In your testimony, you had mentioned that the Children's Behavioral Health Plan Implementation Advisory Board was in discussion to develop a master database for the children that are receiving behavioral health. Can you elaborate on that a little bit? Exactly what would that database entail and what would be the purpose of it?
Okay, I'm gonna punt that to Deputy Commissioner Williams.
Sure. Thank you and good morning.
Morning.
Yes, in the development of the Connecticut's behavioral plan for children, one of the areas that those who developed the plan felt was needed was this notion of data management and service utilization and coordination of services, to be sure that we know that if a child is receiving clinical services at school and they come home and they have in-home clinical services as well, that there's an opportunity for those providers to be able to talk to each other and to be able to see exactly what has happened in both places. And the way in which most states kind of do that is through this notion of a master patient index, so that index, that patient index identifier for that child would be available to every provider who's seeing and treating and providing services to that child or that family. So those providers are not necessarily treating in the dark. They're treating with the information that the other providers are entering into that child's record, so they can see whether the child is on psychotropic medications or not, whether the child has had a recent hospitalization or an emergency department visit over the weekend. They can open the case and see that kind of information. Right now, the gap in information sharing is so large in our system that we find a lot of redundancy happening, and people treating our children without knowing what the others had done. So that was the solution to that problem.
Thank you. So I'm assuming we have no database now. And should there be a database and they had this universal form, based on what you're saying it would help the physicians or the providers communicate with each other. I don't have any further questions for now. I just had a concern about that. My concern is the intake form being such universal. every physician, every behavioral health issue is different, is tailored. Certainly something that you would hope that the providers would work with each other on their own to provide. I can see if the state of Connecticut had a database, now you're talking about a whole new department to manage that database, and the cost of this effective. But thank you, for coming in, and I appreciate it. Thank you.
Thank you very much, Representative Comey.
Hi, thank you, Madam Chair. Hello, thank you for joining us today. Since we're speaking about the data, the sharing of information on mental health, I was wondering, the system, the Connie system, which was implemented before or was voted on here in the legislature, I think a year or two before I was elected. I'm unclear. I have had providers, mental health providers, say to me that they're not actively, they're complying with the law, but they're not actively sharing the information. Can you discuss until something works its way through the courts or something like that? So I was wondering if you could discuss what role the Connie system plays and if it plays a role at all in this. Thank you.
Currently in the children's behavioral health system that we fund and most of the public sector services, it doesn't play that large of a role. A lot of data collection and data entry from providers we collect for those that are DCF funded programs in our own provider information exchange. At time for Medicaid funded services, Carelon, who's the administrative service organization, collects in their data management system. We're very careful with the firewalls that, you know, if a family has mentioned to us, we can't access their data without a consent. And so making sure that families are assured that their information isn't being shared with DCF inappropriately is a part of our system, but the Connie system isn't that active in those processes right now.
Okay, thank you.
You all set? Great. Any questions on this side of the room? No? Any over here? Any online? Seeing none, thank you all very much for being here. And I'm sure we will get back to you with follow-up questions on behalf of the committee, and then we will distribute those answers to all committee members. Thank you all very much.
Thank you.
Next up, we will have Elizabeth Proietti from the Office of the Early Childhood, followed by our child advocate, Sarah Egan, and Representative McCarty. Good morning.
Good morning. My pleasure to be here. Nice to see you, Senator Marr, Representative Lenahan, Representative Dauphiné, and distinguished members of the Committee on Children. My name is Liz Proietti. I'm the Director of the Licensing Division for the Office of Early Childhood. Unfortunately, Commissioner Bai couldn't be with us this morning. She is co-chairing the Early Childhood Cabinet with the Lieutenant Governor, so I'm here to present testimony on her behalf. The licensing division, as you may know, is responsible for licensing and regulating childcare and youth camp programs. And I'm here today to testify concerning Senate Bill 215, an act concerning youth camps. Section 1 of this bill would require the OEC licensing staff to inspect a newly licensed youth camp no later than 48 hours after the licensee commences operations. The OEC would be required to give priority to applicants for an original license and those licensees who hold a national accreditation and where there are no complaints or violations from the previous year. The American Camping Association is an organization that accredits camps and focuses on health and safety. While we know that there are 47 American Camping Association accredited camps in Connecticut, where 34 are day camps and 13 are overnight camps. The OEC does not currently seek to obtain such information on the application for a youth camp license. The OEC finds the proposal in Section 1 to be reasonable with the intent of ensuring the health and safety of our young children. For the 2023 camp season, the OEC received approximately 40 to 45 new youth camp applications. While it may be possible to conduct inspections for those new licensees within 48 hours, we do recommend that the length of time from commencement of operations for new camps for their annual inspection be 72 hours. The first day of camp involves administrative and organizational activities, so an inspection on day 2 or 3 might be more indicative of how the camp is operating in a more typical manner. We also think it's important to note that the OEC's current practice is to prioritize 1-week camps for inspections. We also track which camps should be prioritized for inspections sooner than others based on their previous compliance history. Section 2 of this bill would establish a Youth Camp Safety Advisory Council within the Office of Early Childhood. The council would provide advice to the OEC Commissioner on matters related to safety issues at youth camps. The OEC would be charged with providing administrative assistance to facilitate the activity of the council, including ensuring individuals are appointed as members, scheduling and posting notices of meetings, working with the chairs to create meeting agendas, taking minutes, posting minutes, and ensuring follow-up work is completed. This will require additional youth camp staff time. The OEC currently partners with the Youth Camp Safety Advisory Council. The Youth Camp Safety Advisory Council was originally enacted in state statute in 1970, yet was sunset around 1979. Since such time, the council has continued to voluntarily meet with the Youth Camp Division of the OEC. Members are appointed to a 2-year term by the commissioner and make recommendations to the OEC concerning safety issues in youth camp activities based on their expertise. Current members represent nonprofit day and residential youth camps, for-profit day and residential youth camps, nonprofit residential special needs youth camps, college and university youth camps, and community members. The OEC is available and happy to meet with the committee chairs and proponents about this proposal. Section 3 would require the licensee to submit an annual report to the OEC not later than October 1st and detail how the camp was operated, staffed, and supervised, and how the camp responded to medical and safety incidents during the year. The OEC does not oppose this section, but finds it's duplicative since the OEC already captures this information from licensing, inspections, and investigations. Finally, Section 4 of the bill would give the OEC Commissioner the discretion to refuse a camp applicant that has held a camp license in another state that has been revoked by that state's licensing authority. The OEC recently revised its youth camp licensing application to include questions about a camp's history in Connecticut or another state. The updated application has been posted on our website, and the links to the application have also been included in the testimony for your reference. Some of the questions that are included in the updated revised application include: have you ever operated a youth camp in this or any other state? Was the youth camp or any person employed by the youth camp the subject of an investigation by law enforcement? Was the youth camp or any person employed by the youth camp the subject of an investigation by a child protection agency? And finally, to the best of your knowledge, has the person listed as a youth camp director, assistant director, or director of first aid been disciplined, terminated, or placed on probation from any position that involves the care or supervision of children? We also have additional questions that appear below each of those on the application. We added these questions on the application to ensure that we can prevent entities from operating a youth camp with a history of concern to operate and to better protect the health and safety of young children. Thank you for your time and attention. The OEC is committed to working together with legislators, the executive branch, providers, advocates, and parents to better serve our families for young children. And I'd be happy to answer any questions.
Thank you very much for your testimony. I have but one question at this time on behalf of Senator Seminara, who could not be here at this time, but she did want to get some information on the record. So I will do that on her behalf. The question is, if there is a corrective action plan for a camp, is there any follow-up? We believe it's not in statute, but is there anything in your in your process that states that you must do a follow-up to ensure that there is adherence to the plan?
Sure. While there's not anything set in statute, we do have policies that we've developed that would require that we do follow up in certain instances. For some violations, a written response to a violation might be adequate, whereas for others, we do a follow-up. For instance, if we do an inspection and find there's no director on site or director of first aid on site, those things require an immediate correction. We require the camp to submit that information to us by the close of business on that day. And then we would subsequently do a follow-up to ensure that they had that director or director of first aid on site the next day to verify what they had written in their corrective action plan.
And is this a written policy or is it actually in regs?
This is a written policy.
Great. So as co-chair of the committee, I'm going to ask if you could forward that written policy to us to see if it's something that we want to look at actually putting into statute.
Okay.
Representative Boyd.
Thank you, Madam Chair. And first, I just want to start by thanking OEC because you have an impossible task with a lot of stuff happening in a short period of time. And I do appreciate my experience has always been that you want to partner with organizations to have quality, safe programs, not be adversarial. But that being said, I think the committee is struggling with trying to differentiate the difference between kind of 1 week startup camps that are on properties that are not owned by that organization, that are rented, maybe on college campuses or other places, and kind of well-established camps that have long history. They own their own properties. Would it be fair to say that a disproportionate number of correction action notices go to those shorter 1 week camps as opposed to some of our longer, well-established, probably resident camps?
It's a good question. I'm not sure that we have that data
Yeah.
in that form.
Right. Because, you know, in the testimony, you talked about kind of redundancy and stuff. And believe me, I don't think anybody in the committee wants to create redundancy. But I do think the cases that have become very, very public, that have made it into the media, are very, very different than, I would say, the camping industry in Connecticut, right? They're an organization or individuals that are running 1 week camps elsewhere. And right, in theory, at least in one camp, you know, you require for licensure, you know, fire marshal inspections and water tests and all those things. Somewhere that failed, right? So a camp opened with facilities that were subpar, that I understand you don't control the fire marshals, but those papers should have been in place and somebody should have signed off on it. You know, how do we legislatively go after and enhance the process for those camps without penalizing, for lack of a better term, camps that in some cases have existed over 100 years in Connecticut with little to no issues?
I do hear your concerns. I can say when we do an initial inspection for a new applicant, we do provide a lot of technical assistance at that visit. We also are requiring that, like you mentioned, the fire marshal certificate,
Right.
for instance, we require that prior to issuing the license.
Yeah. One of the cases that, you know, was in the paper had pictures of, I can't imagine any fire marshal would have signed off on. I don't know the particular, and we don't want to get into that case now, but, you know, again, I think the push for greater oversight of this is coming from a certain sector that is, by lack of a better term, fly by night, right? And, you know, I've heard kind of anecdotally from some inspectors that they go to a college campus and it takes them a half an hour to even find the camp, and then another 40 minutes to find out who's in charge, right? And so that's very different than if you walk into a well-established, you know, Y camp or something like that, right? Where things are very organized. So, I mean, do you have any specific recommendations on how we remediate where there's clearly a problem in a couple of documented cases, but not create an onerous oversight process, you know, for everybody else who is trying to do the best work that they can?
I mean, I think what we have added to our application in terms of asking those questions about a camp's compliance history in this or any other state when they apply for a license is a good first step. It's something we haven't done in the past. In the case that you're referencing, I think that, you know, this particular camp did submit an application. They were told they couldn't operate until
Yeah.
certain things were in place, and they did it anyway. I mean,
That's fair.
and we followed up. And we found, like you said, things
Yep,
were
yep.
not as you would hope for. So some of it, is on them. But we certainly do have a responsibility to
Yeah,
protect the health and safety of children.
Do you have,
Representative Boyd, excuse me, pardon the interruption. If you could just give us 1 second. We did institute a 2-question rule. However, I'd like to throw it very quickly over to my House ranking member, Madam.
Thank you, Madam Chair, and I will cede my 2 questions to Representative Boyd.
Thank you very much. Representative Boyd.
what a good neighbor. Thank you, Representative Daphne. I lost my train of thought now. 2 questions and a very brief suggestion. Do you, and I know this puts you in an awkward spot, does OEC have the staff and the resources that you need to actually go out in a timely manner, right? Because that's what a lot of this is getting at, to, visit camps and be able to make either you're doing a great job, have a safe summer, or make remediation action, fairly quickly. Do you need more resources?
We definitely do need more resources. As you know, the youth camp season is a sprint. We struggle with obtaining seasonal staff. The staff that we have had season after season and we've had these individuals for years, thankfully. So then when we do bring them back in, the training, the updating is relatively easy. But yes, we definitely could use more staff in order to do just what, you're asking, more follow-up, more technical assistance, just more.
And have you denied any applications within the last couple of years? Have there been applications, or have they all been given conditions that would need to be met to open?
This is Keisha Hewitt. She's the supervising nurse consultant who oversees the youth camp division.
Bless you.
Hello. When we go out to do these preliminary inspections, they have a corrective action plan of things that we require before we can issue the license. If they don't issue those, if they don't send those in to us, then we don't issue the license to them. So most of the times they cannot meet what we request, and they just either they go away, or if we think that they're operating, then we would send someone out to make sure that they're not operating.
Okay, thank you. And it's not a question, it's a statement. If you want to win over a lot of fans in the camping industry, please make the application for Camp a fillable form PDF. Thank you.
It's definitely on the list.
You gotta love Representative Boyd. Senator Marr, please.
Thank you for being here today. Not really a question per se, just a statement. Camps are so important to the children in the state, to the parents who are working, to educators who then know that the children are coming back after a safe and engaged summer where their brains are being utilized and they're enjoying the nature, being outside and being in nature in some instances. So I just want to thank OEC for the work that you're doing, and also wanted to just ask a question about the work that you've been doing to look at the camps and do the evaluations, and how that is accessible for parents.
Well, information is accessible to parents because we do post all of our inspections online on the 211 Childcare website. So if someone is interested in finding out a camp's compliance history, they can go to 211childcare.org type in the name of a particular youth camp or the area of a youth camp, wherever they're looking for camp services. And the past 5 years of inspection history is listed there. They would find any violations cited during the inspection, as well as the corrective action taken by the camp.
Thank you. And having heard how that process takes place with iPads and fillable forms, I echo Representative Boyd's request.
So it shall be. Thank you. Are there any other questions from members? Any online? Seeing none, thank you very much for your time.
Thank you.
We will next be calling Sarah Egan from the Office of the Child Advocate, followed by Representative McCarty and then Representative Candelora.
Good morning. I'm Sarah Egan. I run the state's
Good
Office of
morning.
the Child Advocate, an independent oversight agency charged with reviewing and reporting out regarding the efficacy of publicly funded services for highly vulnerable children. It's nice to be with you all this morning. We submitted written testimony on a number of bills, but I won't read it. I just wanted to highlight a couple of bills we thought were particularly important. At the outset, I did want to say we did not submit testimony on the ICPC bill. It's just been a number of years since I interacted with that compact, but we are supportive of any work the committee wants to do to review any concerns about the intersection of, I think, a couple of different 50-state compacts around jurisdiction of children. So we're here at your disposal with anything that you may want to look at. So I just wanted to put that on the record since I don't have written testimony about that. So the first bill I wanted to highlight is Representative McCarty's bill about grief counseling for children, which is a huge need. And this bill has been brought up before. And I wanted to lift up a recent work from the Commission on Children that talked about that there are an estimate maybe more than 20,000 children that will lose a family member, a parent, or a sibling before they turn 18. And as we know, in the midst of a children's behavioral health crisis, a workforce crisis, the likelihood that these children can easily connect to the appropriate supports is probably limited, right? And so I think this is a really important initiative. And I think that grief and how to support anybody, but how to support children who are grieving is not something we do very well at, I think, culturally and maybe systematically. And I think that it really needs attention. So I appreciate this bill coming up again. And one of the recommendations we put in here that I'm going to work on next week is I think there may be an opportunity to use the state's opioid settlement advisory committee funds to where we need to do more to look at the impact of opioids within the context of families. And that's money that the state has with a broad permission to remediate the harms of the opioid epidemic. Not that grief counseling is limited to that, because it's not, but there may be a funding opportunity there. And we know already that we lose between 1,300 and 1,400 adults every single year just from opioid overdoses. So I think that would be an appropriate use of money to think about how to use dollars to support regional approaches to offer grief counseling groups and opportunities for children that have lost a loved one. So that's an idea, and I'm committed to working on that any way the committee wants to, and certainly with legislators too, and members of the OSAC committee. So I thought it was very important. The 5262, an act concerning a sexual abuse and assault survey. Thanks again to the committee for continuing to be the policy leader on these issues. You've passed so much legislation over the last several years, but there remains enormous work to do. We know that, right? And we see that all the time, that sexual abuse is both prevalent and underreported and inconsistently responded to by child serving organizations where our kids are. Even the camp bill, which we also testified in writing. I mean, where does abuse happen? It happens where children are. And it happens when you don't expect it. And we know that from what we do know from research about what children say, we know they underreport being abused and neglected. We know that children never report, I am abused or neglected. That's not how children talk. We know that we need to have a better detection, prevention, and response system, which includes having appropriate oversight from a regulatory perspective from the places that children are. And it means that as the legislature has passed mandates, let's say for school districts, that this bill is really seeking to make sure that a survey that I think was already in place and already contemplated pre-COVID that would ask districts about their compliance with various criteria that the state has around sexual abuse prevention response would get done. I think that's a really important tool. So we do strongly support that. And I wanted to lift up some written testimony today from my colleague Beth Hamilton, who is recommending that be done on a periodic basis and that the information from the surveys be available to parents and consumers. And I'm a big believer in public accountability and transparency for child serving systems. So I would strongly support that recommendation. Just checking my notes real quick. So the Star Home Bill, I mean, that's the one I really wanted to focus on with all of you today. And I appreciate the bill being raised that would look at, having DCF report back on the Star Home. So I wanted to say a couple of things at the outset. One, we have a new commissioner in place, and she's new, but not new, right? And I did want to say that while the Office of the Child Advocate's charge is to investigate and report out on these systems, and that can create tensions between agencies as we execute those responsibilities, we are committed and I think are engaged in a candid and constructive conversation with the department on the issues of the day, some of which you may have been reading about, talking about here. And this is one of them, though. And so I wanted to highlight the Star Homes are not working. It's an old model. It doesn't work, right? The only deliverable is it a place where children can go when there's an emergency? It is a place that will take children who are coming out of the emergency room, who may be coming out of detention, who have no place else to go, who are coming into DCF care at the last minute. But it's not a treatment setting. It is a shelter model of care. And that's not disparagement towards the providers who contract with the state to try to do that work, right? I'm glad somebody says yes when that contract is out there. But it isn't working. And that's why we have the kinds of problems that have been reported and that have been discussed in this committee. And a couple of things I wanted to highlight from my testimony. So I talked recently with a young woman who I think the committee will hear from later today, who I go way back with, who's now a policy professional, but who was in DCF care here in Connecticut, who lived in a Star Home. And she and I have been email tagging on this issue. And one of the things she reminded me is how important it is to center the stories about these levels of care, to center the stories of children, right? And she also had another recommendation that I hope I'm not speaking out of turn when she testifies later, but that I did add to my testimony last night. But in the report that we issued to this committee in October, we gave you some stories of the children who have been in Star Homes in the last couple of years. And if I can, I just wanted to highlight a couple of them. One is Teresa. These are pseudonyms, who has been committed to DCF since 2021, has what I would call a severe child abuse history, is diagnosed with PTSD, anxiety, depression, reactive attachment disorder. She has a history of concerns of sexual trafficking and has been referred for services. She has no reunification resource identified. She has a history of hospitalization and suicidality. She has been in multiple Star shelters while in DCF care. Records state that DCF continues to seek a home setting for Teresa. However, due to the lack of foster homes or previous placement options not being receptive and taking her back, she remains in the Star home. She has had 23 placements since entering DCF care in 2021. That is not unusual. The median number of placements for children in a sample of girls that we looked at in the Star homes over a not long period of time was 8. So these are children moving rapidly through our system. DCF made referrals to find various services, including therapeutic mentoring and life skills for her. Teresa is described as smart, eloquent, funny, friendly, determined, and self-aware. She likes sports and prides herself on being artistic. As of October 2023, she was currently residing in another Star setting. I won't read all of these profiles that I put in here, but I do think that they're very important. I know the committee cares about them, and I just wanted to highlight one of these stories. From our investigation of the Star homes last fall, we found that on October 4th, 2023, there were 31 children in Star placements with an average range of 13 to 18, which is a big swing of age in a group setting for teenagers. 90% of the children are children of color. All of the children were in DCF custody. This is also licensed as a short-term shelter, maximum length of stay 60 days. The actual length of stay for the children at that time ranged from 5 days to 533 days. Half of the children had been in a Star placement for more than 100 days. OCA looked at information regarding a sample of 22 girls who resided in Star homes during 2023. Almost all of the girls had a history of having been sexually abused. Most all of them had histories of significant psychiatric treatment needs, suicidal ideation. Most of the girls had moved through multiple DCF placements, diagnoses, vary PTSD, depression, reactive attachment disorder, and intellectual disability. I also wanted to highlight, of course, I have no page numbers on my testimony. I apologize for that. But right underneath that, we talk about access to treatment. I always forget the page numbers. I put them in at the end. I forgot them. Access to treatment for children in the Star homes. It's not a treatment model, right? It is a direct care staff model. There is a clinical director. There are, but if you'll note, if you have my testimony, you note, when DCF regulators go out there, one of the things they look at is how much treatment, how many groups, what are you actually running here, right? And this note that I included here in our testimony, I think is emblematic of what that really looks like in that level of care. So the licensing question in the record was, are the youth receiving the minimum weekly clinical treatment, 1 hour individual, 2 hour groups? If not, what are the barriers? The answer in the regulatory note authored by DCF, no. During the review period, which is 6 months, most youth were either unstable and in the hospital for extended periods of time or AWOL from the program, which prevented consistency in clinical services being provided. Also, during the review period, there was only 1 youth in residence agreeing to participate in group, so groups were not held. The most recent youth that were served by the program had significant behavioral challenges, including frequent and extended periods of AWOL, and there are significant concerns with some youth being victims of domestic minor sex trafficking. Also, some youth were sent to the emergency room for psych eval due to youth demonstrating unsafe behavior or threatening harm to themselves, resulting in a revolving door, with youth having multiple trips to the ER or a youth being admitted for inpatient stays. This had a significant impact on the frequency of clinical service delivery. I think that's the level of care in a nutshell. That's who we're serving. And the challenge is the system needs a place for children to go in an emergency. So we don't have kids sleeping in DCF offices or staying for 30 days in emergency departments, though we do anyway. Or languishing in detention. So you want that, but I just wanted to be really clear that is not working. It's not a huge number of children, but you may have 100, 120 children in a year that rotate through these placements. And as Dr. Gregory said earlier, and I appreciated his point, it's a system problem. So it's a contract issue. How are we funding the Star home? Not adequately, right? It is a model question. How do we intend to deliver clinical services in that model? And then how do we ask a child, a 13-year-old child, this may be their first placement with the trauma of being removed. It may be their 8th placement, which children only experience as rejection. And now it's like, well, talk to this clinician about what you need. And then after 6 weeks or so, we'll get you out of here. And then you can talk to this clinician about what you need. But children are not going to do that. So that means we have to rethink the model of when we have a child traumatized, abandoned, rejected in their minds, let down by adults in their life, probably consistently for a long time, coming into our care, as state custodians. What does that engagement and service delivery need to look like? Does a model like this fit into that? And if so, how can we do it differently so that we're connecting the child to supportive adults who can then stay with the child as they leave that setting and not have to start them all over again, right? How do we deliver a greater level of service to the children where they are in a way that's going to be meaningful and developmentally appropriate? We are not doing that now. That's not the model. We're not paying for that now. I just wanted to draw your attention to some of the responses from the Department to Appropriations Subcommittee questions about that issue. And we are vast. I won't read through it line by line, but they are noting that DCF is noting that we are underpaying for each of those positions, sometimes dramatically. So even within the model that we've created, you can't get staff to work there, right? Direct care staff is a $17 an hour position. Even the lower level clinical position is very low compared to the market rate. So I'm going through that to say it's really important. It's really urgent. I think there are things we have to do this session from a funding perspective to address that. And there are things we have to do urgently around the model. And if we want to ask our providers to do more clinically, we're going to have to pay them for it. I mean, that's the reality of it. So our testimony, I'll wrap up. I know I've gone on and on about it, but we have a number of recommendations that track through that. And we gave you language for your consideration at the end of the testimony, should you be so inclined, that could implement some. I mean, there's no easy fix in statute for all of the things we've talked about, but I think there are things that we can do. The DCF regulatory system for child serving facilities is 30 years old. It's from 1994, right? That's why some of the other language in statute looks the way it does, right? That needs to be updated. And the young, the colleague of mine, I should say, my now colleague, who'll be testifying here later today, made a recommendation that I'd like to lift up, because she said to me, it's not enough to make the Star Home better. She said, because it misses the point of how do we look at who these kids are, how they got here. She's like, you need to constantly be looking at that. And she recommended a permanent advisory structure for child serving congregate care facilities that centers the voices of youth and others with lived experience, harnesses expertise from the provider community, and makes recommendations to DCF and policymakers regarding the unmet needs of children served in such programs. I think that structure fits very neatly into the existing DCF statewide advisory committee structure, which is already authorized to and is supposed to be receiving reports from facilities. I don't think it does. I don't think it has in a while, but it can and should, and we could fit this in there. So that's it for me. Thank you.
Thank you so much. Thank you, as always, for your excellent testimony that really gives us not just more to look at, but actually a deeper understanding of what we need to be paying attention to. So thank you. I appreciate that. Given that we have 2 questions, forgive me for trying to get it all in one. Regarding the Star Homes.
12 subparts.
I'm
sorry, that's what
so question number 1, sub-question A. No, I guess when we're talking about the Star Homes, we have to look at what we can do now and what we need to put in place, and not necessarily make it so tight that we're hamstrung so that we can't react to the changing needs of the kids. So one of the things that you mentioned is that it's supposed to be short term, but it ranges now from, I think you said 5 days to 500 days. In your opinion, would it be more beneficial to transfer out of a short-term program into something that would be not so defining? So if someone needs only short-term, that it is short-term, but if someone needs longer-term, that can work too.
I think that's a great question, and that's something that has been a topic with providers because what you're saying to the child the minute they come in is don't talk to any of the people here because you're leaving, right? And children need what they need. So I think the temporary nature of it now it is potentially problematic. So I would agree with that. While at the same time, you always want to be moving kids to the least restrictive level of care that's appropriate for them, while maintaining continuity of clinical relationship. So I do think that should be on the table. How we think about length of stay when we do these contracts. Yes.
Thank you. And then finally, we talked about from the beginning of this process, the fact that we need to pay people a better wage to get the best quality to come in and work with these kids. But I think something that is also noted in your testimony and needs to be further explained is that in addition to the quality of the care that is given, it also needs to reflect the needs of the children in their care. So when this was, you said, and I didn't know this, is that these were 30 years old, the provisions in these statutes?
The regulations for congregate care facilities run by DCF, the regulations are 30 years old.
Well, so 30 years ago, I mean, I was but a wee lad. Lass. But I don't know if the term, trauma was really utilized in this sense, right? So when we have trauma-informed practice, we know now that is what's best for these kids, especially when you went through and said that a lot of them were trafficked or they've been sexually abused or physically abused. So if there was some sort of greater trauma-informed practice model within these homes, would you agree that would be beneficial as well?
I would. I do want to clarify that because the regulatory structure is really old, it doesn't mean that DCF doesn't necessarily contract within that frameworks, right? So they'll contract with the provider to meet certain expectations when they go out and look at the home, right? They're trying to document things. So they're, but I still think it's important that the regulatory structure be modernized, right? Because it does limit the provision of care in other ways, right? But yes, I think that we have to be looking at what is the model of engagement intervention that is most appropriate to the needs of the children that you have. And that's why it was appropriate for DCF to transition oversight of the Star Homes under their behavioral health director, because that's what they need to always be looking at, right? And as Dr. Gregory said, the Star Home sits within a continuum of care. And as we've all heard at various tables, that continuum of care is collapsing under the weight of need that children have. And so when we think there's no fix for the Star Home in isolation of doing something about the dearth of intensive community-based services in our communities, which is also a money issue.
Absolutely. Thank you very much. Senator? No questions. Representative Dauphiné.
Thank you, Madam Chair, and thank you for being here today, Sarah. We appreciate it. My two questions are kind of data questions. One, do you know if there's any research that's been done that relates children that have had a loss or a death in the family to the opioid usage? For example, someone who has lost a parent, it may have led to antidepressants and then so on and so forth. Is there any data that you know of?
Can you ask,
regarding-
I'm sorry, I want to make sure I understood the question.
So we talked about
Yeah.
children who have had a loss, a death in the family. Is there any data that you're aware of that shows that children that have lost a family member or suffered a death has led to opioid usage? For example, they start on antidepressants and those sort of things, and then it leads to that. I'm thinking there probably is that going on, but I'm just wondering if you're aware.
So it's a great question. I don't know. I know there's a lot of research about the impact of loss and grief on children's risk for having depression and other things. I think it's a really important question. I don't have that data at my fingertips, so.
I mean, we know that adults do self-soothing with alcohol and drugs and that sort of thing. And I just wondered, I mean, you were talking about using the money for the opioid, and it makes sense to me, but I'm wondering if that would be helpful to make that connection. And then the other question is regarding the any research or data collected from other states and how they're modeling the STAR homes. I mean, this can't be unique to this state. So I just wondered if you had done any investigating on other states and how they're running those programs.
Yeah, great question. The problem is not unique to Connecticut. And I think a lot of states are struggling with what we call the deep end of their mental health and child welfare systems. And a lot of states did what Connecticut did with the right goals in mind of downsizing the use of congregate care facilities for children in the custody of the state, right? But not rebuilding it in maybe the way that meets the needs of children now. So now there aren't really places for children to go, right? So that's I think a lot of states are facing that same issue. We did do a lot of in advance of the October hearing. I did a dive into like what are other states working on that may be effective. There is no silver bullet, right, for kids, and I'm sure you all know that, right? This level of need. But I think there are things we could be doing differently that states are having some success with around in that continuum, right? Specialized therapeutic foster care with a wraparound model that's specific to girls who have sexual abuse and trafficking histories, different specialized therapeutic group homes, right? For kids who both may engage in unsafe behaviors, but have intensive clinical support needs, right? A different type of wraparound to keep kids with their families. And so I think we should be looking at how to use our existing funds to do some of those models. Yeah.
Thank you. And I don't think I thanked you for being here, but thank you for those answers. Appreciate it.
Thank you very much. Representative Lanu.
Thank you, Madam Chair. Good afternoon, Child Advocate Egan. Nice to see you. And let me just say, as a fellow child of the 80s, I appreciate your comment on one question in 12 parts. I certainly feel like I'm back to school when I'm up here many times. So I do appreciate that. And I know you did not submit written testimony. You kind of did this on the fly, which I do appreciate, regarding the ICPC bill, as we call it, 5263. I know the commissioner designate touched on in her testimony. You mentioned, as far as the ICPC, there's also maybe another compact that's that should be examined as well. Without putting you, again, I apologize if I'm putting you on the spot, but as you know, the hearings is a good time to air all this out and make sure we get the language right. So I guess my question is, what do you know the name of the other compact that perhaps we could include in this to take a look?
It's the Uniform Child Custody, the UCCJJEA, which is the Enforcement Act. The Uniform, I can email that to you. I'm not sure when I interacted with it more regularly, if I could have said exactly what it was.
That'd be great. If,
Yeah,
what was the acronym again?
UCC, Uniform Compact. God, Lord have mercy. UCCJEA, UCCJJEA.
Okay. Thank you. I guess my second question, and again, I apologize if I'm putting you on the spot, but would you be willing to be a part of the task force, to be a part of this group that can take a look at these two compacts and to take a look at some of the at least hear some of the testimonials from the families and report back to us as a committee?
Absolutely. We're here to help.
I very much appreciate that. Thank you, Child Advocate Egan. It's always a pleasure. I have nothing further.
Thank you.
Thank you very much, sir. Representative Wieelander.
I win. No, good morning. Thank you for being here. And I wanted to touch upon the survey that you mentioned, and wondering if you could expand just a little bit on what you meant about public facing, the information that would be gathered by that, specifically because I'm thrilled that we're having this discussion and we are expanding the awareness of abuse and trafficking that is happening in our state and around the country, especially when we are not looking at children who are in DCF care. So that is something that it's very prevalent. So this idea of bringing more information to it, I think is a really great first step.
Yes, it's my understanding that the survey referenced in the statute is a reference to a survey of school districts around their implementation of more recent mandates around having a sexual abuse prevention and response curriculum and framework. And that prior to COVID, it was sort of all set to go and did it. Right. So it's not a survey of kids, but a survey of districts around their engagement and response to those mandates. And, my belief is, I mean, that's a QA tool for the state, right? And it's a self-learning tool for districts and for districts to learn from each other, right? And some districts may need more technical assistance than others. So if there's a provision for those surveys to then be done on a periodic basis and to be part of the district's website or published on the SDE website, wherever they live is fine. But that's, I think, what folks were envisioning.
Thank you for that. And I appreciate you expanding on who would be providing the information and how it would be shared. So we can make sure that we're gathering information that is important, but also keeping our kids' privacy and their safety in mind. So thank you very much, Madam Chair. That's all I have. And thank you for being here.
You're very welcome. Representative Comey.
Thank you very much, Madam Chair. Thank you for coming in. You always give us so much to think about, Sarah. I want to talk about the grief bill and the grief report. I assume you've read it. You didn't write it?
I did not. From the Commission on Children and Seniors.
Okay, that doesn't count as my question. So there was some, I'm trying to understand it a little bit more fully in relation to actually the question that Rep. Dauphiné asked regarding the top 5 client diagnosis from 28 to 22, being that substance related and addictive disorders looks like 65, 70% higher than some of the other diagnoses. I guess my question is really the intersection of the mental health care that when you lose, because I'm looking at the time period with the COVID, right? And so it's pretty much even with some of the numbers over that 5-year period from 2018 to 2022. So I'm just wondering if there are other ways to look at that data and if you have any insight into that.
That's a good question. I don't. Just because I'm not wasn't the author of the report and gather that data. But if there's something that we can be helpful in, I'm gonna just bring your computer. Sorry. I was like, I need a computer so I can reference that study. But if there's something in particular you think would be helpful for you to consider, I'm happy to work with the commission and get you that information.
Okay, thank you so much.
Thank you very much, Representative. Are there, oh, we have one online. That would be Senator Anwar.
Thank you, Madam Chair. Thank you, Ms. Egan, for your testimony and very thoughtful comments. My first question is, this is just a broad observation, and then maybe you can suggest that if I'm thinking more or less accurately, what we see is we create these very good programs. This is on 5260. And we create these programs, they work, and then suddenly we do not put enough resources and effort to have their sustainability, and their functioning decreases. We hear complaints, and after that, we start to have a study just to prove that we need to put more resources into it. We see this kind of a pattern in different parts of our governance. Can you reflect on this thought?
I agree. And look, it's, yes, it's children's behavioral health is dramatically underfunded. And I'm sure many others reviewed and listened to the report from DSS looking at the Medicaid reimbursement rates in that cross-state comparison. And I think, Senator, it was your question in the informational hearing that really struck me when you said, boy, it's worse than we thought it was. And can't deliver care to children like that, right? And children are in these emergencies for one reason only, because their needs are unmet. And because we have not built and sustained a system that is available to meet their needs when they need it. And trying to fix that even at age 13, 14, 15 is really hard. And we have to, the answer is investing in the levels of care and support for children and families that they require. And that's what we have to fixing. There's no way to just, we can fix some of the STAR home through a better model, different procurement. Could do some of that. But it won't solve the overarching problem of how do we meet these children's needs when they leave without investing in the community-based services that they and their caregivers also need.
Thank you. My second question is on Bill 216, which is about having an app for children for help and support. And what I've learned from opioid-related issues and addiction and other component is that you have to meet the individuals where they are. And if this was a way to try and meet the children where they are and perhaps have a mechanism of using insight to identify high-risk individuals and have interventions. In a theoretical sense, it makes a little bit of sense, but have you and your office looked at this option enough to be able to comment?
I think the short answer is no, only because I don't know enough about what's being proposed. However, I think all options should be on the table and in consideration of, what are the, so I certainly support any initiative that is looking at ways to engage children and meet their needs, or to identify kids who are in need of greater intervention. I think I'd need to know a little bit more about what was being proposed to speak more competently about it. But we're open to any new good idea, I guess, should be looked at.
Thank you so much for all you do and your entire team does your amazing work for our state and our children. And thank you, Madam Chair.
Thanks, Senator.
Thank you very much, Senator. Senator Mar.
Hi, I just wanted to add my thanks for the always comprehensive, thoughtful, and deep dive into the way you look at legislation and the way it affects children and the potential to make things better for children across our state. So wanted to thank you for that.
Thank you, Senator.
And I believe that's all we have for you today. Thank you so very much for being here. Next up, we have Representative McCarty, followed by Representative Candelora, and then Jamie Rodriguez.
Thank you so much. Good morning, I think, to the Children's Committee, Chairman Senator Maher, Chairman Lenahan, ranking members, Seminara and Dauphiné, and to the distinguished members of the Children's Committee. Let me first say it's a pleasure to be here with all of you this morning. And if I may, before I begin, raise Bill 5260, which you've been discussing today. Unfortunately, our minority leader, Vincent Candelora, will not be present today. He was called away from the Capitol, but he wanted the Children's Committee to know that he submitted testimony and that this bill is a high priority for him and the caucus. So I just wanted to relay that information. So thank you. I'm here to speak to you today about Senate Bill 218. And first, before I say anything, I want to thank the Children's Committee from last year. You really started this by creating the working group, and that was led by the Commission on Women, Children, Seniors, Equity and Opportunity, as well as the Social Emotional Collaborative, and then a nonprofit organization in the region. And the title is An Act Establishing a Task Force to Study the Creation and Administration of a Statewide Program for the Delivery of Bereavement and Grief Counseling Services to the children and families. And I think if you had the opportunity, and I apologize a little for the mix-up. Originally, I think the report went to the Education Committee, but I hope you've all received that report now. I know I heard Representative Comey asking questions about it, but you know, when you began the working group, I had thought originally it was going to be a lot narrower in scope, and they really did, in my opinion, a fabulous job researching already throughout the state the real need for more bereavement and grief counseling services. They identified gaps in the state, particularly in the Northeast and the Northwest, where we don't have any centers at all, any bereavement centers at all. And then they went even further and looked at some of the marginalized and disenfranchised communities that could use the services. So I was very pleased to see the scope of the working group, what they did. Their number one recommendation is to continue the work. It's not finished yet, and to create a task force. So that's why I'm here today, to ask you to please support that, create the task force, and let's continue the work. I think there's a lot more that we can do to analyze what we can do. And I know so many of you on the Children's Committee also serve on the Education Committee. We had a 10-hour hearing yesterday about all of the disengaged youth and disconnected youth to our schools, the chronic absenteeism. And I'm wondering how much of that can possibly be related to bereavement and grief. I know Representative Lenahan, you and I have discussed that, and originally, because my own family had the experience with my granddaughter who lost her father due to a tragedy, and it created such anxiety, depression, trauma, and she's a wonderful granddaughter. I love her dearly, and she's doing well now, but it takes a lot, and we could not find the services necessary right away. It took a lot of investigation. So that's what prompted me to come to you to say, can we do more? Let's look at it. I think that if we allow this task force to go forward, we'll even gain more information and we'll be better equipped to help and move it not only to the children, but to the families. Because I think Representative Dauphiné, you asked the question, and by the way, it's so difficult to go after the child advocate, Sarah Egan. She is just tremendous, and I appreciate so much all of her work and her willingness to help on this issue as well. But you asked the question if there's any correlation with the opiate epidemic and what's happening, and I can answer that yes. And if you look at some of the statistics that the work did, that the commission did, they point out that there's so much more. If somebody has experienced grief and bereavement and they haven't received any services at all, there's studies showing that there's a much greater risk for suicidal ideation, much greater risk for self-harm. So this is a rippling effect that goes on in the family. So I think it's worthy of more. And I'm particularly interested to look at the correlation that death and bereavement may have on our students in our schools. So that's the one recommendation. I'm coming here today to ask you if you would please include in that the Department of Education or a designee. I didn't see anyone there. And then I know a student wrote in about it, that perhaps somebody with lived experience, whether it's an older student that is able or a young adult or even a family member that has experienced the death or the loss of someone, I would appreciate if you'd take a look at that. But I'm here today to really thank the Children's Committee for taking this seriously and for creating first the working group and asking you today if you would please create the task force now so we can continue the good work and work together. Thank you.
Thank you so very much, Representative, and thank you for pretty much everything that we've ever done together. I will say that you have been an excellent partner in this, and there is a great deal of crossover between what we do in the Committee on Children and what is done in the Education Committee, where you serve as the House ranking member. And so thank you for bringing all of that forward and bringing this to our committee. And the testimony by the child advocate, in addition to you saying many of the same things, I think that really gives this some serious weight, and we will certainly be talking about exactly what we need to put in there. But one of the recommendations that did come from the child advocate was about that funding source. And I'm wondering, in your work in the working group, were there discussions already, even though it wasn't the original charge, about other avenues of funding in order to really kick off a statewide program?
Right. And let me just, before I answer the question, I was not part of the working group, but I do know because I did speak consistently with TJ Nuccio and the commission on the work that was being performed, and also talked about the nonprofit organization Cove and mentioned that to them, and they worked hand in hand with the Cove. So yes, there were nonprofit organizations that they looked at, and they are able to accept donations. And so there's a piece to this that they want to continue to look at, to what could some of the centers that are already in existence, the nonprofits, how they can interact with the program and what services they could possibly offer. So there is work that needs to continue, and that's why the task force is still important, because I do think there might be some untapped resources out there that could help. But I think they're also asking to look at the creation of a statewide organization that may be housed within one of the agencies that currently exist. So I think it's going to be multifaceted, and that's another reason why I think the task force, the work is just in its early stages, and they would like to have that opportunity to continue to investigate. But I think there will be other areas to look for resources.
That's wonderful. And I thank you again for the work you're doing on this. You're such an advocate, and I know that you are a grandparent with lived experience. So thank you. Just on a personal note, I will tell you that I have a dear family that or rather a dear friend that I love like family, who unfortunately will likely pass away in the next day or so. The work that you have done has really made me cognizant of the need for help for their children. So I just personally want to thank you. And I always get choked up when we talk about these things, but you all have come to expect that from me now. But I cannot thank you enough for the work that you've done in this area. And I know that everything you continue to do will certainly affect those kids, especially the ones that I love.
Thank you
So-
very much for those comments, and I feel the same way as you do. So thank you.
Thank you. Senator Mar.
This is so important. Grief presents in all different ways, and we're still at the early stages of understanding that and how long it takes, especially for children as they go through different phases in their life and experience grief again in a new phase. So thank you very much for your advocacy. I'm 100% behind you on this work.
Thank you very much, Senator.
Representative Wieelander.
Thank you, Madam Chair. And thank you for being here, Representative. I just wanted to publicly echo just not only my support for this, but the support for the calling of including family as well, not just the children, but offering services to extend to family members, because I think we all know that death and dying and grief are not easy topics for a lot of people. And when we can make services available so people have more tools in their toolbox to assist their children when they come home, I think is the best way to actually provide services that can be truly helpful. And I think about personally the fact that when I was a teenager, I lost, my family lost a beloved uncle to death by suicide. And my brothers who are all younger, they processed it very differently than I did. And I'm wondering if we had had resources of support, what would some of their later years have looked like in a little bit different way? And how could we have all supported each other in a way that was trying to find a pathway through the grief? So thank you for your advocacy on this. And I look forward to seeing where this goes next. Thank you.
Thank you very much, Representative Wieelander, for sharing that story. And you make a point that if you do not receive the services, and you know, you have to meet the person where they are, and we all know that. But if they don't receive the services and they carry that and they can't express it or have the support, that can be carried throughout life. And so I appreciate you making that comment. Thank you.
Thank you. And I just wanted to, I should say, it affected all of us. And my, brothers and I process things very differently. That's just how people are. But I know that it took years and years for all of us to come to a place about that. So I just wanted to, I didn't want to throw my brothers under the bus in case they ever watch CTN.
Thank you.
Don't expect a birthday card this year, Representative. Representative Pizzuto.
Thank you, Madam Chair. To my esteemed colleague, Kathleen, I truly appreciate your testimony and sharing your own personal experience. When I was running the UConn Waterbury campus, we had faculty members that would teach death, dying, and bereavement. I wonder if there's a connection somehow through the state higher ed system, then we may be able to utilize those resources since they're already on board. I'm not sure if the 4 state universities or community colleges have that, but maybe just something to reach out to and think about as you go through the committee and the task force.
Yeah, that would be to the children. Thank you for that recommendation. And there is room on the, I believe, on the task force. And as they go through this, perhaps there'll be other sources that we can look at for help. So we're not always reinventing the wheel. So thank you for that.
Very good. Thank you. Thank you, Madam Chair.
You're very welcome. Madam, if you could just check with our clerk to ensure that Representative Candelora's testimony, that we did receive it. And if we in fact did not, if you could reach out to him and let him know for me.
I will.
Great.
Thank you.
Thank you. Thank you for
Thank
being
you.
here.
Thank you very much to all of you.
Next, we have Jamie Rodriguez, followed by Kathleen Garrity, and then Iveles Correa.
Hello, good morning, Chairwoman Mayor Linehan and ranking members Daphne and Seminara and the members of the Committee on Children. My name is Jamie Rodriguez. I'm a licensed marriage and family therapist. I am also the advocacy chair for the Connecticut Association of Marriage and Family Therapy. I'm here today on behalf of CTMFT to testify in support of SB 217. CTMFT represents over 2,000 MFTs employed in various therapies. Are specifically trained through a systemic lens and have extensive training in treating individuals, couples, families, and systems. As a result of our systemic training and treatment model, MFTs are often the mental health professionals involved in the treatment of children and the families that support them. Connecticut continues to see an increase in mental health needs across children and adolescents. Childhood diagnosis of that are on an upwards trend include anxiety, depression, post-traumatic stress disorder, adjustment disorders, substance use disorders, self-injurious behaviors, suicidal ideation and attempts, and an increase in diagnosis of emotional disturbances. We have also seen an escalation of mental health symptoms of prior diagnosed mental health disorders requiring higher levels of care, such as in-home treatment, intensive outpatient programs, partial hospitalizations, inpatient and residential care. Diagnosis and symptoms of mental health disorders are also being seen in younger children. Sometimes preschool age children from the ages 0 to 5 are experiencing increased stress, anxiety, low social emotional school skills, adverse childhood experiences, and interruption of family and community support. This mental health crisis of our youngest residents is of urgent concern and thus brings many mental health professionals in varying roles and settings into the treatment of the child patients. The development and implementation of a universal patient intake form for children patients would assist with the multitude of providers involved in that care to obtain consistent and speedy information. It would streamline and improve overall quality of care for all current and future providers. A universal intake form would also benefit the parents and guardians of these child patients by simplifying the very stressful initial intake process in often crisis scenarios in which bring mental health providers into the care of these children. The extensive background information such as medical history, medication lists, treatment history, trauma history, and much more can be such a daunting task outside of the critical time that already brings these parents and guardians to seek mental health care for their minor children. A parent or guardian that has access to a universal intake form will undoubtedly experience reduced stress and confusion. CTMFT must acknowledge the importance of confidentiality and required consent in sharing this private information of minors. Despite the intended consistency and ease of a universal intake form, CTMFT asked the committee to not ignore the risk of potential exposure of sensitive information of minor children. Overall, CTMFT supports SB 217 and applauds the Committee of Children in seeking strategies to ease the burden and improve the quality care of mental health for children, and this bill and so many others being discussed today. Thank you so much for your time, and please do not hesitate to ask any questions or anything that you need of me.
Thank you very much for your testimony. We appreciate your time and attention. Senator Marr.
Thank you, Jamie. It's good to see you. You mentioned that there are over 2,000 LMFTs, and I was curious if you could speak to one of the pieces that people are raising is the issue that everyone has a different way of interacting and they have different questions. Could you speak to how that is for you and LMFTs in terms of looking at a universal form and how that would be developed, and what are some of the components, perhaps beyond what you've already listed, that you would want to see?
Yes, great question. And I think this again leads to that we do have so many different providers that come from different training models, that come from different types of treatment models. And so they ask differing questions. Although the majority do ask kind of what I had listed, the background information and things like that. MFTs, for example, we are going to look at the background of the family history, not only, psychiatric and medical history of that family, but also things like maladaptive strategies, separations, loss, all those kinds of other pieces that impact a family system. And in a difficult way, but also in a positive way. There may be a connection to a community or to, a basketball organization in the town that is a tremendous support to the family that might be overlooked by another provider because of the way we think systemically. Again, not this or that, better or worse, but just different ways of looking at things. And I think if we have this universal intake form in which multiple providers can have input onto, then the systemic lens that an MFT looks at through could benefit another type of provider that may not have even thought of asking those questions that could really help the family and the child.
Thank you so much. Really appreciate
Thank
your
you.
testimony.
Absolutely. Thank you.
Are there any questions from other members? Representative Comey.
Hello, thank you so much for your testimony. I just have a very quick question, Jamie. Did you send in written yet? Can you please?
I
If you
have submitted written testimony as well. Thank you.
Okay, I'm sorry. I cannot make my way through this. Okay, thank you so much.
No problem. Thank you.
I'm sorry, Representative, did you ask to hold for a moment? Oh, I apologize. I misheard. Okay, are there any other questions from members of the committee? With none in person and none on, that was a no, Representative? Did you? Oh, did you just raise your hand, Representative? No? You do have a question? Go ahead, Representative Mr. Francesco.
Thank you. Thank you for your testimony. One of my concerns with this universal form is a privacy issue. Maybe a family or a parent does not want to share that information into a database. My concerns are always it goes into a database and there's a breach. Do you have any concerns about that?
I did. And as I listed in my verbal testimony, I think we're always thinking about our patients' confidentiality, especially of the most sensitive and private information in their lives. But especially when we're talking about minors, right? And a form that may follow them for life, right? So if we have a child that enters care at a very early age and now they're into adulthood, that's a lot of information to be following. I know, again, all providers kind of have different laws around consent. MFT specifically, we need to have very specific things listed about what we can give consent about. It can't just be a blanket consent, and to whom and how it can be shared and things of the such. So I do think that should be looked at and really taken into consideration. Not in a way to not allow this to happen, of course, because I think the benefits far outweigh that. But that really taken into consideration and thought through thoroughly before implementing.
Thank you for that. Yeah, my biggest concern is it's no cookie cutter, right, in the medical field. Not every person is the same and not every profession practice is the same. I worry about the breach issue. I worry about the privacy of a family that maybe they don't want that information shared. And you also made a good point, and I really didn't realize that this information goes into a database and it follows somebody for life. And there could be ramifications from that going down the road as well as that person possibly gets older. As you know, we all go through adolescence. They go through certain things in their life, and sometimes they're temporary and sometimes they're not. So those are just my initial concerns on it. But thank you for your testimony. I appreciate it.
Thank you for the question.
Thank you very much. Senator Mar, did you want to go? Okay. So I just want to ask one quick question.
Sure.
Because I think that there seems to be kind of some thoughts about how exactly this should be spelled out. And so the question I have is really from a provider perspective, that if this was not a database or is just a form that would help give information and not be required for that. The way I see it playing out in these discussions is I have this very clear picture in my head of a parent who needs to go from provider to provider to provider with an extensive amount of history, especially history regarding medications, so that this would be an intake form that a parent could choose to use. But if I, as a parent, chose to use it and I was able to provide for you, even as a mental health professional that does not write prescriptions, but if I were to come to you with my child and I had a list of the last 10 years of medications, how long they've been on it, what their side effects were, and what their moods were based on these medications, and I was able to keep this with me at all times, every time I went to go see a new provider, would you, as a provider, find that would be very helpful in helping you treat, even though you don't prescribe?
Fabulous question. And I think absolutely, as you mentioned, there are many master's level clinicians that do not prescribe medications. However, we cannot be in the mental health field without having education and acknowledge how medication impacts the work that we do. So I completely agree with that. And I would absolutely, as a still a practicing provider, find that very, very helpful. I also like that you are kind of, that's what I was thinking of, almost having like a paper document. Now, I wasn't sure, it wasn't clear, at least to me, by the way the bill was written, if it was going to be a database or kind of a more form. But in my mind, as a provider and also a parent of children that have sought mental health treatment, kind of more this universal intake form that obviously providers have access to if the parent does not, but that the parent really could be the holder of that and then share that information with the different providers. That might be another way to kind of bridge that gap and manage that confidentiality piece, so that the parent and the guardian, and then possibly even the patient, once they reach into more adolescence and get closer to adulthood, could have some say on the information that is shared and is not shared. And they have custody, I guess, of that information. So I appreciate that you asked both that question and kind of thinking through how this could take shape in many different forms.
Thank you very much. And as I'm sitting here listening to you, I'm kind of going over in my head kind of who this would apply to. And I recognize that we're the Committee on Children, but boy, wouldn't this be great for the elderly population as well, to actually have something to be able to say, these are all the medications that we're on. And if there is an emergency situation and they go to the emergency room, it would be the same as kids as it would be adults to say, I've already got this. And so here's all of this information that is really necessary to help treat. So thank you very much for your input. I appreciate it because I always look at it in terms of a parent of a child with mental health challenges. And so to hear from those who treat those challenges and find places where we meet in the middle is wonderful. So thank you very much. Are there any questions from members of the committee? Seeing none, thank you very much. We appreciate your time and input.
Thank you.
Next, we have, please, Kathleen Garrity, followed by Iveles Carrera, and then Wendy Klein.
Thank you, Senator Mayer, Representative Lyman, and committee members. I appreciate the opportunity and the invitation to join you today and testify on Bill 5261, specifically on the issue of whether energy drinks should be sold to children under the age of 16. I'm Kathleen Garrity, the Executive Director of the Connecticut State Dental Association, representing dentists and our dental teams. We advocate for public policy that allows us to provide the essential oral health care to Connecticut that our citizens deserve. Having this hearing on this leap day is a perfect way for us to end February, which is National Children's Dental Health Month. We have been working locally to provide education to our youngest population on the importance of maintaining good oral health. The subject matter of this bill obviously overlaps this ongoing efforts. I know that the sugar issues have been well documented in terms of overall health, so I'm not going to be redundant on that. I'm going to focus my comments specifically to oral health issues, because oral health care is essential health care. When you visit your dentist, the dental team is not just looking at your mouth for decay of your teeth, gum disease, or structural changes, which are all major health concerns, but they're also looking for indicators of other emerging chronic diseases, such as diabetes, hypertension, and oral cancer. We educate every patient we see and emphasize moderation of sugar, as it often negatively impacts your oral health. Earlier this month, I was visiting a practice, and I learned of a situation where a mother brought in her 3 young children for a visit. The youngest of the children, who was not even 2, was seen sipping on a sports drink. And the mother confirmed that it was a habit and, in fact, his preferred drink. When she was counseled to offer her child water often enough to offset the sugary drinks, the mother was concerned, thinking that the sports drink would help her child grow strong like an athlete. This misguided mindset continues through the teen years, when the energy drinks become a popular choice at a time when these children are under immense social pressures. I raise this example simply to note that choosing healthy lifestyles and educating our constituents on making healthy choices is a lifelong process, and it's an investment so that future generations will naturally choose good options and balance their diets to positively impact not just their oral health, but their overall health. In 2011, CSDA adopted a policy that supports statewide policy and initiatives that aim to decrease the consumption of sodas and sugary beverages, which we typically call SSBs. In a 2015 article of JADO, which is the Journal for the American Dental Association, it was reported that Americans consume sugars, particularly in the form of SSBs, at an alarming rate, and they are the leading cause of dental cavities, as well as obesity and type 2 diabetes. SSBs include the energy drinks we're discussing today, but obviously include other drinks as well. In the US, SSB consumption has reached epidemic proportions, with an average American now consuming more than 50 gallons per year. Besides having no nutritional value, SSBs displace healthier beverage options. They're cheap and readily available, and they are one of the most widely advertised products, particularly to children and adolescents. In closing, a bi-directional relationship exists between your diet and nutrition and your oral health. Your oral health affects the tissues in your mouth, and a healthy mouth affects how you consume your nutrition. I'm happy to provide additional information to help you reach a decision on this important matter, and will welcome any questions that you might have. Thank you.
Thank you very much for being here. It's no secret that this bill is of great importance to me. This is now the third year that we've brought this up. And there were some concerns in how it was written in the past based on lack of information in the marketplace. And I think now we're at a point where we can overcome those challenges. But there are some other things in that time period between when we last brought this bill up that now things are, we're seeing it get worse. And so I'm very happy to see you here representing dentists. So what we tried to do was kind of decide what constitutes an energy drink by the ingredients. And we looked at proprietary blends and stimulants. But one thing that we failed to really talk about the last couple of years was actually that in addition to the sugar content. And so everything together kind of works together. And you talked about the effects that these are having on the teeth. And Doctor, I just want to give a very brief synopsis of an experiment that I did in my daughter's kindergarten class, where we actually had collected the teeth, her baby teeth that fell out, and we put them in test tubes, and we let them sit for a period of 4 weeks in these test tubes to see exactly what happens to their teeth in these drinks. And we did milk, we did water, we did juice, and we did soda. The soda actually was such that it created, when we took the tooth out of the test tube on the 4th week, it had disintegrated so much that we pressed on it and it just broke into a bajillion pieces. So having you here, I wanted to ask you, and I'm sorry, I don't know if you actually still see patients or if you are simply on advocacy, but I'm wondering if you have any anecdotal evidence or empirical evidence that these sugary drinks, have you seen anything in the patients that would tell you that it is indeed having an effect on the teeth where they are causing teeth to rot or disintegrate, or even just greatly stain?
I just want to take a moment to say, once again, you are a rock star, Mom, and we have more examples of it. So thank you for sharing that. And I also want to clarify, I am not a doctor, and I appreciate you understanding that I play the role of being privileged to represent the oral health care providers. And so they have helped.
Apologies.
No, please. I would consider it an honor if I was, but I'm not. So I'm here today just to represent them, obviously. And on this particular issue, I will say that there's a lot of documentation I'm happy to provide to you and the rest of the committee about the effects of sugars in general, sugary drinks, et cetera. It's harder to find it specifically in the narrow niche that you have found in terms of energy drinks, because that is, as you've mentioned, in looking at the formalization of those, it's an ever-evolving whack-a-mole, if you will, that the drinks keep evolving and changing. You know, even what we looked at 10 years ago versus what's on the market now is vastly different, including not just the sugar, but obviously caffeine intake and things like that. So it would be hard to find something specific on energy, but I can give you some background information on SSBs in general for sure. And the last thing I would say in terms of anecdotes, I would be happy to provide in our written testimony some practitioners who are actively seeing patients talking about this particular issue because they do have frontline information. But I will share with you a pediatric dentist who just went into the OR a couple of weeks ago with a patient who was under the age of 15 and who had 22 cavities that had to be dealt with. And that's why it was an OR visit, because you can't do that level of treatment on a child in 1 or 2 visits. So, that is a marathon. That is a very decayed mouth. There's a lot of other issues going on and underlying conditions. But, the fact that many of our population, whether they be children or those with some disabilities, it's difficult to maintain oral health care. And if they are seeing these as options in terms of what to drink over something that's more natural and has less sugar in it, obviously we want to steer them towards those, as well as anybody in our population. Make good choices and follow up with brushing your teeth, drinking water, all that good stuff, and have a good oral health care home. So thank you for highlighting this issue today.
Great. Thank you very much. And then one final question from me, which you may not have this answer, but if you don't, I would appreciate it if you can seek that out on our behalf. Do you have any information on the cost to parents since the influx of these high sugar energy and hydration drinks because of the effects that they have on the teeth?
That's a pretty loaded question, so I'll try to keep it to my short response here, but I will provide you additional in my written statement. I would say that, one of the things that we have been most concerned with in terms of our advocacy work here in Connecticut is the rising cost of all healthcare and certainly oral healthcare. If you had privy to listen to the Medicaid rate study that DSS is currently doing, they're looking at 9 different categories, including dental. And ours is the one that was mentioned most often as people cannot afford their dental care and they need it. And we all know what happens when you put off essential medical care. It gets worse. You end up in the ER. And I know you all are looking at bills that are dealing with the influx of patients going into emergency departments as well. So the big picture here, to answer your question as quickly as possible, is that the cost is enormous. The resources devoted to it are certainly rising. And as reimbursement rates from private pay insurance and Medicaid are declining, it's increasingly difficult to get the care that these patients need.
Thank you very, very much for your testimony today. Senator Marr.
Thank you very much for your testimony. I want to say, as the daughter of a dental hygienist, she was actually my mom was very clever to be a dental hygienist, and she then went on to have 6 children. So it certainly made it a lot easier and less expensive to get our teeth cleaned. But I know for a fact how important dental care is because my mother put it often in front of us, and we were not allowed to drink sodas. It was a different time. But what I do want to say about this is that I appreciate the work that you all do. And as in everything, hearkening back to what Sarah Egan said about prevention, this is again the same sort of thing. We don't want children in emergency rooms having to have 15 cavities dealt with in an emergency room because they're not getting preventative care, or they are drinking things that are going to cause their teeth to be destroyed. So thank you so much for your advocacy. And I just want to put in a huge plug for flossing. Thank you.
Thank you.
You're the best. Senator Anwar.
Thank you so much, Madam Chair. Ms. Garrity, I agree with your testimony. And I also agreed with another part of the testimony when you said that our co-chair is a rock star. So I agree with that too. And I just wanted to mention, again, there is the oral health is actually physical health because the rest of the body is going to be impacted. I feel it's worthy to talk about that the destruction started right at the moment that the individual takes this drink. And then as the drink goes down further, all the other organs are going to be impacted subsequently, including increased heart rate. I feel compelled to speak about the fact that I have seen patients die because the marketing is that this is supposed to help in their exercise capacity and make them more physically fit. And it causes actually dehydration rather than hydration. And that's probably the part that is causing further dehydration and cardiovascular collapse and death in individuals. Could you speak a little bit about some of the other components, if you could, beyond the dental component?
Certainly. Thank you, Dr. Anwar. I think that what you are starting to look at and what you're leading me towards is the idea that, we call it the oral cavity is the gateway to the rest of your health. So the fact of the matter is that if you don't have good oral health and if you are in pain, if you have teeth that are not functioning correctly, it affects not just your nutrition, you're not going to eat the right food, you can't chew, etc., but it also affects, as you said, your hydration levels, which obviously are critical to all the systems of the body. You also are looking at sleep issues, that if you have pain in your mouth, it's going to lead to a deterioration. If you have excessive weight that you're carrying because of sugar intake, you're going to be more likely to have sleep apnea and things of those nature, which we also treat with our medical teams. And, as we're looking at the big picture, the reality is that pretty much everything you do starts through your oral cavity, the way you eat, the way you breathe, the way you hydrate. And so if you are in pain and you're not getting care, you're not going to maintain healthy habits. And that's really what this is all about. This specific bill looks at just energy drinks, and I understand the mentality behind it, but we have to look at the bigger picture. When a dentist looks at in your mouth, they're looking, as I said before, they can see the onset of what could be diabetes, hypertension, other issues, and they can get you referred into a system where you can have that evaluated. A lot of times, if you have an oral health care home, you're seeing your dentist twice a year. You may not see your primary physician once a year. So we are the gateway to make sure that people are upkeeping their health. And if they're not, to lead them towards an integration with medical. Same thing for mental health. I talk a lot about mental health. I've been listening to the hearing. I know this is a crowd that understands that. But when we look in there and we can see somebody who has an addiction issue, we can start that conversation. The dentists are trained to do that, the hygienists as well. And I just think that we have to really focus in on how do we use that moment when they're sitting in our chair to address their overall health and make good recommendations by somebody that they trust.
Thank you so much. Thank you, Madam Chair.
Thank you very much, sir. Any other questions? Representative Dauphiné.
Thank you, Madam Chair, and thank you for your testimony today. And I 100% agree with everything that you said and the impact on our children's teeth. I know my dad suffered from gum disease, and it was so important for him, for us to have good teeth. We all had braces. Those were the days when he made us carry a little mini toothbrush to school and brush after our lunch. And I can remember we were one of the few kids that did that, but he was very, very, very committed to us all having good, healthy teeth. And as a result, we all do. And to that end, I mean, we talked about a few things. So the energy drinks we know have sugar and stimulants such as caffeine in them, but there's many other products on the market that do this. Soda, we talked about soda, excess juice, tea, coffee with caffeine. And I see many, many kids going in and out of Dunkin' Donuts and Starbucks with these big frappy coffee drinks full of sugar and caffeine. So to that end, I understand your concern with children having too much sugar. So we know too much sugar is, you mentioned, contributor to diabetes and other things, including there's many, many studies out there to the effects of sugar on our brains and our cognitive abilities. So we know that, and we know that caffeine also affects us. But so this bill is to prohibit the sale of energy drinks. Would you also be on board with prohibiting all those other things, coffee, tea, soda, and the other things we spoke about for children 16 and under?
I think that it would be outside of my ability, my cognizance to make a comment like that. Speaking on behalf of the association, the dentists I represent, I am going to stay in a narrow lane here. I'm not going to speak on my personal advocacy on either side of that coin, including the fact that I have children that fall under the age of 16. But what I would say is that, we are really pushing for the fact that we have to have a communal shift in terms of how we approach anything that we put into our body. We have to have a balance. We have to always have things in moderation. Whether you're talking about alcohol, cannabis, sugar, etc. There's a lot of things here. And so we have to really just try to build in a system where people understand how to make healthy choices, and maybe not limitation on never having X, Y, or Z, but understanding the impact of when you are going to have that, a piece of chocolate, a coffee, etc., how it's going to impact your body. And it's not something that you're going to do all the time. So I'm going to defer to others on whether or not there should be a ban on sales of this, that, or the other thing, and if there's an age limit, etc. I don't think that that's something that I am ready to state. The association, I'm happy to bring it back to our members to get some feedback on if we could take a policy on that. But at this point in time, I'm going to defer on that question. Thank you.
Thank you. I appreciate that. I just have in front of me many graphs that compare energy drinks to coffee drinks and tea and many others. And in many of the cases, the other drinks have far more stimulant than the energy drinks do. So I guess, while I agree with everything you said and my good chair and co-chair with regard to the effects on our teeth and our health and so forth, I find it a real stretch to make a law prohibiting the sale of energy drinks to persons under 16. Thank you for your testimony.
Thank you.
Representative Master Francesco.
Thank you, Madam Chair. Thank you for coming out today. Appreciate your testimony. I have a question. I'm a little confused that you are representing the association. Is it is it your testimony that you're representing the association that is in agreement with the bill that is before us that bans the sale of energy drinks to anyone under 16?
I would not make that statement. What I would say is that we have not taken a position on this. To be honest with you, I was approached by the committee yesterday to take on this bill, so we haven't had a chance to really come up with a cohesive message. I would try to get that by my written statement, but I would just reiterate that our policy has always been, at least in the last few decades, to support any statewide policy initiatives that would decrease the consumption of SSBs. And I think that that would be where we start the conversation to move forward. I just hesitate to go be in front of anybody. I don't want to get in front of my board. I respect their opinions. We do have a meeting next week, so I'm happy to get something more formal and send it on to the committee. I think the overarching message here, though, is that education to consumers to understand the impact of consuming any of these SSBs has been something that we have been very much vocal about and in the front of public eye on.
Thank you. And the reason I asked is because your testimony was specific to that bill.
Correct.
That bill is specific to ban the sale of energy drinks to people under 16. So you might want to go back to your colleagues.
I will. And I think part of it is
let them know, because they are putting you on the spot. And I am assuming that that is the case. I appreciate it. Just a quick follow-up, though, and just a comment. Obviously, I'm not in favor of banning any type of energy drinks. I think it's a free market, and I think education is a key. Like we do in school, we educate our kids on what's good and what's not good. There's so many products out there that are bad for your health, for your teeth. I mean, just look at the food products that you have. Bioengineered food ingredients, GMOs, natural food flavorings that are bad and toxic for you. I mean, do we go down this path to start banning everything? Is that what we want the government to do? Are energy drinks good for you? I don't know. I don't drink energy drinks, but some people would say, yeah, they got a lot of caffeine and a lot of sugar, but probably no more than anything else. And yes, of course, we want our kids to have healthy teeth, but some of that is genetic, and you can't control what goes on in the home. You can go out and buy a 5, 10, 20-pound bag of sugar. You don't know how much sugar they're putting on their cereal, any of their foods, or the salt intake. So I just find this bill to be just such an overreach. Is that this is if this is the position we want to start going down, banning things, because the government feels that they know what's best for you, how you should raise your family, and what your children should be eating. It goes beyond the pale for me. It's certainly a family issue. But again, we can legalize marijuana. It just makes no sense to me. I appreciate your testimony today, and I didn't mean to put you on the spot, but I was a little confused about where you stood on the issue because the bill was specific. Thank you very much, ma'am. I appreciate it.
Thank you.
Thank you very much. And just for the purposes of clarification, I would just like everyone to understand that we are not banning the consumption of these beverages by children under the age of 16. It's simply a bill to empower parents to make those decisions for their children by requiring a parent to actually be the one to purchase it, so the parents do know best as to what's going in their children. So I just wanted to make sure that that was a clarification. Representative Kit.
Yes, thank you. Sorry, it took me a second there to find the mute button. Think I'd know by now. I just would ask if Ms. Garrity sees a difference between, I agree with the issue that, of limiting sugary drinks and making healthier choices when it comes to what we are consuming. As far as either banning or restricting the sale of energy drinks. And this is probably outside your scope of expertise, but I see a difference between, say, a sale of something like a coffee or Coca-Cola that just has caffeine, not saying that caffeine can't be negative in high doses, but we're talking about other substances as well, including cetacabine, I think. I'm just right now looking at the ingredients on 5-hour energy shots. It's something that's a constituent of brain tissue, and it plays a role in neurotransmission. We have tyrosine, which impacts nerve transmission and nerve impulses in the brain. And I'm concerned about these energy drinks that do have these substances that, when consumed in large doses by young children, can have negative impacts on their bodies, much more so than just caffeine would have, or sugar. So I would just be interested to hear your thoughts on that, and whether we need to take a closer look at energy drinks that have these substances beyond sugar and caffeine. Because, for example, I'm thinking of the lemonade drinks that they sell at Panera, the energy drinks there. Yes, they have a lot of sugar, but they also have, I think they have taurine and some other non-caffeine stimulants in them. And people are drinking them and buying them because they think they're just lemonade. So that's where my concern is.
Well, thank you for that question. To respond to it, I would say simply that, the dentists are physicians. They are physicians of the mouth, and they are well trained in how all of those things would impact your body. This testimony today is specifically focusing on sugar, because the other things that we're talking about, the concerns about what is in these drinks and how they're labeled and who they're being marketed to, a lot of that falls under consumer protection. A lot of it comes from FDA rulings, et cetera. So I think your question is very broad in the sense that it could take a long time to address that. I think today, given the time constraints, I've only focused on the sugar aspect of it, because that's something that's easily translatable. Everybody understands it, hopefully, after the education we've had. But what I'd like to highlight is the fact that even after educating on sugar for as many years as we have been, and I mean, we as global society, that, we should avoid it when possible, that sort of thing, we still are having these issues. And I think the example that I gave of the mom giving her young child a sports drink kind of highlights it, for the fact that the messaging that we're doing regarding moderation of things like sugar is not getting out all the time. And we have to double down on that if we want to impact the overall health of our people in Connecticut and elsewhere. So I think your question is wonderful, and I think it's too much to answer in this particular venue.
Thank you. And I do want to say, I do completely agree with you about the issue of better educating people about limiting children's consumption of sugar. My grandmother, back in the 70s, was a dental hygienist in a free clinic outside of Atlanta. And, her patients would routinely come in with baby bottles filled with Coca-Cola. So we have been fighting this battle for a very, very long time. I just think for this particular issue, we also need to look at these other additives. Thank you.
You're welcome. Thank you.
I'm here. Sorry about that. Thank you very much. Are there any further questions? Seeing none, thank you so much for being here. Your input was tremendously helpful in the way we will continue to draft the bill. So thank you so much.
Thank you. I look forward to further discussions, and please let me know if there's anything you need for the record that we didn't already cover today.
Absolutely will. Thanks.
Thank you.
Now we are going to have, please, Iveles Correa, followed by Wendy Klein, and then Beth Hamilton.
On. There we go. All right. Good afternoon. I'd like to thank the committee for allowing me to speak today. I am a former DCF youth that was cycled through the criminal justice, mental health, and residential systems of Connecticut while my father was incarcerated for cannabis. I am extremely representative of the efficiency of the programs offered then and now. I am still healing from the trauma I faced as a throwaway child in the Connecticut DCF system. And when I speak to youth today, my heart aches because very little has changed. I'd like to start by echoing support for Sarah Egan's idea to use the opiate funds for children who have lost a parent in the state of Connecticut. A few years ago, about 10% of all Connecticut children lost a relative to opiates. While I don't have today's numbers, we all know that has increased. I would also like to speak in support of HB 5262 because children pretend it's not happening to them when they have to put on a brave face to their peers and temporary adults they're not sure about trusting. They don't know how long they're going to be in these facilities, who they can trust, and there's no reason to open up to them. So whatever we can do to get that reporting going, we should do. I also support SB 217, an act implementing universal patient intake forms as written, full stop. We need accountability, and such a form will force DCF and its contractors to remain accountable while keeping permanent information in history from falling through the cracks. Such an example that we can all relate to is the Epic healthcare system, in which most of the people in this room already have their information logged into. So your medical provider does use that, and that is a current database. However, you guys might not be aware that any DCF youth who has been in the system since maybe about 2000, we don't have privacy. And let me read this the way I wrote. A universal intake form would not stop individual providers from using their own intake forms for specialized care, and supplemental information would be nice, but having a universal intake form would provide a baseline for information. And for lawmakers who are not aware, I already do not have privacy, and my life story is already in a database, including criminal and medical history, which DCF contends is their property, despite assurances of privacy over 20 years ago. I am happy to sign a release for lawmakers for limited review if you guys want to know what that looks like. So we already don't have privacy, and I'm already subject to a data breach, as well as everyone else who's been in the system. Finally, I support HB 5260, an act concerning an evaluation of short-term assessment and respite group homes for children, but ask that the committee go even further with this law. Every program should be required to report. And we need to know the efficiency of the programs being offered as well, and how many children graduate from these programs. We need follow-up surveys for these children as adults. During my time in DCF custody, as a teenager in residentials, I saw money go into programs, and there was always a threat of long lane if we didn't comply. A significant portion of the girls I lived with have graduated to inmate numbers if they're not dead. So rest in peace, Cassie. We have a limited window with children to work with before it's too late for interventions. Very basic reports and audits would
Your
allow—
3 minutes are up. Can you please summarize?
I'll summarize. Would allow decision makers and lawmakers to replicate the programs that work and discontinue spending on the programs that do not work. I also want to remind the committee that child deaths have increased since DCF is no longer under federal oversight, and we should be auditing as much as possible. Nonprofits contracting child caretakers right now are also not paid enough, and that's what's contributing to high employee turnover and understaffing. Thank you very much for the committee for allowing me to speak today. I'm happy to answer any questions.
Thank you so very much for being here. Did you submit your testimony in writing as well?
I can. I usually just wing it, but this time I felt like it was more appropriate to type it up.
To be honest with you, I found it so helpful that I'd like to have it to refer to often, not just for this session, but as we move forward next year for the long session, because you bring up some really good points that might be too much to dive into during the short session. So your input would be extremely, extremely valuable. And I just have one comment, actually. And I didn't even formulate my thoughts around this because I didn't think I was going to say anything. But you mentioned the threat of Long Lane.
Yes. So I was in Long Lane and we had to go to medical appointments at CJTS. It was terrifying to go to those dental appointments.
It struck a chord with me. I have made no secret of the fact that I grew up labeled as a troubled youth. And I was threatened with Long Lane all the time. So when you said that, it like sent a shock through my body. So I don't know exactly what that's going to mean in the context of what we'll be doing. But I think I just want you to know that I heard you likely in a way that is different than how other committee members or audience members may have heard you. And I just want to acknowledge that. Thank you. You're welcome. Anyone else? Let me try my co-chair first. For you? No, okay. Representative Master Francesco.
Thank you, Madam Chair. Thank you so much for coming in. A quick question, a comment and a question, but first I want to comment you sound like you're doing so much better today and you've had trouble in your life and you seem very well grounded today. So I want to congratulate you for that. It's not easy to do, but people do it and it seems like you're doing it really well. So I'm really happy to hear that. I did have one question for you on the form. You mentioned in there that you're already in the database. You really don't have any privacy. Are you okay with that?
No, I'm not. So if you speak to other lawyers who might deal with this type of situation, I've spoken to other lawyers and DCF still contends it is their property. So if for any reason I've got to go through DCF, which they're not just if they take your kids. DCF deals with a multitude of things. You know, they subcontract to Beacon Health Options for their voluntary services, which is crazy. So they're able to see when I reach out to them or if we need to do something with them. If I would have to go through respite services for my son. This is something they have access to. I'm not okay with this at all. But the sealing of my information is a little bit different than a universal form, which I think would help. There's so many different programs that you get cycled through. And just having that baseline so you don't need to explain your life story over and over and over. And all the psychologists and everything else, you don't even remember faces when you're a kid at that point. It's a violation. It was a violation then. I didn't know it, but it still continues to be a violation now where I don't have privacy. You can pull me up in DCF database. So.
Thank you for that answer. Yeah. And I understand what your stance is on the form. Appreciate the feedback on that. Of course, my concern is, the state of Connecticut has way too much information and at some point it needs to let go, because once you put all that information and you share it among providers, it's out there. It's kind of like the internet, right? Once it's out there on the internet, it never really goes away. So I'm a big advocate of protecting people's privacy. And your will to whether you want to release that information, that certainly should be up to you. So I get really concerned when the government has too much information on a person, whether it's a healthcare issue, whatever the issue is. It's certainly a concern to me. But thank you so much for your testimony today and for coming out. I appreciate it.
Thank you.
Thank you very much, Representative. Senator Marr.
Thank you for your testimony. I wanted to circle back around to the question that was just that you answered when you were saying that you felt that there was a lot of positive about a universal intake form.
Yes.
Can you speak a little bit more about that as someone who went through having to answer questions time and time again, and how you thought that that might be helpful?
When you're in these situations, you're clearly going through trauma. This is stuff that you're going to be recovering from for the rest of your life. Having to relive situations over and over, having to explain your medical history, all the medicines you took. I can't remember all the medicines I took. I don't remember everything. And when you're busy attempting to figure out who to trust, what's going on, your parents aren't there. Just simple baseline information and having that simple baseline to follow you through the system it's not as triggering when they have it, as opposed to you having to repeat yourself over and over and over, bringing your parents in, having to sit there and, have your dad answer questions while he's in prison and, you're both in shackles together in a room. It's a little difficult.
I really appreciate you doing that. I can see how it triggers just answering the question. So thank you for your time.
Seeing no other questions from members of the committee, thank you for being here. Thank you for sharing your story, and thank you for submitting something in writing. You have some time. It's not immediate, but it will help us now and in the future. So thank you very, very much for being here.
Okay, thank you.
Next, we have Wendy Klein, who is remote, followed by Beth Hamilton and Dr. Daniels. Ms. Klein.
Good morning or afternoon, everybody. My name is Wendy. I'm not sure, I apologize. I do not know the bill, the number of the bill that I'm speaking on. It's the energy drink bill. And as I sit here and I listen to a few of you say that you're against banning anything and it's the parents' job to teach their children, etc. I sit here and think, yeah, I did that same thing. Told my kids, no soda, except for a special occasion here or there. It's bad for you. Energy drinks were out. I could see they were targeting to minors because of all the hats and the shirts and the sports, that sort of thing. So the only thing I basically knew was there was a lot of caffeine in those. I know a lot of caffeine is not good, so my children were not allowed to have those either. My daughter, who would have turned 27 years old yesterday, went to the mall with her friends. She was almost 15 years old. She went and did what her friends were doing, and she bought an energy drink from a candy store in the mall. She came home about 2 hours later, said she wasn't feeling good, slumped over and gasped, and that was it. She went into cardiac arrest at home. I did CPR on my own child. This was the 17th of December, 2011. She was on life support until she was taken off on Christmas Eve when she donated her organs. We just celebrated the 12th anniversary. Since then, since I sat by her hospital bed, I did all the research I could. Through the Freedom of Information Act, I got all the adverse event reports on these drinks. There were deaths upon deaths upon deaths. I didn't know about them, did you? So I called somebody from the New York Times, sent all the information over. They published the story and it went international. Since then, I have met numerous parents who have lost their children the exact same way. During the first few years, I got a congressional hearing on Capitol Hill. They made it illegal to market to kids. They had to change the ingredient labels and put everything, the whole caffeine content. I noticed that somebody mentioned that there's just a lot of caffeine in them. There's some other stimulants. The thing is, there's caffeine in these drinks that are synthetic, powder form. They absorb through your body quicker than naturally occurring caffeine, like in coffee or tea. In addition to that, a lot of them have guarana, which has up to 2% or even more percent of caffeine. than a coffee bean. They add that in there. Panax ginseng is something that if you look on WebMD, it says it could have a very bad reaction if mixed with caffeine. Taurine and sorbitol, a bunch of other stimulants all together. Not good for anybody, but minors should not be able to go into a candy store and buy a drink that's going to kill them, like my daughter did.
Does that conclude your testimony before we start to ask questions?
I mean, that's all I have to say so far.
Ms. Klein, hi, it's Liz Linehan.
Liz.
For those of you, I mean, Mrs. Klein has been coming to our committee for a few years now, so we've developed a relationship. I want to thank you so much for being here again today. And I'm so sorry for the loss of your child, and I too celebrate her angel birthday with you. I think that you brought up a really great point, and our testimony for the past couple of years has focused on it, but no one has focused on that yet today. So I'm glad you brought it up. But these energy drinks, a lot of people focus on the caffeine, but it's not just the caffeine. In fact, my co-chair was given a small card today as she walked into the committee room that was given to her from Red Bull that says, know your caffeine. And it shows that Red Bull energy drink only has 80 milligrams of caffeine per 8.4 fluid ounces. But nowhere in this marketing piece does it say that it had also, whether it has the guarana or the other proprietary blends of ingredients, that they're not necessarily required to fully say what they are, but there are multiple stimulants. And I only have 2 questions, so I have to use them carefully. But I think that this one might be worth it, even though I don't know the answer. Are you aware of which energy drink your daughter consumed?
Yes, it was Monster Energy.
It was Monster Energy.
I think per can it has 240 milligrams of caffeine.
240 milligrams in addition to additional stimulants, correct?
Correct. And I think the pediatricians are now recommending only 100 milligrams of caffeine per day for minors. So there you have it.
You were a very involved mom, and obviously the death of your child is not placed at your feet, and I want to be very clear. But you are a very involved mom, and you started your testimony by saying that you had these conversations with your daughter and that she wasn't allowed to drink these drinks, but she went to the mall with her friends where others were having them. And like a teenager does, she defied her mother and
Shocking,
ingested,
right? Shocking, 14 years old.
Right? But she ingested a drink that was not good for her. So I guess I just have one final question. Do you believe if the business that sold her that energy drink required ID, and if your daughter was under the age of 16, do you believe that your daughter would be alive today?
Oh, she'd definitely be alive today if they were banned. She was only 14 years old. She wouldn't have been able to get it.
Thank you. I so much appreciate you taking the time. You have devoted so much time and energy to this cause, and I appreciate you so very much. Are there any questions from members of the committee here in person? No questions? Any questions from members online? Representative Kitt.
I just wanted to offer some information and answer a question that you had, Representative Linehan. Red Bull does contain taurine. I'm looking right now at their their ingredient list on their website. So I just want to say to Mrs. Klein, I'm so sorry for the loss of your daughter and the grief that your family is still feeling. And thank you for coming in front of this committee to help educate us all about the dangers of these energy drinks that hide their caffeine content by using these synthetic forms of caffeine. Thank you.
You're welcome. Thank you.
Thank you, Representative. Senator Anwar.
Thank you so much, Madam Chair. Ms. Klein, I'm so sorry for your loss, and I want to thank you for having the courage to share your pain to make sure that we do the right thing. I think the parents are doing the best job that they can, and nobody's taking the rights away from any of the parents. The issue is that some of these companies who are committed to making profit at any cost, they are acting like parents, and between the parents, we want the real parents to be the parents rather than people dedicated to making money through addictive chemicals from our children. We have seen the tobacco industry, and we have seen how that is done, and this is another way this is happening. So I think your testimony helped solidify my understanding that we as policymakers have a responsibility to protect the families, not necessarily the children, but the families, so that the mothers, fathers, children are all protected, because when a child is hurt, the rest of the family is hurt very significantly. So I just wanted to thank you for that.
Thank you.
Thank you very much, Senator. I always think it's fantastic to have an MD on this committee. So thank you very much. Are there any further questions from members of the committee? Hearing none, Mrs. Klein, thank you so very much for being here today. Again, I appreciate you, and I'm so sorry for the loss of your daughter.
Thank you. Everybody do the right thing. Thank you.
Thank you, Madam. I'm trying. Next, we have, please, Beth Hamilton, followed by Dr. Daniels, and then John Catalan.
Good afternoon, Representative Linehan, Senator Marr, Senator Seminara, and Representative Dolphinet, and distinguished members of the Children's Committee. Thank you for the opportunity to share our support of HB 5262. My name is Beth Hamilton, and I am the Executive Director of the Connecticut Alliance to End Sexual Violence. The Alliance is the state's coalition of community-based sexual assault crisis services centers who provide 365, 24/7 crisis interventions, including hotline services, counseling, support groups, accompaniments in hospital, police, and court settings, and legal and advocacy services while navigating complex systems-based processes. As the state's anti-sexual violence coalition, we were outspoken leaders in the support of the passage of Public Act 14-196, which established the requirements for all K-12 schools to develop and implement sexual abuse awareness and prevention programs that includes training for teachers and students. Since that time, our coalition and our membership have worked with many schools who are both not aware of the mandates and who do not have such programs or training in place. As a parent, as a survivor of childhood sexual abuse, and as someone who has dedicated my entire adult life to working in violence prevention, I believe that it is imperative that we address child sexual abuse. Sexual violence is a preventable public health epidemic. In the US, approximately 1 in 4 girls and 1 in 13 boys will experience sexual violence before blowing out the candles on their 18th birthday, and nearly half of all females who experience rape first did so prior to the age of 18. The collection of public health data is critical to inform not only future policy efforts, but to identify where and how the limited resources school communities have can be spent to effectively address and prevent sexual abuse. In 2019, the Alliance and the Department of Public Health convened a group of stakeholders, including the State Department of Education, Department of Children and Families, and the Connecticut Association of Schools to develop a survey tool to assess the successes and challenges of Connecticut's K-12 schools when implementing sexual violence awareness and prevention policies and programs. Due to the pandemic, the survey was not disseminated. Following a devastating increase in child sexual abuse and exploitation during the pandemic, both locally and nationally, the Alliance and our partners are now poised to send the survey out through the State Department of Education in the coming weeks. The goal of the survey is to learn more about the types of information currently being shared in schools and what kinds of support schools need to implement these policies and programs. This information will be collected and used to create a toolkit to help districts develop meaningful policies and practices to increase school safety, to respond to those increases in disclosures, and to gauge the effectiveness of existing policies in preventing and responding to sexual violence in K-12 schools. We support the intention of HB 5262 to require a similar survey to be completed by schools to increase awareness of the existing legislative mandates and to continue to measure the efficacy of existing training and programs, again, both for students and for teachers.
We also would like to see an addition in the requirement for a survey to be completed every 2 to 3 years going forward, as well as for the information gathered to be returned to the legislature and to be made publicly available. Excuse me. As always, the Alliance applauds the good work of this committee and is here to be a resource to you in any way that we can. Thank you for your time.
Thank you very much. We're going to take your testimony because and kind of rework this legislation simply because there's an additional LCO that's out there that has not been filed as this. So we will be looking to contact you directly for more feedback about that particular. But I find myself having a question because I know that this survey already exists. And that was done through the law in 2014. That came out of that. And so it's been in existence, but not quite shared. But recently, and when I say recently, I mean within the last 24 hours, I've been made aware of an issue that has come to light, and that is that there has been some questions regarding the keeping the names and identity of mandated reporters who have reported sexual abuse and assault within a school setting, that was, whether purposely or inadvertently, released by the police to the public in the last couple of days. And I, as one of the co-chairs of this committee, I think that that is a very serious problem. So when your questions go there, for the clarity of everybody, that this survey is for administrators, it is not for students. Would you be open to adding a question onto that in order to, even if it's not a question, I'm spitballing, some sort of information within that survey that would alert the rights of mandated reporters to keep their information private, so that we don't have an issue where those who have their eyes on kids are afraid to report on behalf of those kids. So when we send you back, if you could think about how to best do that, is that something you could think of and you'd be open to?
Absolutely. I mean, I think I would like to bring it back to the larger group that stakeholders that I shared that helped to develop the survey tool that we did, which is actually not tied to that 24 legislation. The onus for us doing the survey was a legislation, but it's not mandated that survey be done. I certainly think that there are ways to add, things like that and different caveats for folks. I would absolutely agree that we don't want a chilling effect where folks are afraid to report what they see for fear of retaliation or being named publicly in that way. Our way of collecting the survey would be through using the Yale Consultation Center. They would house all of the survey data. It would go back to them. They would not release information by school. In fact, they would release it by district. And really what we want to look at are just patterns and trends. We want to see, one of the things is we see younger kids don't get any awareness and training, right? And there's lots of different ways that you should be talking to children about that. As a child who has started being sexually abused at a very young age, right? I am somebody who is, living proof of why you need to have those conversations, even starting in daycare ages. So certainly, our eye is to both keeping confidentiality of the schools and of that information. We want them to be able to readily share with us and not feel like they're going to be scrutinized. And that is not the intention of the survey. So I think that that's a really important piece. Would be very happy to bring that question back to the larger group. I don't personally see any challenges with that, but would want to consult with our stakeholders.
Absolutely. Thank you. And like I said, this just came to light actually, it was less than 24 hours, 12 hours ago. So, so thank you for that, because I don't even know exactly what it's going to look like, but you are the trusted expert. So I come to you for those things. Thank you. And that's really the only question I have for you. Is there anyone else in person? Anyone online? Your testimony was so spot on. No one needed to ask questions.
Thank you. Have a great afternoon.
Thank you very much. Next, we have Dr. Daniels, followed by John Catalin, and then Alyssa Trachtenberg. Dr. Daniels.
Hey, good afternoon, Representative Linehan. I appreciate the opportunity to share some comments, maybe some insight. I'm a dentist by training, but also an orthodontist here in Cheshire, Connecticut. And when I began private practice coming out of residency, and to this day remains one of the most important things we have to worry about with the children I treat, are their oral hygiene, how well they take care of their teeth and their gums. And we've known that dental erosion has been a relevant public health problem in recent years, as that is heavily related to the increase in the consumption of acidic beverages. And these energy drinks, as previously discussed, contain very high levels of acid and sugar, in addition to, of course, caffeine and some of the B vitamins previously referenced. Their corrosive effects on tooth enamel is extremely well documented now in the literature. A point of biology for everyone. We all know that we have this normal flora, bacteria that colonize in our mouths, and they feed off the sugars that they're provided, and in turn produce a very corrosive material, lactic acid, which in turn irreversibly harms tooth enamel. But this corrosive bacterial effect is exacerbated with energy drinks by the high amount of acid already in the drink. When I first began private practice, one of the big issues, and we still emphasize with the kids and the parents, both during consultations and when they proceed through a couple years on average of orthodontic treatment, is the importance of oral hygiene. And we show them the before and after, and what can go wrong, what it should look like, and what can go wrong, so there's no surprises for the family if there's a lack of compliance. And when I began private practice, the images that we would share were solely restricted to before and after effects of poor oral hygiene. But now there's some other behaviors, lifestyle choices that I have to share with kids and their parents, who are investing a lot of time, resources, and funds to provide for their children. Eating disorders like anorexia, bulimic. That's unfortunately something that we see. The mouths, as you're gathering, are windows into what's often happening in the body. You were just talking about being reporters, and there's a lot of things that we can catch if vigilant, that's happening to the kids. In addition to anorexia, bulimia, I now have before and after pictures of tobacco use by minors. Most commonly, especially in teenage boys, is the development of when using smokeless tobacco, erosion of gum tissues by the canines. And as a reporter, we have responsibilities to have these conversations. But now we have before and after pictures that we present to families, cautioning, advising, pleading about the dangers of energy drinks. And think about that.
Dr. Daniels, we did have a timer that let us know that it's time for the committee to ask questions. And
by all means, happy to.
I just, in full transparency, I want the committee to know that I saw you in the grocery store and you came to me and you were very, very concerned about this issue. So I want to thank you so much for being able to speak so intelligently on this. You brought up something that I want to give you an opportunity to kind of dive deeper and clarify. You mentioned bulimia, and bulimia has, you can tell, we had we had a dentist on earlier, or she represented dentists, that you can tell when someone has been purging based on the erosion of their teeth. That's correct, right?
Absolutely. The outermost part, the hardest portion of the tooth is the outer enamel. And typically in these situations, not just girls but also boys, young men, is you'll see a corrosive deterioration of the outermost layer of the tooth, the enamel, down to the more yellow brownish underlying portion, dentin, sometime approximating the nerve or pulp chamber of a tooth, and it's evident on the
And
back
that's
sides of the teeth.
and your testimony is that the effects that you're seeing of these drinks, not just the sugar content, but also the acid that is in these drinks, they are mirroring the dental effects that you've seen from those who are anorexic and bulimic. Is that the testimony to understand?
Yes, ma'am. It can be a challenge when the braces come off. You straighten the teeth, you fix the bite, but what's the first thing that both the child and the parents might notice are these hypocalcifications about the teeth, white spot lesions, areas where the opportunistic bacteria got to do what it did because it was basically given a buffet as the teeth were bathed in high sugar, acidic medium. The ADA is very clear on what, as providers regarding, they have position on energy drink. We tell the kids, well, like any other behavior, abstinence, a behavior that might be deleterious, abstinence is the way to go. But in the event abstinence is not on the table, copious irrigation with water. In fact, the ADA recommends us not to instruct them to brush right away because the brushing itself spreads the high acidity between the teeth, under the gum line. You got to wait at least 5 minutes before you can even brush. It's safe to brush because of the power of these drinks.
And that's terrifying to me as a parent, I'm just going to say. And my last question is actually, it doesn't apply to what is written in the bill right now, but it is something that we need to talk about whether or not we're going to move forward with the legislation and have to change some of the language. Just so you know, Doctor, we have had some trouble kind of defining energy drinks in legislation to make it easy for businesses to comply. And I think that was ultimately why the bill was never passed in the past couple of years, because energy drinks were so new to the market and it was almost impossible to put into statute how to define an energy drink. But you have made mention and others have made mention and the fact that you like to educate parents and you talk to them about the effects of this. So do you believe it would be beneficial for the Department of Public Health, in consultation with dental professionals as well as pediatricians, maybe the American Heart Association, to put together some information from trusted sources and provide that to all pediatric medical professionals, including dentists and orthodontists, so that it's easier for you to just hand them this information at their yearly visit in order to alert the parents to these concerns?
Think it wholeheartedly, because I think it would lend a greater credibility, paternalism currently absent, the unity of bringing these disciplines together. This is a wonderful opportunity for it. And many of us, and we have kids, and if you have teenage kids, you know that in the past year, the drink known as Prime has exploded among both boys and girls, and particularly of the age of our discussion of concern. You're right, not all energy drinks are the same. Take this Prime, for instance. Well, it's loaded with coconut water. It doesn't have the caffeine. It does not have the acidity of your quote unquote energy drink. It does require both further clarification, especially among our very conscientious parents who are trying to do right by their children.
Right, because everything is just changing so quickly. And, well, this isn't a question, it's really just a statement. You did bring up Prime, which is, anyone who has kids, my kids' age, knows that that is developed by the YouTuber Logan Paul. And he has billions of followers, and he used it to launch a drink that is actually causing our kids' teeth to rot out. And so I think that as we continue to move forward with this, I really want to take under advisement what you have said and what others have said here, is that really education is going to be an important aspect of however we decide to move this bill along. So Dr. Daniels, I can't thank you enough for your expert testimony today. I sincerely appreciate you being here. And are there any questions from other members of the committee here in person? Seeing none, are there any questions online? Okay, Dr. Daniels, you were great. Thank you very much. We appreciate you so much, sir.
My pleasure.
Have a great day. Next, we have, please, John Catalin, followed by Alyssa Trachtenberg and Catherine Davies.
Good afternoon, members of the Committee on Children. Thank you for the opportunity to testify on Senate Bill 215, an act concerning youth camps. My name is John Catalin. I represent the Connecticut Alliance of YMCAs. I wish to emphasize the vital role that summer camps play in fostering mental health, imparting essential life skills, and removing the negative influence of technology for all youth in Connecticut. It is imperative to recognize that not all states maintain stringent regulations for youth camps. Shockingly, some states do not mandate licensure for camps, nor do they require background checks for camp staff. In Connecticut, we uphold some of the most stringent regulations in the nation, including comprehensive background checks, thorough camp inspections, qualifications for program directors, maintenance of health records, mandated reporting protocols, and robust emergency plans, excuse me. I would also want to offer the following insights into the specific provisions in the proposed legislation. Section 1, we support the provision of setting a priority with the inspection of new and single-week camps within 48 hours of operation. We would suggest the bill list the nationally accredited organizations that will be recognized in order so there's no confusion. Section 2, we really question the rationale behind appointing a representative from the Connecticut Parks and Recreation Association to the Youth Camp Safety Advisory Council, given their exemption from state licensing requirements. Section 3, Connecticut's YMCAs do not believe it's necessary for licensed camps to submit an annual report to the Office of Early Childhood. We believe unlicensed camps should be obligated to report an accident or incident at the end of the summer to the OEC, and furthermore, unlicensed camps should be required to disclose their status on their websites. Thank you.
Thank you for your testimony. And Representative Boyd.
Thank you, Madam Chair. And John, thank you for testifying and being a presence on a lot of these issues and some of your work in the past. Just a couple of things. Just the last section you talked about unlicensed camps, right? We all know we had this full debate last year, right, with requiring municipal loose term camps to this. Do you think, and I think you answered this, that if you're an unlicensed camp and you walk and talk like a camp, right, that there should be some type of reporting requirement back to the state, right? So be it the same incident report form. So like any licensed camp, there's a very specific category of injuries or things that need to be reported to the state and what you did about it. So, you know, be it a end of the season report, which I agree. And I think most people agree that licensed camps, that's redundant for, but for unlicensed camps, that's a different area.
Right.
And that at a minimum, they should be reporting incidents and injuries and God forbid fatalities, right?
Right.
That happen under the auspices of that program. Can you opine upon that?
I agree. I mean, I do think it's a way, you know, one of the things that's interesting is I was trying to gather information on all some of these issues with camps. And it doesn't really exist because there's, you know, in this country, we don't even know how many camps there are because there's so many unlicensed camps. So at least, you know, at least being able to collect data to show what type of incidents could possibly be happening at unlicensed camps, I think would be a positive.
Do you think that would be, because you deal with, your organization deals with camps in all different settings from resident camps. Do you feel it'd be a regulatory burden if they were held to the reporting of incidents part of the statute as opposed to a larger piece, just that narrow piece?
Right. I mean, I know what I think, but I'm not the person having to complete that report. So I would rather defer to their viewpoint on it. But I mean, I think it's a good idea if they can accommodate that.
Yep. And then last question, dealing with the Youth Camp Safety Council, and there's a lot of testimony, and others are going to be testifying about kind of its existence as a kitchen cabinet at these days. Would it be helpful to you and your members if there were actually minutes of those meetings posted and an actual roster of who's on it so that there's a greater sense of transparency? Would that be helpful? Or do you think being a kitchen cabinet as it is now, an advisory piece, is it a diverse, you know, it's
Right.
what the commissioner makes of it now?
Right. I mean, my opinion on it is I would like to see it codified into statute just because I know it's been in existence for 40 something years, but all it takes is a new person in the administrative branch to say we don't need that anymore. And I do think that advisory council plays an important role in advising the Office of Early Child Care what is a positive, what is doable, things like that. So, you know, I think, you know, I'm fortunate enough that I do usually get an email on what happened during those meetings, but I think, you know, posting it and keeping some type of minutes would not be a bad idea. And obviously, you know, I'm not an attorney, but I would imagine from a legal perspective, it probably would be a good idea as well.
All right. Thank you for your work and advocacy. Thank you, Madam Chair.
Thank you. Any other questions? Seeing none, thank you so much.
Thank
for
you,
your
Senator.
testimony. Next, we will have Matthew Jackson. I know he was added. Yep. All set.
Good afternoon, Senator and members of the committee. Thank you for having me today. I want to talk today on how important it is for the ICPC process to continue to get better in its processes and the knowledge of it being an option to just the public in general. My boys were taken, and not only were we not given any paperwork or rights as parents with child services or any court documentation in Tennessee, but we did not even get asked if we had family that could care for the boys, which we have family up here in Connecticut, which is how we got the ICPC done up here after some time. And like I said, we also didn't know anything about the ICPC until we had a family friend that told us about it, and to have our lawyer ask the judge for an expedited ICPC because I was on military transfer orders to Connecticut. Also, even with the process was started in time to meet check in my command, I had to leave Tennessee on 24 January, and my boys were taken on 12 January of 2023. I had to come up here, report for duty in Connecticut, and then it was another 7 weeks before they were brought to Connecticut, and I didn't see them for that entire 7 weeks. And at first, they also went to Tennessee foster care because we were never asked if we had family that could care for them. So they went to a complete stranger's home at 5 weeks of age, and Also in that home, they had COVID going around, so it was putting them at risk of that as well. Let's see, sorry. This should have and could have been avoided, and I feel the time period could have been easily shortened for the two states to talk and to get things aligned. There needs to be a more streamlined and efficient process for the ICPC, especially with infants being involved, not only just for children, but infants. It's a more vital time that they should be with family if they can't be with the parents. This affected me in ways to where it made me depressed, anxious, and lack of focus I needed to have at work and also in my daily life. Not having my boys was a lot to begin with, but then not even seeing them when I should be able to made that worse. And dealing with the whole situation with losing my boys in the ICPC was worse than when I was on board the USS Connecticut that hit an underwater mountain and almost took all of our lives. Losing my boys was more of a traumatic experience. This is why I feel that the state of Connecticut or any other state that's monitoring for ICPC should be able to do their own investigation to see if the other state did the right thing, or even as a second opinion to back that up. Because then we are even wasting time and resources providing monitoring and work. They may not be needed when it could have been streamlined or taken care of faster. So I feel that we're wasting time of resources and personnel to focus on something that can be taken care of in a faster manner, if it was stated. This is just unjust due to the fact that.
Can you please summarize your testimony?
Yes. This is unjust due to the hands of Connecticut being tied and not being able to help when my family needed help, even when I'm a state resident now. I've been living here for years now. I have a house, and my wife is also from Connecticut, raised in Griswold and only transferred due to me being in the military. Other than that, I just ask that not only to better this process for military families, but all families, because anybody can come with this tragic event at any point. And I thank you for your time and listening to what I have to say.
Thank you so much for your testimony. Representative Lanu.
Thank you, Madam Chair. Mr. Jackson, good afternoon to you. Thank you for your testimony. I appreciate your advocacy on this issue and your story. And let me thank you for your service to this country as a Navy man, as somebody who enlisted. I know I have to obey by the 2-question rules. So I just want to make sure I just want to sign it. I'm going to just summarize here in my own mind for context before I ask you the question. So essentially, you were assigned to Washington State up in the Tacoma, Washington area for the Navy. Your wife, of course, went with you. Griswold native, Connecticut native, born and raised in Griswold for the most part, spent most of her life here. When you got reassigned to Groton, Connecticut, in the end of 2022, you went from Tacoma, Washington to Groton. In transit, you stopped in Tennessee, which you never resided in. Your parents had retired there, and you, like millions of other people, for Christmas decided stop there to enjoy the Christmas holiday with them. When you were there, you were concerned about one of your sons possibly having an injury. You took him to the local hospital, and they were concerned with the injuries. To make a long story short, to summarize, the Tennessee Family Services decided they were going to take custody of your children, and eventually they got placed with your in-laws, your Mrs. Jackson's parents in Griswold, by a state that you never resided in. Did I summarize all this correctly?
Yes, sir.
Now, when you were in Washington State, did you have a pediatrician look at your children, evaluate your children after they were born, your twin boys?
Yes, after the boys were born, it was the next day that they had their newborn appointment, and then they had a follow-up appointment the week after that. And then at the 2-week mark, they had a circumcision that was outside the hospital because they don't do them in the hospital there. That was in the pediatrician's office. So they were seen a total of 3 times and told to have good health by examinations before we left Washington the day after their circumcision.
Okay, did the military, you remember you're an active duty military personnel. Did the military do an investigation into you and your wife as far as being considered good parents, if you should have custody of your children? Did they do any kind of underlying investigation into any of this?
Yes. When I got up here, I checked into my command and immediately went to the Fleet and Family Support Center, where they had a family advocacy program, and they opened a investigation with NCIS and the child abuse team up in Bethesda to be able to look at it, and where we provided all the information, including the scans from Tennessee. And it was two or 3 days ago now where they came to that conclusion that we were unsubstantiated and it did not meet criteria for abuse or neglect.
So essentially they're saying the children belong with you. That's what the U.S. military say.
Yes.
Okay, thank you.
Thank you, Representative Lanu. Other questions, Representative Wieland? Oh, I'm so sorry. I didn't see you. I apologize.
So, thank you so much for your testimony, and of course, thank you for your service. I'm just trying to get a little clarity exactly what happened here. So you were serving in the military, you're moving back to to Connecticut. On your way, you visit your in-laws. And what exactly transpired that would result in taking away your children? Or is it children or child?
Children, ma'am.
Children.
So yes, ma'am, I can answer that. So upon transfer, when I was in Tennessee at my parents' house, I was changing one of my sons and putting his left arm into the onesie. I heard a pop in his arm. So from there, we took him to the hospital because we figured something was wrong and he needed help. We took him to the hospital and they did complete body scans of my son. And then they said that it was just a humerus fracture and that there was nothing else, that everything else looked good. And then they also asked me if they could look at my other son, his twin, and I said, yes, you can look at him. So I checked him in. They did body scans of him, didn't find anything. They kept us overnight in separate rooms and had to be monitored. And then the next day they discharged us, saying that everything was good, but they did have child services investigate because it was just a suspicious injury, which I understand because child safety. But then from there, it was a couple hours later into the middle of the night after we discharged where they called and they said that we had to bring our other twin that didn't have any injuries back to the hospital because now they think that he has injuries. So at that point, my wife and my mother took him to the hospital for him to get rechecked, where then they determined that they think that he had healing rib fractures and at 5 weeks old. And they said that it was not possible that they were from birth. And then at that point, the CPS took him from the hospital from my wife. And then the other son that was at the house with my father and I, another team came and got him, and then we didn't get to, I didn't get to say goodbye to my other son, and then she didn't get to say goodbye to the one at home.
Okay, that's quite the story and sounds absolutely unimaginable, quite frankly, that we get from a point where you bring your child in for an examination to the point where your 2 children now are, and you are a suspect, I'm assuming, of abuse, right?
Yes.
Neglect and abuse, was that the charge?
Yes, ma'am, even though we have 4 medical experts that say otherwise.
And for the 4 medical, I know I'm going over my 2 questions. Sorry.
Okay. I recognize that the four, or my question would be, were the four medical experts now here in the state of Connecticut made that observation, or was that back in Tennessee?
No, ma'am. They're actually from different states of there's some out of Illinois. We've one here and then other states because we got through them through the Child Resource Center out of Illinois that fight for families that were wrongfully accused.
I understand now. Okay. Thank you very much. Maybe there may be some other questions to further try to clarify what's going on here. Thank you. Thank you so much for your testimony.
Yes, ma'am. Thank you.
Thank you. Representative Welander.
Thank you, Madam Chair. Thank you to Representative Lanou for providing that synopsis. I know this is like, it's a challenging situation. Trying to use my questions wisely. Would you be able, I'm trying to understand the situation and what you and the proponents are hoping to get from it. Would it be correct to say that you're hoping that we can look at this compact to ensure that if you are a resident of a different state, that you have an agency or advocates on your side that can be more representative for you in a situation like this? So you or any other family wouldn't be, I don't want to say use the word at the whim of another state's agency, but be not without resources of your own. Am I right in that assumption?
Yes, ma'am. Because especially because like being in Connecticut, they're monitoring and giving all the information back. But I feel that just for any ICPC, that the state that is monitoring should be able to do their own investigation and look into things and also give feedback on that, on what they find.
And has Connecticut looked into that? And was that done in a timely manner if they did?
So they did not, because they said they were not able to because it is not their jurisdiction. However, I did have a baby girl in December. That
Congratulations.
because of predicted neglect,
Oh.
they tried to take her, but were not successful. We got her back because it was found that it was unsubstantiated and there were not any harm to children. But during that process, they did pull all the stuff from Tennessee and were trying to use that to take her.
Can I ask one more question? Did you get your boys back?
No, ma'am. It's been 14 months now, and they still live with my in-laws in Griswold.
I'm just trying to process all of this. And having three brothers that were in the service, two of them under the auspices of the Navy, I also know that they look into these types of situations very, very carefully, and don't mess around with if they've cleared you. I'm just trying to understand the next steps in the process and why you're here where you are in this situation and your family. Thank you very much for your testimony and for being able to ask questions.
Thank you, ma'am.
Thank you so much. Representative Dauphiné.
Thank you, Madam Chair, and thank you, Matt, for being here. We're so appreciative that you can tell your story. And to Rep. Welander's point, and I think many people in this room, we're all appalled, simply appalled at what's happened to you and that you still don't have your boys. I'm very proud and pleased to have kind of worked with you along through this, and we're happy to get your story out. But I guess maybe you could, I don't know what was said. I was in another meeting, and so I just came down, but could you just maybe fill us in? I know Alicia, your wife, will be on in a little bit. We'll be able to get a little more information from her, but did DCF here in Connecticut have an opportunity to look at anything with regard to your case in Tennessee, or has this been like Tennessee's case and they handle it and that's what you're dealing with?
Yes, ma'am. So Tennessee is, since it's their jurisdiction, they handle it. So DCF here They have not looked into anything for the boys, even though we have given them all the information because it's not their jurisdiction.
Mhm.
They're solely just to monitor and give reports back on how we work with the children, which have all been glowing reports. But again, that's why I think that Connecticut should be able to do their own investigation in the ICPC process and feed that back to where they could have a meeting and maybe determine something between the two.
Thank you for that answer. And I would add that, we're looking at now, how many months has it been since your boys were taken from you? Because how old are they now?
They are almost 14 months. So
They were taken
well,
at
14,
5 weeks?
14 months is, sorry, it's been 14 months since they've been taken,
Okay.
but they're about 15 months old.
So, correct me if I'm wrong, but we can look at this and say, if this case were in Connecticut, perhaps things could have moved along much quicker for you to have your day in court, be able to bring the doctors in, which I understand you did have your boys evaluated by a pediatrician, a specialist in Boston, which was, if you will, disregarded by the Tennessee DCF. And perhaps that would have been looked at a little bit differently here. There's so many pieces to this testimony and story that it will take us hours to really cover all of it. But would you agree that all of those things would be better handled if they were here in your home state versus having to try to work with those in the state of Tennessee and living here?
I do, ma'am. I believe that the state of Connecticut is not only more efficient in handling those processes more faster, but it was even proven when they, with my daughter, how when they tried taking her, we were in court the next week to take care of that, where we still haven't set foot in court down in Tennessee and still won't till April. And we've spent about $35,000 so far.
Thank you for your testimony. Thank you mostly for your service to our country. We're glad you're here and we're looking forward to listening to Alicia as well. Thank you.
Thank you, ma'am.
Representative Hayes.
Thank you, Madam Chair, and I would like to yield my 2 questions back to Representative Lanu.
Representative Lanu.
Thank you, Madam Chair. Yeah, Mr. Jackson, can you tell me as far as the scope of what happened in Tennessee with the Tennessee Department of Children's Services? Did they what was the scope of their investigation? Did they contact the state of Washington? Did they did they consider what the military how the military essentially exonerated you and your wife? Did they take that into the account at all as far as the placement of your children?
No, they did not. So can you repeat the question again and for the beginning?
Yeah, I'll rephrase. The military, as we discussed, you said they essentially exonerated you and your wife of any wrongdoing. They independently looked at this. Has the state of Tennessee took this into consideration at all?
No, they have not. And the initial contact with Child Services, like I believe you also asked in your question, down there, we even informed them of how my wife's side of the family has rickets in the family. So we wanted them to look into that, and they just brushed it off. They didn't do that. And also with how they were born early, and she had prenatal issues as well, like preterm labor and stuff with the boys. And we explained all this to them and what we would like for them to look at more, like even possible OI or brittle bone disease. And they again just brushed that off. And even when the doctor at the hospital said that she cannot rule that out, they still decided to take the children.
Wow. Let me bring it back home. Let's talk about Connecticut DCF. What they're able to do. Have they been able, or do you know, have they independently investigated the underlying allegations, the underlying decisions that were rendered against you by the state of Tennessee? Have they looked or investigated the underlying matter in this case? And do you know why or why not?
To my knowledge, they have not. And I do not know why, because we've given them all the same information over and over.
So everything's pretty much at a standstill where you still do not have your children? And-
Yes, because they said, Connecticut says they're unable to help because it is not in their hands or in their jurisdiction.
It is not near,
Representative Lanu,
okay, yep.
Representative Pizzuto.
Thank you, Madam Chair. I'd like to yield my two questions to Rep. Dauphiné. Thank you.
I thought perhaps you might.
Yeah.
Representative Lanu.
Thank you, Madam Chair. I'll try to be quick. I wanted you to explain a little bit the difficulty in trying to get assistance in Tennessee while living here. For example, I know you've been working with Rep. Lanu. I know you've been working with Representative Dubitsky. We have spent hours on the phone working with you. How does that translate to trying to get a legislator in Tennessee or perhaps somebody there to help you when you're living here?
So it's been difficult because they just do things differently down there, especially where it is. It's a smaller town. But I will say we have reached out to a representative down there that said give us the questions and stuff, and they will go to the commissioner down there. And we've given that, and I'm still unsure if they actually went to the commissioner to talk to them about it.
Thank you, Matt. I just wanted to have everyone here understand how difficult it is when you don't have your own representative in your own area helping you. And because you live here, you don't have that in Tennessee. So it makes it that much harder. But thank you for your testimony.
Thank you, Representative Dauphiné. Any other questions? Matt, thank you so much for being here and for sharing your story. We very much appreciate you.
Thank you again, Senator.
Next, we'll have Alyssa Trachtenberg, followed by Alexandra Gruber Perez.
Hi, thank you so much for having me. I submitted written testimony, so this will be different than the written testimony. So thank you for taking up SB 217 to create a universal patient intake form. I'm the mom of a young adult who's been receiving a plethora of behavioral health services since the age of 3 from a variety of service providers ranging from, but not limited to, in-home programs, outpatient and inpatient services. We've used a large number of voluntary services available, access resources at child guidance centers, schools, private providers, crisis units, therapeutic boarding schools, and so on. I've had over 15 years of filling out paperwork and doing inpatient intakes for my child. So for someone who had mentioned I could carry around the paperwork with me, just so you know, this is a portion of the paperwork. Just thought I'd show that. As was said, it's imperative that clinical service providers are able to communicate with each other so they're not treating in the dark. Sadly, I can attest from personal experience that there's absolutely a gap in information sharing. It comes in part, in my opinion, from the fact that there's a large variety of electronic record systems that don't communicate with each other, and also from the fact that providers are busy and that the parents or guardians need to fill out release forms, and some of those require that the forms be dropped off in person for each party, and for them to be able to even share the information or reach out to the other provider that you've asked them. And some of them, we hound some of our providers for weeks and weeks to do this. It's not that easy. So while in theory, best practice would be for agencies to share information with each other, it's not consistently happening, and it's beyond frustrating for a parent or a guardian who's desperate to get their child the help they needed. In addition to not allowing clinical service providers to have a complete overview of the patient, the current intake process is burdensome, inefficient for both the parents and guardians and the service providers, with mounds of repetitive paperwork, as agencies can transfer or share basic information from one intake to they can't share or transfer from one to another, even with the same service provider at the same agency. We filled out something with ICAPS. We'd use them like many times, and we had the same provider multiple times, and we had to refill it out because they were not able to even pull it up on their screen. So like a common app, you could have common questions that everybody fills out, and then you could have particular questions for a particular provider. Furthermore, I want to say that it leads to a delay in receiving the actual services as the first few sessions are spent doing an intake, filling out paperwork. I hear today that there's a lot of concerns about breach of information, but much of the information is already out there. It's through insurance, MyChart, personal computers such as mine, because if I have to type it up and carry it, if I have to write it out or type it up, you know, and it's online and people could go onto my computer. So the information is out there on all of these kids. There's so much information out there. You can't put the genie back in the bottle. And I'd rather be able to make sure that my daughter can get the help that she needs than that she ends up dead because people don't have the right information. And, you know, I know that one of the
Can
people
you please
suggested.
summarize your testimony?
Yeah, the point is we need to have something like this, and the system we have right now is not working. And we also need to have this expanded to adults as well, because there's a lot of adults with mental health problems as well. And so anyway, thank you.
Alyssa, thank you so much for being here. You showed us the box of your records, which obviously is huge and
Some
quite
of them.
heavy to carry around.
Yeah, that's like half of them, maybe.
It's half of them.
Yeah, maybe. That's actually, it doesn't have her newest stuff. So that's from only up through age 12. That
Okay.
box is through age 12. Sorry. Again.
So aside from carrying all that with you to go to an appointment, can you please speak to, because I'm presuming you've had this experience of being in a new provider at a new, perhaps at a new facility, and what's it like when you are presented with a form? And can you speak to the impact of bringing your child to this for observance or, you know, care, and then having to address issues in a new form?
So it's really frustrating because you don't always remember things. So a lot of these things happen when so having a child with mental health services is traumatic for the child, it's traumatic for the family. And a lot of times when you're first filling out things, it's in a crisis situation. Either you call 211 or 911, or 211 is called 911 and you have people show up, or you finally end up somewhere. So you're rehashing, just like, I think it was Even S who was talking, I don't know if that's how you say her name, who had the woman who had been through the system for years and years and years. It's traumatic to sit there, to fill out the paper, to go through the same exact thing. And it feels like a waste of time because you waste the first few sessions. Like, sure, I get they might have other questions that they want to ask that are unique to their agency, but the medication list, the history, you know, like, sure, get the history from my child from the last time they saw someone to now, no problem. But you don't have to go back and rehash everything. It's there. And what happens is you don't always have everything with you, you don't remember. So like for me, I've tried many times to get the list of medications that my daughter took because she had adverse reactions to at least a dozen psychotropic drugs. And I don't remember what all of the reactions are. You just, in the moment, you don't remember, your emotions are heightened. And it's really, really tough. And you can try and put back, but you might not remember all of the exact dates. It just leads to, if you had it in the system and you could update it as you go along, it would be accurate. They can look some of the stuff over before you meet, so they're not sitting there using up the time. You know, once you make a chart with all of the genetic information and who has what illnesses, and that's the same, that's pretty much the same. And so anyway, it's incredibly frustrating and it feels like a waste of time, and it's difficult to get all of the information accurate. And as time goes on as well, memories fade. So it's not as accurate as you move forward for the stuff. I mean, my child's been in receiving services since 3 years old. Okay, so we're talking like over 15 years now. I can tell you what's going on now, but I can't tell you what was going on necessarily as vividly and as accurately. And I read through this year, all of her things, and there's a lot of themes. And when the agencies share the information, they can really help provide an overview. Like, instead of just having what they have, when you really go back and you read everything, you can get a different picture and you can kind of see what repeats and everything, instead of having everything isolated And then like some agencies give you forms to fill out on paper, and then they can't really write them, and then they might put things in incorrectly spelled. You know, there's a lot of there's a lot more room for error, stuff like that. But the most frustrating is when it is the same agency with the same provider. And then they tell you, you say, well, look, we just saw you 3 months ago because they told us we had to wait for, you know, for our time. Because some services, they make you wait for 3 months to start up again, which is silly, but that's a separate issue. And so when you have the same person and she says, oh, well, we can't really pull it up in our system, that's just ridiculous. So I don't know, that's my personal opinion. So I've been lobbying for this for a while because it drives me crazy. And I also am part of NAMI, and I know the other parents in that group that I'm in, NAMI Southwest, it's the same thing. And I guess what exasperated me the most is I was filling out applications for my daughter to go to therapeutic boarding school. And by the time I hit page 28 for one of them, some of the questions, they're same kind of questions, but when you have a kid who's had a long history, like each page had like 2 or 3 questions, and then each question required at least a 2-page answer, and you're just like, oh, every single time. So a lot of the stuff it's repetitive, and it's got to be really frustrating for service providers as well.
Thank you so much for that. One last question, and that is, in any of the times that you've brought your daughter to receive care, has usually in an emergency situation, has this created a situation where you had to wait and were prevented from getting the care in the timely way that you needed?
Well, you always do, because it takes a lot of time to do it. And when you're, the first few sessions of whatever you're doing, you don't get the care right away because you're doing the intake. So let's say you sign up for something like ICAPS, you might spend the first couple sessions, and if they only come once or twice a week, you're waiting weeks until you actually start any kind of treatment. I'm just picking that out of the, out of the blue, but let's just say you use something like that. You're waiting for the person to be assigned, and then once they finally get assigned after a long wait, you're waiting several weeks. So you're not actually getting, and then if you use another service after that, it's the same thing. You spend the first few weeks, so they're not even really building this bond, which is so critical, especially when you have a young child. It's really important that they can connect to the therapist or the service provider or whoever it is. And this first time is not spent bonding. It's spent answering repetitive questions that have already been answered many times.
Thank you so much for your testimony. Is there anyone else on the committee who would like to ask a question? No? And
it looks like
online we have Senator Kushner.
Thank you. I don't have a question, but I did want to thank you, Alyssa, for your testimony here today. As always, I find you to be very precise in your knowledge and very to the point about the issue that we need to solve. And for members of the committee, I can tell you as one of our constituents from Richfield, you are so valuable to the community because of the work you do and advocacy you do for children and for all those that live within Richfield. So thank you for being here today.
Thank you for having me. Have a wonderful day.
Thank you. Bye-bye. Next, we have Alexandra Gruber Perez. Oh, okay. Then Catherine Davies, followed by Alexandra Tudiska.
Senator Mayor and esteemed members of the Committee on Children's, I'm grateful for the chance to speak to you today with regards to Bill 215, an act concerning youth camps. My name is Catherine Davies, and I serve as the Associate Executive Director of Camp Hazen YMCA. Additionally, I'm a member of the Connecticut Camping Association, their Legislative Committee, and the incoming chair of the current Youth Camp Safety Advisory Council. While I support the underlying goal of prioritizing safety and well-being of children in youth camps, I have some some reservations about the current wording of the proposed legislation. Firstly, I fully agree that new camps and single week camps should undergo inspections earlier in the season. However, I'm concerned about the use of the term national accreditation. It would be helpful if the bill specified which national accrediting organizations the OEC will recognize. Alternatively, relying on the longevity of the director and past OEC inspections may be more like a reliable standard. Regarding Section 2, I'm pleased to see the recognition of the Youth Camp Safety Advisory Council as a permanent advisory group to the OEC. The Council has a strong track record of collaboration with the OEC and previously the DPH for the past 40 years. The Council currently has 9 members representing various types of camp programs, serving 2-year terms, and we work closely with the Connecticut Camping Association. While increasing the diversity of the council could be beneficial, I would hope the appointees will possess a working knowledge of current camp operations. I do have some concerns about the timely appointments of positions by legislative leaders, the specific meeting timing requirements, and the quorum requirements. And I'm also curious of the rationale behind appointing representatives from the Park and Rec Association, considering they are unlicensed and not bound by the state's youth camp regulations. Lastly, I respectfully oppose the position of Bill 215 mandating a submission of an annual report to the Commissioner by licensed camps. This requirement duplicates existing processes within the licensing and regulatory framework governing youth camps. Requiring additional annual report imposes unnecessary administrative burdens on both camp operators and the OEC without offering significant insight or accountability benefits. However, if municipal camps were required to fill such a report, it could establish a more consistent standard for summer programs across the state. If the goal of this bill is to improve oversight and enforcement regulations in youth camps across Connecticut, I believe that by providing OEC with additional resources to hire and train inspectors and staff could be a more effective way. Thank you so much for your time and in ensuring that the children of Connecticut can enjoy their summer in safe programs.
Thank you so much for your testimony, and thank you for the work you do with children. Any questions from the committee? Seeing none and none online, we appreciate your time. Thank you. Alexandra Tudiska?
Hi, I'm Alexandra Tudiska, and I'd like to thank you guys, honorable members and chairs of the committee, for listening to my support on House Bill number 5259, which is an act that would allow court orders pertaining to child custody provisions to include identifying a neutral location for parents to drop off and pick up their children. Now, although I could speak on my experience as a social work student and as a professional who has collaborated with family clients navigating abuse, I actually feel a personal responsibility to share the following story of how co-parenting with an abuser is dangerous for survivors of abuse. To respect the individuals in this story, I'm not going to use names or identifying information, so that way their privacy is respected. But about a year ago, I was with a close friend of mine when she picked up her daughter from her ex. Her ex had psychologically manipulated her, controlled her, and lied to her for years. This is a man with whom she must now co-parent for their 4-year-old daughter. It was lunch hour in the parking lot of a local restaurant, and customers were walking past us as the two of them transferred their daughter from his car to hers. For the next 10 minutes, my friend's 4-year-old daughter had to listen to her father without shame and with no regard for who was listening, proceed to verbally belittle and degrade her mother in front of strangers. People stared as he harassed her for the entirety of the pickup, and my friend could do nothing but plead with him to stop, to be kinder to me as he belittled me within his tantrum, and to not say such things in front of their own kid. He expressed just how much he did not care about what he was doing as he continued to use verbal obscenities and insults to hurt her. He went on to call her over 40 times after we had left to continue his beratement over the phone. And as we drove away, my friend looked to me and profusely apologized, and she said, "I'm sorry you had to see that, but please don't forget about this. You need to know that this is what intimate partner violence looks like." Even though my friend's ex caused so much harm to her and her daughter in this 10-minute interaction, I at least knew that my friend had made the best choice to meet in this neutral location. Because I couldn't help but wonder that if this is how he chooses to behave in public, what more would he have done if they did this privately? Without bystanders, without the restaurant's cameras facing the parking lot, and without me being there as a witness. Abusers will capitalize on every opportunity to cause harm. This same man now has pending criminal charges and a full no contact protective order against him. We must deny abusers these opportunities to perpetuate their violence, and we must prove to survivors that we are here looking out for them. We all know a survivor. They are our parents, they're our siblings, our peers, and they're our friends. And they're watching to see how we show up for them. And I'm trying to show up for my friend by speaking with you guys today. Thank you so much for giving me your time.
Thank you for your testimony. Representative Dauphiné.
Thank you so much for that testimony. I'm very familiar with a situation like this that was very personal to me, so I can appreciate the desire to address this. So my question is, are we looking, would you like to see this done for everybody, or is this specific to cases such as your friends who had this situation? I mean, there's many, many people who exchange children and nothing like this happens. So I'm just wondering, are you looking for this bill to pass to protect just those specific families and children that this happens to?
Correct. There are many separated parents who co-parent very healthy and very well together, where this provision would not be necessary. But we have a lot of evidence in a lot of cases, too many to count, where people who co-parent are afraid to meet up with their child's other parent, their other mother or their father. And they need protection set in place where there are ways to hold their perpetrators accountable if they don't meet these mandates of their custody agreement. So I think this is important to become an option for those who are afraid to be co-parenting with an abuser.
Thank you very much for your testimony, and I couldn't agree more.
Thank you.
Any other questions? Seeing none and none online, thank you again for speaking up for your friend. Next up will be Kristen Ebner Martin, followed by Kim Libera.
Good afternoon. I would like to thank Senator Maher, Representative Linehan, who's unfortunately not here at the moment, Senator Seminara from my neck of the woods, Representative Dauphiné, and the other esteemed members of the Children's Committee for their time and energy to keep our summer campers safe and healthy. My name is Kristen Ebner Martin. I'm a third-generation Connecticut summer camp owner. My family has owned and operated 4 summer camps in Litchfield County since 1948. If you want names, they're on my shirt. We have, for the last however many years that is, since 1948, my family has been operating all 4 of these camps safely under the American Camp Association standards since their inception in the 1960s and the state of Connecticut laws governing youth camp operations since the mid-70s. And like my esteemed colleague who's coming up after me, Jane Balefield, I have been involved in summer camp all of my life. My first summer, I was 5 months old. Today, I would like to speak to you about the proposed bill, SB 215, and some praises and concerns I have regarding it. Firstly, I am in complete agreement with the idea of OEC placing priority on inspections for 1-week camps. I also believe that any established camps that have major changes between seasons, such as new owners or directors, or a new location, should also be put on this priority list. Having the well-known established camps that have proven their safe track records on the bottom of the priority list is also a win for those camps. Secondly, I would like to address the official establishment of the Youth Camp Safety Advisory Council. Having served on that council for approximately 10 years, back in 1998, I believe that having 12 members of this council is a great idea. I believe that asking for 10 members to be a quorum is a stretch and would ask you to consider making that quorum number 8 instead of 10. When I was on the advisory council, we would meet 4 times a year, but not necessarily quarterly. Our meetings were held in October, December, January, and March. Because the majority of this council would consist of camp people, meeting in quarters 2 and 3 makes that very difficult. In addition, in section 2, subsection B, numbers 2 through 4, I would ask that you add language that requires these appointees to have knowledge of summer camp operations. In that same section and subsection under number 12, I would humbly request that you change the word any to an, so that it states and I quote, "an additional member appointed by the commissioner to fill the needs of council based on expertise in the field," not any additional member. Thirdly, I would ask you to consider the requirement for the annual report for established and accredited camps. It seems to me that this was meant to be aimed at the 1-week programs and at municipal programs, so perhaps the wording should be updated. Camps who are accredited by the American Camp Association are required to complete an 18-question, 5-page annual accreditation report prior to opening each summer. I know that the Boy Scouts of America also require their camps to complete paperwork and an inspection prior to their opening each season. Also, many camps who may not be ACA accredited for whatever reason also have ACA accreditation visitors on staff, so they often comply with all the ACA standards, of which there are over 300. This accreditation, if you do not know, with the American Camp Association is completely voluntary on the part of the camp. Thank you for taking the time to hear what I have to say with regards to this bill. I would like to mention, which is not in my written testimony, on Bill 218 with regards to the help for grieving children and grieving families. I have one thing I'd like to say to you. I live in Northwestern Connecticut. 17 years ago, I lost my husband and my children's father to alcohol abuse. There was nothing available for us in the Northwest corner. So anything that you can do to bring that to every part of Connecticut for my now turning 20 on Sunday year-old son would have been amazing at the time. And now he's had to deal with this for 17 years with just me. You know, and I deal with a lot of kids, but it's really difficult to deal with your own when they're grieving and you're grieving. So thank you for listening.
Thank you so much for your testimony, and thank you for your heartfelt
Thank you.
statement around the grief camps.
Thank you.
Having lost my husband to alcohol abuse also, my heart goes out to you.
Thank you.
And
And
I
mine
was
to
a
you.
little luckier. My kids were older. Thank
Yeah,
you.
he was only 2.
I'm so sorry. Senator Seminara.
I want to thank you so much for your testimony on both bills. Your insight on the camp bill is very valuable. So I hope that my colleagues will take that into consideration. I've been a proponent of this bill, parts of it, but we need to, I think, take into consideration your feedback. So I very much appreciate that. And I also very much appreciate you heightening the fact of the limited resources that are in the Northwest corner. So I represent the Northwest corner. We are forever, and I am forever begging for resources in the Northwest corner, whether it's transportation, therapy, medical services, educational, you name it, the Northwest corner. There is a grocery and food desert there. I mean, I can go on and on and on. So I very much appreciate you advocating for the Northwest corner and recognizing and making people aware that there are many services that are lacking there. And please know I'll continue to try to work on improving that. Thanks so
Thank you,
much.
Senator. If I can be of any help to this committee at all, as I said, I've been doing this for 58 years and I'm 58 years old. And my dad is 81 and is still around. So if we can help at all, please let me know.
Thank you. Are there any other questions? Seeing none and none online, we really appreciate your testimony.
Thank you again.
Kim Libera.
Hello. My name is, can you hear me?
Yes, thank you.
Okay. My name is Kim Libera, and I am a coach. And I've been aware of this energy drink issue for a few years, notably the products known as Monster and Red Bull, which are hypercaffeinated. And these have been shown to cause on occasion some cardiac fatalities in our youth. And I'm guessing that they are overdosed in caffeine for a person's metabolism at that age. And I think our FDA does a very poor job on regulating stuff like that and allowing it on the market. And personally, I would like to see some restriction, but I will give you some options that you can consider along the way, because I understand the slippery slope of trying to ban every single product there. First of all, it is false advertising that these are energy drinks. Okay? Energy is derived from carbohydrates, fats, and proteins. Caffeine is an alkaloid stimulant, which keeps people alert. And this is a very attractive drink to some people. And most people are not educated in nutrition to decipher the devil in the details there. So what I would first suggest is that you work with DPH, CP, and the Department of Education and work to develop a nutrition requirement course as part of our phys ed curriculum in high school to educate and develop some consumer skills for people. Likewise, these agencies can develop apps or webinars that could be placed on YouTube or on their website, some brochures. I would maybe like to see a mandate in supermarkets of a very detailed large font bulletin that incorporates information as to some of the dangers in these particular drinks and it placed in that aisle. Let me differentiate that these energy drinks are much different from electrolytic drinks like Gatorade, Powerade. Those drinks are meant to hydrate the body, and this is very important for athletes. And I'm not for taking those off the market or restricting those. But clearly, a lot of people that go into this type of business develop stuff that is really not good for the health. They're out there to make money. There. So I would encourage you to work in that direction as well as you try and develop this topic there. I think the CIAC will take a role in this in dealing with our high school athletes. What we must remember too, as we have developed some
Can
of
you
these
please summarize your testimony?
these issues along the way, is after a few years, coaches just tend to check a box and don't go about teaching the athletes this stuff. And we forget what we're there for. It's got to be more than winning. It's got to be mentoring too. So that's what I would like to say.
Thank you so much for your testimony. Any questions? Representative Dauphiné.
Thank you for your testimony. And just, I'm just curious. So I have several data sheets here that show where the energy drinks fall in place with regard to caffeine and sugar and the like. And really the energy drinks fall really to the latter lower side. And we know that young kids are going into Dunkin' Donuts and Starbucks and getting all these espresso drinks and frappy drinks and full of coffee drinks full of caffeine. So with with that knowledge, I mean, would you suggest that we do education with regard to the ingredients that are in all those drinks, or are you just specifying energy drinks?
Regarding the bill, I'm here on the bill, but I would say it would be a good idea to educate the public on all of this stuff. I mean, I've had this knowledge for over 40 years since college, and I'm appalled that we don't do a nutrition course in school. Believe me, even parents don't know this stuff. I have to teach it as a coach. Therein, it would help the consumer discern stuff. This is a consumer life skill, and you can go over it certainly in a school curriculum because you have more than one day to do it. You may have a term or a semester to do it, and it's worth developing that critical reasoning skill.
Thank you for that. And so you're supporting the education piece versus prohibiting the sale of energy
due to one
drinks.
of the other testimonies, I personally don't like these drinks. I would like, if you can, to have this parental restriction. If I can't get that, the next best way is education. And I educate a lot about it every year, but not every coach does. And most parents don't know this stuff. And we've had potent testimony here today. I'm always for increasing consumer knowledge on nutrition, and that should be a standby. It's better than, if I can reach 80% of the people, 80% is better than reaching none at all.
Thank you. Thank you for your testimony today.
I think I'm stepping in for Senator Marr for just a second. Does anyone else have any questions in person? Are there any questions online? I don't have that open. It looks like we are good. Thank you so much for being here today and
Thank
for
you.
your testimony. Next up, we have Jane Beelfield. Awesome. All right. Thank you. And after that, Caitlin Lupia.
Can you please turn your mic on?
Sorry. I'm Jane Bielefield. I am president of the Connecticut Camping Association. I also work for Chris at Camp Chinqueca as one of the co-directors up in Bantam. I have been at camp since I was 6 months old. My parents were camp directors. My dad worked for the Boy Scouts. My mom worked for the Girl Scouts. I'm not always sure how there's 4 of us. So looking at this bill, there's a couple of things that pop out at all of us who are concerned. One being certainly the Youth Camp Advisory Council. We would like to see the quorum certainly lowered to 8, that their meeting schedules be not so dictated in that bill, only because that sets people up. And like Chris said, it makes it really difficult for those people in camping. I also think that looking at the way camps are inspected and the order that camps are inspected, it does make sense for camps who are accredited by the American Camp Association. There are 46 of us in the state of Connecticut, and camps that are Boy Scout accredited, and those camps that have camp directors that have been in place for a long time. You have people who know what they're doing, and you've got camps that are run by ACA visitors. So we do have some sense. I know in Maine, if you are an ACA accredited camp, then you take 1 year that you don't have to have an inspection. I did some research after a quick meeting with Senator Marr and Representative Linehan in January about what the other states in the area are doing. And right now, there's a lot of states that aren't even being inspected. And I know 40 some odd years ago, we fought to keep that inspection in place because it was being considered a waste of money. So, and lastly, the annual report, again, I think that needs to be looked at, and it needs to be really focused on those municipal and 1-week camps that have high turnover and are not being inspected. When the press has a headline that says that there was an injury or fatality in a camp, it doesn't specifically say that that camp was licensed or not, and whether or not they're meeting all of those state regulations that the rest of us are meeting. So in closing, that's where we're looking at. That's what we have. And we also would like to offer our services if there's any way we can be of service. We've worked with Pat Boyd, who is also a member of our association. So, you know, we're available and would be willing to offer anything we can to support this bill.
Thank you. And I see that you have also submitted
Yes.
the written testimony for the
Yes.
details. Thank you. Does anyone have any questions? Here's Representative Comey.
Thank you, Jane. I recognize your name from my days with Girl Scouts. You mentioned that perhaps it would be better to have municipal camps or folks that were not currently a part of the American Camping Association, some of the other associations that you're already submitting all these extensive reports to. If, for instance, and you may not know the answer to this, if the OEC does not have authority over those camps, what sort of, if they get a report and it's indicating something that might need to be, looked at further or reviewed, or, we don't have the authority over that. And I'm just curious if you have any thoughts on that.
I did try and find information on that in looking at other camps, and around here in New Jersey, New York, all of New England. I meet with all the presidents of the other state associations in New England on a monthly basis, and no one could help me with that. So no, I don't have that information. I have a concern that you have seasonal inspectors at OEC and they're gone, and there's no one to review the annual reports that are being submitted. So that is also a concern of ours.
Thank you. Any other questions? And I don't think they're online. No other questions online. Thank you so much for being
Thank
here.
you.
Next we have Caitlin Lupia, followed by Glenn Lungarini. Nope, that's not right. Lungarini.
Good afternoon, honorable members and chairs of the committee. Thank you for hearing me today in regards to my support of Senate Bill number 216, an act concerning a study regarding the use of an online software application to address the mental health needs of students. As a social work student, mental health is something we talk extensively about. But instead of going on about suicide statistics, like how in 2023, 48,138 Americans died by suicide, I would like to share a personal story with you. I was 15, it was a Friday, and I was so excited about the weekend. I'd gotten on the bus that morning and was talking to my friends when I later noticed that one of them hadn't gotten on. It was getting colder, maybe they were just sick or missed the bus, but fast forward to first period. I was sitting in algebra when the principal came over the loudspeaker. The friend that I thought was just sick or missed the bus had actually passed away. I heard an agonized scream from down the hall as I made my way to the library where the counselors were going to talk to the friends of the student who passed. We didn't find out until later that this high school sophomore, this friend of mine, had died by suicide with the use of a firearm. I sat there thinking, I saw them get off the bus on Thursday. I just saw them yesterday. The fact that still sits with me to this day is that they had said goodbye to me, but I didn't say goodbye back, not knowing that I would never get this chance to talk to them ever again. To my knowledge, this came completely out of the blue, and no one had suspected a thing. To think that this child was struggling so much alone that they thought suicide was the only way out breaks my heart. Suicide is the third leading cause of death in high school students aged 14 to 18, and in 2021, in Connecticut alone, 14% of students in grades 9 through 12 said they seriously considered committing suicide. No child should feel that suicide is the only way out. A study like this could change the game. By giving children a way to talk about their mental health struggles, we could further reduce the stigma surrounding mental health and get more kids the help that they need. Call me hopeful, but maybe this could further reduce the number of suicides in the state. Maybe instead of 1 in 8 kids considering suicide, we could reduce that number to 1 in 20. Thank you for your time. I really appreciate you listening to my story.
Thank you so much for being here and for sharing that. Just our heart goes out to you for having been through that. I know how hard that is and the thoughts that come with it afterwards and the regrets. Are there any questions from in person? Representative Daphne.
Hi, good afternoon, and thank you for your testimony. From what you've just said, I think you advocate for this app. A couple questions. Do you know the cost of the app and who will be paying for it? That I could not find the information on. If you have the information and would share it with me, that would be lovely. Okay, thank you. I just wanted to know if you knew. Yeah.
Are there any other questions? Are there any online? Thank you so much for being here and for sharing your testimony with us.
Thank you.
Up next, we have, I'm going to say it properly this time, Glenn Lungarini, followed by Alicia Jackson.
Good afternoon. You did a great job with that fine Irish name. Appreciate that. So- Yes, thank you. I'm Dr. Glenn Longarini, Executive Director of the Connecticut Association of Schools and the CIAC. Here today to talk to you about House Bill 5261. I have submitted written testimony, but again, just wanted to take a minute to highlight some of the thoughts. In addition to my role with CIAC, I also serve as a consultant on the Connecticut State Medical Society Sports Medicine Committee. The topic of looking at these high sugar drinks, high energy drinks is something that has been talked about frequently. And with that, I think there's agreement across the board that the promotion and the advertising of what these drinks can do in terms of performance enhancers and stimulants that is often advertised to kids does not hold true when we look at the actual impacts. For these high caffeinated drinks, while yes, caffeine is a stimulant, it does wear off fairly quickly during high intensity sport and exercise and really does not have the impact that kids may believe it has. High sugar drinks, again, have shown that there's really no enhancement to performance in the high sugar drinks, but does add significantly to what we face in terms of obesity crises across generations. There's also concern in some of these high caffeinated drinks of what it could do to kids with underlying issues of cardiac, undiagnosed or unknown cardiac issues. We have seen increases of younger and younger kids facing cardiac incidents. And so that is another concern that we have. Just quickly, a previous person had testified looking at curriculum. Out of our CAS-CIAC office, we do serve as the state consultant for health and PE and state coordination. We do, through the Healthy Balanced Living curriculum, talk extensively about nutrition, and we do have a section on there that talks about high sugar drinks and how to limit those, what should be considered. So not only what you see in some of the canned over the counter stuff, but also in what kids are purchasing, at the local stores or, the Dunkin' Donuts, Starbucks, and so on. Thank you for the opportunity to speak to you today. Happy to answer any questions.
Hi, Dr. Longarini. Thank you so much for being here. You have always been such a huge help when it comes to the work this committee does, especially surrounding the health and wellness of our kids and especially our athletes. So that's where I'm going to ask my question. This committee last year or the year before, maybe it was last year, we unanimously passed out a bill that would create that athletic health group that we wanted. Unfortunately, it did not pass into law, but you took that and ran with it and did it anyways, which thank you so very much. In that, has that group had a chance to meet yet?
We have met. A lot of our discussion through the fall was really focused on the topic of throat guards and ice hockey and looking at the realization of doing cardiac testing as a preventative measure. Those were kind of the focuses of discussions thus far.
I've always been a huge proponent of the cardiac testing, but that goes to now this, right? Is there can you speak for the committee now by saying whether or not you believe that these energy drinks pose a direct cardiac risk to student athletes based on the fact that you've seen that they ingest them prior to getting on the field?
So I'll speak from just my research on it. And I did reach out to several of the doctors on the CSMS committee preparing to come today. So for kids who have underlying cardiac issues, we do believe that this is a risk for those kids. For those that don't have underlying cardiac issues, it's going to have an impact that any other stimulant would have. So it's going to increase heart rate. It's going to create a little bit more of that jittery feeling. Again, as some kids may feel that stimulant gives them, an advantage in enhancement of performance, it wears off fairly quickly as you're engaged in that activity. It's really going to be what you have in your healthy stores in terms of carbohydrates to really pull on in those long duration activities to continue to perform at a high level.
Thank you very much. And since we have a 2-question limit, that's it for me, but I'm going. You know, it's like, hey, your own rules or your undoing, lady. But, you know, I'm just going to make a statement, that you know, it's really important to have, the conversation regarding student athletes. And I will say, as an athlete with my coach here today, I don't know if you know this, but Representative Lanu is coaching me in powerlifting. You know, and it is, yeah, it's true. He's doing a great job. Really tries to get my weight up there. So because of him, my deadlift is just, but the point is that in our sport, we see that a lot, and we also see the use of smelling salts and things before a deadlift in order to, you know, get the blood really flowing to the muscles. But I have seen even adults who ingest what is known as a pre-workout, which is the exact same thing as an energy drink, and they feel like they're having panic attacks and heart attacks. And so it's a definite concern. And especially when it comes to our kids, because if you went and you took 3,000 18-year-olds and you ask them, do they have a cardiac condition? Most of them are going to say, I have no idea, because before the age of 18, it's rare to have it diagnosed. So I appreciate you being here and talking about that importance. So thank you very much. Are there any other members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Thank you for coming. Appreciate listening to your testimony. I'm curious, do you feel that there's a lot of other drinks out there that are just as high in sugar and caffeine as energy drinks? Like I was last night looking up coffee at Starbucks. There's a lot of caffeine in it.
Yep.
So taking the ability away from kids under the age of 16 to purchase them in a store, technically they can still go to Starbucks, right? And they can still purchase a coffee that has high caffeine in it. So your experience in sports, have you experienced students taking other things than energy drinks?
I mean, primarily in sports, we'll see kids in, you know, in the Gatorades, Powerades, you know, that sort of sport drink that they're taking. And, you know, the sugar level in those drinks alone are fairly high, not to the level of what you see in the energy drinks, but it's the type of sugars that may be involved in the formulas for those drinks. So if it's more of a, you know, complex carbohydrate, that's part of that sugar, than a simple sugar, the body will use it differently. And for the sport purposes, that's where a Gatorade or a Powerade may be slightly, you know, maybe more beneficial than, you know, if you're having the Frappuccino from, you know, a coffee shop. But as you're saying, I mean, I was a high school coach, a college coach, and a health and PE teacher, and a principal, and I can't tell you how many kids, you know, I see walk into the school building with an iced coffee and a, you know, or, you know, a Dunkin' Donuts cup or Starbucks cup. So I think it's, you know, we're not going to solve that issue with any one measure, but any one measure that we can take towards solving what is, you know, potentially an issue, I think is a good step. The work that we do through the education piece of that is going to continue to be of importance, as you said, educating people on what is the best thing to buy and put into your bodies. But, you know, I don't think any one measure will necessarily change that across the board.
Thank you. Yeah, and I actually agree with that. I believe education is always a better alternative. I think today people are more educated and more in tune with what's actually going into our foods today more than ever. I don't necessarily believe that having a 16-year-old under 16 not be able to buy an energy drink is going to solve anything, because we can't monitor them, right? We don't know what they do when they leave the store. We don't know what they're doing at home. We could assume, but we can't know for sure. And this committee is really good. You know, we always have people speaking here, and they always have the heart-wrenching stories that we have to hear, right? And those are very, very sad stories, but they're not all the stories, right? So there's some positives and there's some negatives. But in these public hearings, we always hear the worst, which is unfortunate. We don't want to see any child get hurt. As far as heart conditions go, I'm not a doctor. I don't know, but I know that there's many things out there that cause heart conditions. like you said, anything that we can do to help somebody, but again, they have to want to do it, right? You can lead a horse to the water, but you can't make them drink it, right? They have to want to learn and take the steps, the proper steps to have a better, healthy life. We really can't control it. That's really what my opposition to this is that it may be something that may help some one or two people. I don't know how many people it would help, but it's certainly not going to solve the problem. And I think more education than anything is important. Listen, we have vaccines out there that they say cause myocarditis, right? We have so much stuff out there that is causing problems and heart problems and mental issues with mental health issues with children. I just don't think this is going to solve the problem, but I appreciate your testimony. Thank you for coming in today.
Thank you.
Excuse me, I'm sorry. Representative Lanu, did you have a question, sir? Go for it. Thank you.
Good afternoon, Doctor. How are you?
Very well, thank you, sir.
Good. Yeah, I just as I was sitting here, I wasn't planning on speaking on this, but kind of an issue, kind of popped in my head. If we do go down this road where, like I said, okay, you're under 16, you can't buy these in the store. If you have somebody who's older, an adult who, can almost create an underground market where they go and they purchase these, perhaps open them up, lace them with something else, sell them to the under 16 population. Could we actually be creating a worse situation and creating a bigger problem by essentially making this illegal for a whole group of young people? I mean, we see that with all sorts of other products. Could we be creating a similar situation here? Yeah, in your opinion?
I think the under 16, is taking a step that, and, maybe, making a small assumption that if you are heading, go into the store to buy those things, that you're likely going with an adult, you're going with a parent, because you're not driving there yourself. So you're going with somebody older. But, to your point, I think, we do limit the age that you can purchase cigarettes. We limit the age that you can purchase, alcohol. It doesn't mean that, somebody older of those ages can't, purchase and provide, as you're saying in this case. But as I said, if there's a measure and a state and a step that we can take to help, and maybe, those laws are in place to, again, support the education that we're given of what the appropriate age and timeframes would be to purchase some of these products, that, maybe that statute and that law can align with the education of when maybe those choices would be best for individuals.
Yeah, I mean, 'cause if I'm a bad guy and I'm into criminal enterprise and I'm selling things on the underground market because it's more expensive on underground market. I go and buy a bunch of these. Again, I can open them, I can refill them with God knows what else. And get the word spread with the younger teenagers that, hey, go check out this guy. Yeah, he's got all these underground products, where not only are they getting attracted to the energy drinks, it may be a laced energy drink, but who knows what else, whatever other array of substances or products now get exposed to these kids, because now we're essentially creating we're making this illegal to purchase, without, in different circumstances.
Yeah.
So that's my concern with all this. Like I said, your view on that in totality. But
Yeah, I appreciate that. I think, as you're saying, there's probably no perfect solution. I think even, the ability to order product online, I'll tell you, as a principal, we've seen that a lot with, kids getting vape devices and other things, and talking with parents about those was, it was purchased online, it was delivered, to another house, and it was so kids get creative, and people get creative. But I think ultimately, the decision that we're making is not what potentially can somebody get around in creating what that restriction or that standard would be, but is it the right thing to do in terms of what we should have available by law, and and then again continue that education piece, and do our best to try to ensure that people stick with it. But you're absolutely right. Is there's a workaround today, you know, in pretty much anything.
Oh, I certainly appreciate that, that answer. I really want to thank you for your work with the CIEAC, encouraging kids to get into athletics. Very, very important. This might be a little bit of a biased opinion, but I think it is a bipartisan biased opinion. I'd love to see powerlifting get incorporated. And so not that there's a bias there, but again, I think it's a great sport, and weightlifting, and I know it's been incorporated into a lot of different programs. And I guess I'll congratulate you on what you're doing with the kids. So I do appreciate it, and thanks for your testimony today. I yield back.
Thank you.
Thank you very much. I second that request, by the way. My 12-year-old can probably bench me. So that's fantastic. Senator Anwar.
Thank you so much, Madam Chair, Dr. Longorini. Thank you so much for your testimony and placing your experience in a manner to help us be better prepared. Now, with what I heard from your testimony is that you do support with your experience with young boys and girls that this is important to be able to restrict the sales for some of these energy drinks to our children. Did we hear you correctly, right?
Correct.
And how would you respond if somebody said that, look, it does not matter 1 or 2 children or more dying, and the market will take care of itself, and we don't want to become overprotective from the state policy? How should we respond when somebody says that?
Thank you, Senator Anwar. You know, as I stated previously, I think that if we can take steps that aid in the education that we're giving kids and align with what we are trying to teach in best decision making for what can help keep your bodies healthy, you know, the high energy drinks, the high sugar drinks that are purchased, and when looking at it from a sport perspective, it doesn't provide any sort of enhancement. If anything, it may have an adverse effect, believing that this, you know, will help you energy wise. But again, that the aspects of the sugar, of the caffeine, are going to wear off so quickly that it's not going to have that impact. And if you do have these underlying cardiac issues that we're seeing more and more of, the caffeine can have a very negative impact to that. So that would be my approach is, you know, again, we're not trying to necessarily limit anybody's decision, but an ability, but to purchase something. But what we're trying to do is align best practices between what we believe is good and healthy for kids as they're developing, as they're participating. I'm looking at it through the sport lens. And then how do we align that with what we readily make available to them for purchase?
Yeah, thank you so much. I agree with you. I think we have a collective responsibility when children are dying, and there's a risk of large number of them having addiction to another chemical, but also that's dangerous to their hearts. We actually, as a state, have to pause and then look at the data, look at and listen to the scientists, the people who are there, and try to make the best decision to save our children and protect them. So I agree with you that we have a responsibility to educate, but also have a responsibility to restrict that easy access. Now, will we be 100%? No. But just because we won't be 100% doesn't mean we look the other way. So I appreciate your testimony. Thank you, Madam Chair.
Thank you very much, Senator. Representative Dauphiné.
Thank you, Madam Chair, and thank you here for coming today for your testimony. My question is, you know, with the data that shows that these energy drinks, in many cases, and some of the data I have here show that the caffeine level, which is what you were speaking about, and some of the sugar, but the caffeine level is much lower in those drinks versus the coffees that our kids are buying. So would you be favorable in prohibiting the purchase of the caffeinated drinks such as coffee, tea, and Coca-Cola, which has a high amount of caffeine as well? If you look at many of the charts that are put out, would you be favorable of that as well for children under 16?
Yeah, you know, again, I think one of the primary differences when we're looking at the purchases of those, if I'm going to go and I'm going to purchase a coffee or, you know, some sort of drink from a Dunkin' Donuts or Starbucks, if I'm under 16, it's likely that I'm purchasing that drink with an adult, with a, you know, whether it's a parent or, you know, somebody else with me who's taken me to the store to do that. Looking at it through the sports lens, when I'm, if I'm on a sport field and I'm looking at what are kids reaching into their bag and pulling out and drinking, it's more along the lines of, the Red Bulls. It's along the lines of, the, energy, the energy drink type that's in a can. So, again, as we were just saying with Senator Anwar, I don't know that, any one step that we take will solve the issue across the board. But if taking that step does help in making movement towards aligning what we believe is in the best interest and what is healthy for kids, I think it's a good step to take. But as you said, it's will we stop kids from having that coffee? Not at this point, but maybe banning something that is that we do see them going to quite frequently raises other awareness, and maybe that helps them think more about those choices as they're making them.
Thank you for that testimony. In my town, the Dunkin' Donuts is right near the high school. And I can tell you that right after school, they
Running
fire
across the
over there and they get their coffee. So to be consistent and fair, when we're looking at the amount of caffeine in these energy drinks versus these coffees that children are, it seems to me to be consistent, we should prohibit all of it.
Yeah.
So anyway, thank you so much.
Are there any other questions? Seeing none, thank you, as
Thank you.
always, for being here.
Thank
We
you.
appreciate you. Next, we'd like to call, please, Alicia Jackson, followed by Carly Van Buiten and Dawn Matos.
Good afternoon, everybody. In January of 2023, our family was relocating across the country to my home state of Connecticut on military change of duty station orders. During our trip, we stopped in Tennessee to visit family for Christmas. During this visit, my husband was changing my 6-week-old twin son and heard a pop. This prompted us to take him to the closest emergency room to get him checked, as any concerned and responsible parent would do. The Children's Hospital ordered labs, x-rays, and CAT scans. The x-rays revealed that our son had a fractured humerus bone. The hospital said the injury was suspicious for non-accidental trauma and called in CPS, or Child Protective Services. Both the hospital and CPS requested an eval of both of our sons, including our other twin who was with us at the ER. We both gave permission. At this time, we were not allowed to have unsupervised contact with our babies. The next day, the hospital discharged the twins back into our care, but later that night, Child Protective Services called, instructing us to bring one twin back to the ER. A different radiologist identified old and healed fractures not seen by a previous radiologist. CPS threatened to take both our sons away if we did not comply. At the hospital, I asked about abnormal lab results, potential birth injuries, and brittle bone diseases, but my questions were dismissed, attributed solely to non-accidental means. Child Protective Services then took both of our 6-week-old twin sons into the Tennessee foster care system. Through legal support and collaboration with advocacy groups, we sought second medical opinions of highly qualified medical experts. Pediatric specialists, including a pediatric orthopedist and radiologist, identified vitamin D deficiency rickets in both twins, which was evident in their x-rays. The deficiency causes softening and weakening of the bones. A geneticist and endocrinologist also evaluated and diagnosed the twins, my mother and I, with a connective tissue disorder called Ehlers-Danlos syndrome. The syndrome has been known to cause easy bruising and skeletal fragility. Despite sharing these clear medical findings with Tennessee Department of Children's Services and CPS, they still refuse to give our twin sons back. Our next court date is July 25th, marking 572 days that they have not been in our care. When our twins were taken, we awaited an agonizing 7 weeks for the approval of a court-ordered expedited interstate compact agreement. This allowed the twins to move to Connecticut under CT-DCF supervision. There were a lot of delays in getting a provisional approval from Connecticut due to all the requirements that the Compact Administrator's Office requested. These were not federal requirements, but rather the ICPC's office requests. The home study was already approved and the house was deemed safe. Criminal background checks were done, as well as financial and medical documentation secured. A thorough review of the requirements set forth by the Compact Administrator's Office during a provisional approval of an ICPC should be a priority because making these changes would be in the best interest of the children involved. Thank you.
Thank you very much for sharing your story with us. I understand how hard that is, and especially to come in front of a room full of people that you really never met before and talk about these things. So thank you for sharing your story with us. Are there any questions? Rep. Pizzuto.
Thank you, Madam Chair. Ms. Jackson, I know in 3 minutes you synopsized probably the most terrible thing that can happen to parents. Is there anything that you wanted to expand on? I know you said 500 plus days for the next court date, but is there anything?
I can tell you we have not stepped foot in a courtroom to have the ability to testify that we did not abuse our children. We have 4 medical experts ready to testify to that exact fact. Tennessee has seen these reports. The courts, they have not given us an opportunity to do so. I can also tell you that the original judge that took custody away from us was just recently asked to step down and was charged with 4 felonies and pled guilty to, I believe, at least 3 of them. And he's awaiting sentencing as we speak.
And my last question to the chair, are you able to visit your children while is it your parents or someone has custody?
Yes, sir,
Yeah,
we
so-
do. My parents have custody of both the twins now.
Very good. Thank you.
Thank you very much, Representative. Representative Lanu.
Thank you, Madam Chair. Mrs. Jackson, thank you so much for this which is, I'm sure, very painful testimony for you. As a representative who represents your hometown, I wish I could say I know what you're going through, but no, I don't. I wish I did. I can just imagine the pain. I can see it in your face and in your voice. And I really hope in some way we can alleviate whatever we can do to alleviate this and just get closure to this one way or another here. This is, I can't imagine. With that, and I want to be clear. And I want to ask you about Connecticut DCF. And again, I want to be clear with the line of questioning here. I am not saying anything that they may have done right or wrong, or my concern is what they can or cannot do based on legal restraints, because you're going from A, Tacoma, Washington, to B, Groton, Connecticut, in military service as a military family, and transiting through and having your feet on the ground in a third state at the time. There's what I'm hearing, and I just want to try to make this clear, whether it's through ICPC, a piece of ICPC, or what the child advocate talked about today, the UCCJEA. What I'm curious is, to back this up, you mentioned the pediatric reports, the pediatric endocrinologist, and that did an assessment on you and your mother, I believe you said.
Yes.
And their reports. Again, I want to make crystal clear. We're talking about Tennessee, a place you're in for a minute, but your home state, your resident here, and I'm just curious. Did Connecticut DCF say to you, or were they willing, or do they have the ability under current law, based on these interstate compacts, do they have the ability to review this and make a decision and protect you and your family as Connecticut residents?
They do not, as it pertains to the twin boys. They are strictly bound to just supervising the visits and allowing them to stay here and have the ability to give reports back to Tennessee on how their boys are doing and if we're doing everything that we're supposed to be doing to get our sons back.
Okay, and again, and I think I had gone through this with your husband, his testimony earlier today, that essentially, under the underlying matter that happened in Tennessee and their decision to take your children from you, we can't look into it right now under the way that these based on these compacts. If Connecticut DCF was willing and able, ready and able to do it in a minute, we can't, because another state made this decision based on your on transiting from the West Coast to the East Coast for military service. Another situation I know that came up. By the way, congratulations, you had a baby girl.
I did.
Since being back, has this at all implicated with this whole matter with Tennessee, with your twin boys? Did anything arise as far as custody regarding your baby girl?
Yes, it did. So when she was born, about a week after, the worker that kind of supervises the contact between Tennessee and Connecticut, she filed a report that my daughter was born, and based on Tennessee's allegations, said that predictive neglect was potentially there. CPS came out, did an investigation, CPS in Connecticut, and unsubstantiated that. And our daughter lives at home with us, and she's perfectly healthy and good. The Attorney General for the state of Connecticut reviewed all of the medical records we had from our specialist. She also reviewed whatever Tennessee provided to them to support their case. And Connecticut here, DCF, the Attorney General, told us we could have our daughter at home and that she was safe and we are not a harm to children.
What medical records are you referring to? I'm sorry. Was it for
The Tennessee medical records that Tennessee is using to keep our children away from us.
so the boys'
there's-
medical records?
Yes, and then, yes, sir. And they also reviewed our expert report saying otherwise. And they made the determination that that she was safe at home with us.
Thank you. I think I've done my two, so I'll yield back.
Bless you, thank you. Did you already ask? I'm sorry, it's blending. Representative Dauphiné.
Thank you, Madam Chair, and thank you for being here, Alicia. It's just impossible to get every single piece of this case out in this short amount of time where we only have 2 questions. But we're trying hard to get what's most important and what's most compelling to the state of Connecticut to let them know how perhaps we can make these intercommerce relationships work better. I know you spoke about the doctor who saw your boys in Boston, and I wanted you to expand on those results and Tennessee's response. And I know that I wanted you to just speak a little bit about, now that you have a daughter and you've been able to enjoy her at home, most of us in here are parents, and we know how wonderful that is to have a newborn at home and be parents and being able to spend time with them and put them to bed at night. I know I think I recall you saying you were nursing her. Can you just expand on the impact and the trauma that brought to you and your husband with your inability to do all those things are so precious? And now we're looking at, they're 14 months old. Tennessee is not, yeah, and Tennessee has not once had you back into court to defend yourselves, or it's been 14 months. They made an allegation in one visit, your boys were taken away, and they've been gone ever since. And, you know, I just want to say, if you were here in Connecticut, there's so many advocates here for you and so many people that we can work with, and we're minus that because this case is in Tennessee. So if you could expand on a few of those things. One, the doctor, I wanted to hear a little bit more about that, and one about the impact it's had on you and all of your family.
Yes, I will do my best. So back in July of this past year, we went up to Boston University and met with Michael Hollick. He's a doctor. He holds a residency there at the university. We also met with a geneticist, and they reviewed our medical records. They did full evaluations of both myself, my mother. They looked over Matt as well, and both the twins. And we were diagnosed with Ehlers-Danlos syndrome, a clear clinical diagnosis. A report was written up, and we presented this to Tennessee, who basically rejected it and said, you know, this is something we'll talk about in court when the time comes, kind of thing, instead of acknowledging it and allowing us to have our children back. And they've done that subsequently with each report, you know, pediatric radiologist report and a child abuse pediatrician's report and an orthopedist surgeon's report. And so here we are, still fighting that. And then the second question, can you repeat that again?
I just wanted you to expand on the trauma that it's brought your family as a result and all of this time that's gone by that Tennessee hasn't addressed this issue. We're looking at, when are you going to court in March? Is it March?
That was actually pushed back again, now till July 25th is day one of an adjudication.
Right. So right now, your two boys spend every night with your parents and not with you and your husband. So, you know, the trauma of that and what that's like.
And also bringing up a daughter now who isn't around her siblings. It's a multitude of things, but it's something that we're working on the best that we can. And then re-experiencing it again because of the non-resolution of Tennessee and having to go through it with our daughter as well was extremely traumatizing. And we're doing our best to keep it as normal for our boys as the older they get and realize we take their sister home every night. And, you know, they're starting to realize mommy and daddy, they don't stay, they leave and they take sister home. You know, they're starting to come about and realize those things. So we do the best we can to keep it as normal as we can.
Thank you for your testimony. I know you heard the commissioner here earlier. She's new, but we've talked to her. She's very committed to hearing more about this case. And I think she's agreed to meet with Representative Lanou and I. And we are committed to working through this on the Connecticut side of things. And hopefully we can make these commerce compacts better and more favorable to our residents of Connecticut. And for people like you who've experienced this situation, we thank you so much for your testimony. Thank you, Madam Chair.
Thank you very much, Madam Ranking Member. Are there any other questions? Representative Hayes.
Thank you, Madam Chair, and I'd like to yield both my questions to Representative Lanou.
How gentlemanly, absolutely. Representative Lanou.
I thank the good Representative Hayes, and I thank you, the good chair. Mrs. Jackson, I know we can't forget about the past. I'm not suggesting that. But what I do want to ask you is what we certainly can do as far as this bill before us. 5263, which currently the language that's currently in there, it's saying to the DCF commissioner and also to the chief administrator to come up with a report to be able to say, are these, right now the language has to do with the ICPC. As you may have heard some testimony earlier from the child advocate, Sarah Egan, who I would love to see also included in here to overlook this, to see give her suggestions as well. So I guess should I get this all in one question here? If we were able to modify the language in here to include the child advocate as a person to overlook this as well, is there any? Do you think that? Do you agree to that? And is there anything that we should also include in here for language to hopefully try to see what more Connecticut can do that it's not doing? In your situations like yours, other military families and other families from Connecticut that just happen to be in another state and these situations arise. So
Yes, so I think my husband touched on this and I 100% agree with him. I think that it would be great to have Connecticut be able to review the case when they're given these ICPC contracts and have the ability to not only report back to another state that had sent the child about how the children are doing and how the families are doing, but also to have the ability to review and make their own independent decision based on the medical evidence that they're given and the medical records to decide if maybe it was in the best interest of the children to potentially be returned also and be able to at least weigh in on it. Because right now they're not able to. It's binding for the ICPC. They're just basically report givers, so to speak. But I think that with such an important role that they're maintaining the safety of the children, they should be able to have a conversation about where that children or child will be placed overall.
okay, so as the to examine, again, the language in this bill before us, to have if we bring in do you think we should bring in the child advocate
Yes.
to
I
weigh
do.
in on this? And do you think we should, do you think it should be a little bit even expanded a little more than just the ICPC? Also incorporate the UCC, JEA in there as well, that compact that the child advocate was talking about.
Yes, I absolutely do.
So, okay, that's helpful. Thank you, Mrs. Jackson.
Thank you.
Thank you, Madam Chair.
You're very welcome. Thank you so much. Oh, madam, if you wouldn't mind. No, that's okay. You weren't dismissed. No, really, I just, I don't really have any questions. I just wanted to, take a moment to just kind of talk to you mom to mom, right? You don't know, I'm known to everyone on this committee here as I'm the one that gets upset. I'm the crier when we talk about mom issues. I understand and I absolutely feel for you. And the more I hear about what happened, I recognize why you reached out, right? I see like you're helpless because all of these things are out of your control. And it looks like these laws are the ones that are keeping you from your kids. And I totally get that. I will say that Representative Lanou has been an incredible advocate for you. It just the amount of times he's called and texted me about this, I can't even tell you. You know, but and then of course you have Representative Dauphiné, who's a ranking member on this committee, and they're both really committed to helping find a solution. I guess my concern here is how do we find a solution when it's really out of our hands? Because this seems to be really a Tennessee born issue. The bill that is in front of us is actually about looking at those interstate compacts. So I just want to, I want to have you understand and recognize the issues that we as a legislature will run into in the attempt to solve your problem, because we're not sure it will actually do so. Because these interstate compacts, they affect everybody. And if one state changes something that takes us out of the compact, and what the compact does is it also helps us keep tabs on Connecticut children who are in harm's way that head to other states. So, you know, it's about working together. I think there is very clear evidence based on what you provided that Tennessee, that there are some major issues there, what you said with the judge or how they're acting. So I guess this is forming into a question. Once the case in Tennessee is done and adjudicated, will you then plan to spend time here? Like, do you believe that you'll be remaining in Connecticut even when the case in Tennessee has ended?
Oh, absolutely. I was a resident here for 27 years and grew up here. The only reason I moved is because my husband was in the military and we moved together.
And so this is now going to be your home base for long term.
Yes, sir.
And I
Ma'am.
think
Ooh, not sir.
I think the good news is that in your testimony, when you were asking a question, you were asked about what Connecticut DCF did and that they came in and you said, excuse me, that they did their due diligence and they looked at the family and they decided, and the Attorney General's office decided that there was no need for further oversight from Connecticut DCF, correct?
They check on her to make sure she's doing good, but yes.
There's no like additional oversight. I understand where
No.
that could feel like a bit intrusive, but I think then once the Tennessee issue is gone, if it happens that there's actually no case left, that it's completely dismissed, the likelihood then that you would not have involvement in DCF would be much greater. And so I just want to create realistic expectations that if we open up a compact to change it, that creates problems in a million different areas and actually technically doesn't even solve your issue. I thank you so very much for bringing these to light, because we do need to look at them, if only for the purpose of a greater understanding of how things happen in real life. But any changes made to the compact besides us dropping out need to be done in concert with 49 other states. You can't change a compact only as it applies in one state. That's the issue with these compacts. It's an agreement between everyone. So if for some reason we don't find a path forward legislatively, I can say unequivocally that having Rep. Lanu and Rep. Dauphiné fight for you and your family is going to be just as good as if we were able to open up the compact and look at it and make some changes. I feel that it's a little overwhelming for us to do that and out of our jurisdiction. But as co-chair of this committee, I wanted to make sure that you know that we heard you, we understand the issues, and if there is a path forward, we will look at that, but there is some concern about our ability to do that. But you've absolutely been heard. Okay.
Thank you.
Thank you very much. Are there any other questions from members of the committee? Okay, great. Thank you very much. Thank you for your time and telling your story. We'd like to call, please, Dawn Matos, followed by Bob McCullough and Sean Fogel.
Hello, and thank you for hearing me today. My name is Dawn Matos. I'm a resident of Griswold, Connecticut. I'm also a longtime friend of Alicia Jackson's parents, and ironically, I live across the street. So their tragic story impacted me as if it was my own children. And I was prepared to make a statement on this IPC, and after listening to everybody, we have a problem with our system. You're basically saying the ICPC does not need to have changes. It clearly does. And the fact that I had to reach out to my representatives for help, it went on deaf ears, except for Brian Leno, Ann Daphnes, and Doug Dubinsky. All our other representatives were silent. If nothing else, Matthew Jackson serves in the U.S. military and almost died on the USS Connecticut. He almost died, and he has to worry about his children. Our system is broken. I should not have to advocate as much as I have had to advocate for this family. And where do they go? You have a judge that was incarcerated. He had to step down for having sexual relationships with a juvenile court clerk in the courthouse, had inappropriate relationships with prisoners where he was hearing their cases. These are the people that cast a judgment on these people. Chief Petty Officer Matthew Jackson and Alicia Jackson deserve for attention to this case. And I do not want to hear, not one more time, it's a Tennessee issue. We are all mandated reporters for children. These children have been greatly affected. The impact it has done to this family. I'm amazed they stayed as compelled and together as they have. Then you have no idea what it has done to my best friend, Sue, the grandparents. Because they had to do immediate kinship, foster care, their laundry list of what they had to do to get these kids into Connecticut. Of course, they were eager and willing to do it because it was the right thing to do. But they're grandparents, and this ICPC requires them to take foster care classes. I mean, they had to at least initiate that in addition to a boatload of other costs. And while this family is spending thousands and thousands of dollars to win their kids back, and I keep hearing it's a Tennessee problem. It's not a Tennessee problem. It's medical kidnapping is what it is. And we are going to be heard. And I so appreciate our representatives because I reached out to every single one in the state of Connecticut, and people that claim to love our military, they were silent, and it is appalling to me. And I cannot thank Representative Daphnes, Representative Linnell, and Representative Doug Dubinsky, because they are for the people. And I thank you for your time. I cannot stress enough, I am sure the Jacksons are not the only family, because there is abuse of power in Tennessee and all the other states. So in your ICPC, I recommend that you have a clause in there so that when somebody has abuse of power, we do not have to go through all these channels and bankrupt families that are fighting for their children. I thank you very much.
Thank you very much for your impassioned testimony. Are there any questions from the members of the committee? Representative Lanu.
Thank you, Madam Chair. Mrs. Matos, thank you so much. Thank you for advocating. First of all, before I ask you questions, I just want to be clear too what 5263 is all about. And Madam Chair, I very much appreciate your comments for the last witness. I want to make clear what 5263 is. It doesn't speak to, hey, we're gonna redo the compact. We're going to opt out of ICPC. We're gonna put it through the shredder and burn it and hope it never exists again. What this is saying is ICPC, this other compact that might be is affecting the Jacksons and others can we at least look at it and say, is it possible? Can we make changes to it? To have the child advocate, to have the commissioner of DCF, and have the chief administrative judge of Connecticut be able to sit down and say, is it possible? So let's have these people, let's have an extended discussion here. Does this warrant it? At least to have that discussion. I'm not saying maybe it's not possible to modify it. I don't know. I think this is going to take a lot more effort than just today. We need to have this discussion. We need to have this examination. And we're not saying we're going to make these changes. Is it possible? At least let these people come to the table. The child advocate today seemed very open to be part of this and at least examine it. I think it's worthy to have that discussion for a year. I think the Jacksons more than paid their dues to make sure we have this discussion for maybe the next year or two with these folks. Allow others to at least tell their story. Examine us a little further. Look at these records that maybe Tennessee didn't. I'm sorry, I don't mean to be preaching to you, Ms. Matos, but I believe you're speaking on behalf of the grandparents who currently have the children in their custody.
Yeah.
You're here in that capacity. If I understood right, 43 days before they had these children, these babies, twin baby boys, were taken away from their birth parents to be put in a strange state with strangers in some foster care system that we're not familiar with, none of us are familiar with. For 43 days, they were in that situation. Because now with the ICPC, there were things that they needed to go through. The biological grandparents of these twin boys' mother. I guess I'm just wondering, I mean, what was the process? I mean, 43 days? What was the process the grandparents possibly had to go through? The biological grandparents, upstanding citizens, as far as I know. What did they need to go through under ICPC to keep these kids down there, away from their biological parents, with strangers, for 43 days?
So the very day that they were informed by their daughter that they were taking them, the grandmother immediately got on the phone in can you imagine? Desperate, trying to figure out how to get these kids to Connecticut and trying to understand what's even happening. I mean, the whole story is just so bizarre. And they turned around and had to call one of their friends who has a daughter in the DCF system to find out what can we do. Instead of having your DCF workers in Tennessee, it should be a universal thing. Do you have parents? Do you have a kinship? Do you have a place these kids can go? I mean, that should have been, their rights were violated. They didn't even know that was even an option. The grandmother found out, had to call Alicia. Then they had to do the whole court process for that as well. And the DCF worker in Connecticut advised them to make sure you have the judge sign off on it, because that was very important that you obtain his signature. And then they had to go through the whole process. Like I was saying, they had to apply for foster care. They at least had to start it. They had to take CPR and first aid, and they had to be certified in it. These are their grandchildren. It's broke. Our system is broken. And I just think that the ICPC, I get it. I do understand there are real cases out there that children are abused. And I am a huge child advocate. But there has to be some kind of clause in there that, because let's face it, I don't care what, arena you're in, there is abuse of power. And where there has to be some kind of clause in every bill you do for that abuse of power. And, it's just unfortunate that they can't just be grandparents to their grandchildren. They're having to be parents to their grandchildren. They don't get to just have that special relationship. And I feel guilty because I have 2 grandchildren. And I just feel bad because this family is so broken, and how they just pick up their pants and put their shoes on and function day to day. I don't know how they do it. And as you can tell, I'm very passionate. I'm angry because I just want them to enjoy being parents. They've been robbed. And the grandparents are being robbed from being grandparents. It's just sad.
Where I'm angry as a legislator, and again, this is not an indictment under Connecticut TCF, but where there's no way that we can independently evaluate what's going on in another state was made a decision that was made on Connecticut residents who just had to happen to have their feet on the ground at that time with a very questionable judge. Put it lightly. I guess my other question is there disputes between or any type of conflicts between the Connecticut guidelines and the Tennessee guidelines as it relates to, say, parental visitation?
It did. And that was part of the process that held the kids up from coming to Connecticut. Was Connecticut felt that since Tennessee were saying that these kids were severely abused, they only wanted to give them, I believe it was 1 day a week visitation for the parents. And Tennessee turned around and said no, I think they allowed them 5 days, right? 5 days visitation. So, I mean, that contradicts itself, right? You're pressing felony charges on these people. They have to have the felony side in addition to the juvenile side. You're saying that these are awful abusive parents, but you're going to give them 5 days, and Connecticut wanted to give them 1 day. So fortunately, Tennessee, because they have the authority, they were able to get the 5 days, but it has to be a universal. I don't know how you can apply the IPCP and not have it be universal. It has to be. And I think there really has to be a clause in there that protects the parents' rights. They were so violated, and they continue to be violated as they start to lose all their money. It's and Matt has to go out on deployment soon, and he has to endure all this. There has to be an answer, and we are pleading with you.
I hear those pleas, believe me. I I hope 5263, that's where we can move forward, at least try to get answers. Let's apply answers. If nothing can be done at the end of the day, then nothing can be done in the immediate. Let's at least get some facts. Let's get the facts on the table. Let's have a discussion. And we got all the right people. Let's bring them together. Let's bring you guys in and let's have this discussion over the next year or two. I don't think this is a huge ask. Ms. Matos, thank you so much.
Thank
I
you.
appreciate
And
it.
I do appreciate your
I did have two
committee.
questions. I do appreciate
you.
it. Thank you, Madam Chair.
Thank you. Senator Mar.
Thank you for your testimony. Just a quick question for clarity's sake. The judge you were speaking about before, was that judge in Connecticut or Tennessee?
Tennessee.
Thank you so much.
Thank you very much. Are there any other questions? Representative Dauphiné.
Thank you, Madam Chair, and thank you, Don, for being here. We have spent hours on
Many.
the phone, hours. The Jacksons are lucky to have you. You have been a great advocate and a great friend, and for sure, this testimony got out because of you, for sure. You just pushed on, pushed forward. One of the biggest things I see with this state to state thing is that I don't know what Connecticut would do. I do know that Connecticut, when I call them, they respond. I've had good responses. I know the commissioner today agreed to see Rep. Lanu and I, so we will do what we can to further this along. But one thing that seems really apparent to me is the time that's gone by with nothing done. And there's nothing been reported from the day they were removed to now that suggests that there is a problem. If anything, quite the opposite, because Connecticut's been reporting that the family has done everything. They're good family. They're responsible parents. They're not abusive, yada, 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 yada. Why has it been so long? And so that to me really stands out. And I don't know if that can be worked into this ICPC commerce that goes across state to state, but we should have some kind of time frame that children, you can have your voice heard in court and have an opportunity to get your children back in a timely manner. This is just so egregious. And we're grateful that you're here and we're going to do everything that we can. Thank you, Madam Chair.
Thank you very much. Representative Pizzuto.
Thank you, Madam Chair. Very quickly, Ms. Matos, wouldn't a review by doctors with the new evidence of the disease that they say they have erase that? Wouldn't that bring it to a new light to say, under review medically, they were not breaking their legs, they were not abusing the children? It seems like you have that at least as something in your tool chest. But has anyone brought that up? I'm sure doctors could review it, surgeons and pediatric, orthopedic, right?
That is true, but here's the problem. While you have a judge that is under legal matters, he kept pushing their case out and kept pushing it out because he had his own issues going on. So unfortunately, the Connecticut senator that I spoke to, when I explained that about this judge and what's happening in the Tennessee courthouse, she said it's irrelevant to the case. And I said, it's not irrelevant. These people have not had their fair due process allowed. They have not been able to prove they did not abuse their kid. It's so broken.
That would be the first thing I would go after.
Yeah. And even they discredited the doctor up at Boston University. And I think there's a power struggle. I think there is truly an abuse of power. Tennessee is broken. And because of the restrictions, not allowing Connecticut to step in, even though we are Connecticut residents and Matthew serves in the US Navy, I'm like, if nothing else, that blows my mind.
I agree. Thank you for your testimony. It's very compelling.
Thank you.
Thank you.
Thank you very much. And seeing no other questions, thank you
Thank
for
you.
your impassioned pleas.
Thank you for your committee as well.
Absolutely. Next, we'd like to call Bob McCullough, followed by Sean Fogel and Blake Warnock.
Thank you, members of the committee. You've been able to sit through some very powerful stories and passionate testimony today, and it's I'd like to just thank the Jackson family for their service. Certainly when one serves, they all serve. And so my heart goes out to them. My name is Bob McCullough. I'm honored to serve as the Vice President of Clinical Strategy for Kooth. I've been a licensed clinician for over 30 years, working primarily with youth and their families during that time. I am here to testify in support of Bill SB 216. The current charge of this bill as it stands directs the state of Connecticut to delve into a comprehensive study exploring the potential of online software applications in addressing the critical needs of mental health across youth. While we appreciate the state's attention to this innovative intervention, I propose that instead of conducting another study, the state take the next stride by considering funding for a pilot program for digital intervention. Such a pilot would provide tangible outcomes for this body to scrutinize and offer valuable insights into the effectiveness of this modality. For more than 2 decades, Kooth has served the behavioral health needs of youth and young people via digital means. First web-based and now utilizing an app available on both Android and Apple devices. Utilizing digital means offers a benefit of making behavioral health and wellness to every youth and young person to whom it is available, regardless of the acuity and need. We believe that this population health model effectively augments the more traditional in-person therapies. These therapies, as I'm sure this committee is aptly aware, are becoming increasingly more difficult to access as the pace of the need has outnumbered the number of actual clinicians. A digital application delivering behavioral health services such as ours does not replace the need for traditional therapies. When warranted, rather, it augments what is already available to meet the needs of young people where they are at exactly the time that they need. In our commitment to early identification and intervention, we continuously refine and expand our services. This ensures that youth and young people have a secure, confidential, and timely means to access proactive behavioral health support. Our multifaceted approach within Kooth's platform provides 3 digital guided pathways. First, we have a self-guided pathway where the user can actually dive into more of the psychoeducation path, learning about issues that they may be facing. They also have tools available to them that will help enhance some of that emotional regulation. The second pathway is an asynchronous peer community. These communities are segregated by age groups, and additionally, the peer community is pre-moderated by members of our clinical team. This allows for safety and ensures there is no personal information that is shared. There's no means on the platform by which there can be any kind of direct communication. Therefore, there's no bullying that occurs, there's no personal information shared, and instead creates an environment for encouragement and support from peers. While most users receive what they need through these first 2 pathways, our third pathway does allow for Connecticut-based licensed clinicians to be available for chat-based counseling sessions. Oftentimes, these are just single sessions, but it does allow us the opportunity to be able to assess for risk and then help initiate further referrals as needed. Currently, Kooth is available to over 20 million young people throughout the UK, Pennsylvania, Kentucky, and California. And we'd love the opportunity to be able to support the youth in Connecticut as well. And I'm happy to stand for any questions.
Thank you very much. We appreciate you being here. My question is really, do you have data that you can send the entire committee about any outcomes that can be quantified in the 2 states in which it's currently being used?
Absolutely.
That would be
We're
really,
happy to
really
share.
helpful. I think to provide it for everyone via email to give us all an opportunity to soak it up and look at it would be great. And then my second question is, it's a mental health app. Is it also a school safety app? Like, is there anything in it that has to do with recognizing if someone becomes a school shooter risk or if there is a violence risk somehow within the student body?
It's a great question. Certainly what we're doing with that moderation is for any of the content that's being created in the app, whether that's through the journaling, if it's any articles, forum questions that they develop, that's all being moderated by our team. So we are looking for risk, and it's not only risk to themselves, but it would be looking for risk towards others as well.
Thank you very much. Are there any questions from members of the committee? Senator Mar.
So, thank you for your testimony and question, where is this currently being used? I know it's come a company out of England. Where is it currently being used in the US?
In Kentucky, Pennsylvania, and California.
And do you have any, using my second question really fast, do you have any outcomes you can point to?
We do have outcomes, and we're happy to share those with the committee.
Yes, Senator, go ahead.
Good afternoon. Thank you so much for your testimony. And I've had the pleasure to meet with you, so I've a clearer understanding about what Kooth has to offer. But for the sake of some of these for the committee members who may not have, I would like you to, if you can, go into a little bit more of a, because I know there was some confusion by some of my fellow committee members around the app with the peer-to-peer.
Sure.
Thank
sure.
you.
Yeah, very happy to. Again, what we have found is that in much of our research is that within that peer community, oftentimes that's a great learning opportunity, not only for the youth to be able to garner support and encouragement from each other, but it has to be done in a very safe environment. And that's where we really do introduce the moderation. So with those moderators, they have three primary goals. One is to make sure that they're meeting our community guidelines that are posted for all users to be able to review. It's also an opportunity to make sure that they're staying anonymous. We do not want them sharing any personal information, names, phone number, addresses, location, anything along those lines. And then it gives us the opportunity to assess for any type of risk or escalation that may need to occur. This gives us then that opportunity to make sure that it's a safe environment. It's not a social media platform. So it's not an opportunity where youth can call out another youth. There's no bullying that can occur. There's no opportunity for them to be able to reach out and say, hey, you sound like you're pretty cool. We exchange names and phone numbers? All of that would be caught by our moderators, and that would be removed before anything else would be posted. But what it does then allow is that once there's an appropriate post that's available, or a story or a song or a poem that we see them actually create, that's then where other youth have an opportunity to be able to respond to that. And so it may be an opportunity where somebody who's been having anxiety when it comes to maybe some of their sporting events, they may post that as a question. Somebody else then in that forum may actually see that, respond to that yes, I've had some of those same issues. Here's what I've done to be able to combat some of that. But again, that all goes through moderators before it would actually be posted. So again, no opportunity for any direct peer-to-peer communication. Does that help give some insight?
Yes, that helps me, but I think there may be some questions by
Sure.
some members.
Sure.
And which members would that be? Okay, Representative Esther Francesco.
Thank you, Madam Chair. This is really complicated, at least for me, and we only have two questions. I think if everybody here had two questions, they still probably want more information, really just to see how this works. For me, I'd like to actually see a demonstration. But the states that are using this app, is this app available to download on the App Store?
It is.
Okay. And when you download it on the App Store, do you pay a subscription for it?
You do not. No, currently the app is available throughout the state of California, who just launched as part of Governor Newsom's plan to address youth mental health. We just launched statewide, so it's available to 6 million Californian residents ages 13 to 25. And when so the state is actually paying for the service. So there is no cost to download the app.
Thank you. I have probably 20 more questions, but I think I just used my two. I guess I have no more questions. Thank you very much.
Always happy to be able to schedule some time for a demo or to be able to have further conversation as well.
Thank you, Representative Wielander.
Thank you, Madam Chair. I also have many questions, so I'm going to try to So, I did have a chance to speak with one of the company's representatives yesterday, which was very helpful. With the moderators, with that, and the people that are overseeing the initial contacts, these are real people. It's not AI.
Real
and-
people. We do not use AI.
And they're located in the United States?
Absolutely.
Okay. And then if it needs to escalate, it's a trained clinician, but before it's just content to make sure it's safe and not divulging any personal details or.
Correct, yeah, absolutely. But if it does need to be escalated, or if there's a request for that third pathway, that is with a Connecticut licensed clinician.
Okay. I guess I just went through, I think, 3 questions, but I will say that having learned a little bit more about it, I do have concerns about the implementation of it during school. I know that it would go through the school districts, but we are asking so much of our school districts and our teachers right now, adding one more thing, whether it's a in classroom presentation or an assembly. I do have some worries about taking away instructional time for that, just because they have so many things on their plate currently.
No, I completely understand. And we've worked very closely with the school districts in which we've implemented throughout Pennsylvania and California to really make sure that we make that as light a lift as possible. We have customer success teams that we bring into the state where they take all of that lift. And so the only requirement that we really ask of the schools is a little bit of time, whether that's just for an assembly or a little bit of classroom time. But you're absolutely right.
It's in short supply these days
I
in our
know.
schools.
I know.
But
I
all
understand.
right, thank you very much. I appreciate your time.
Yeah, thank you.
Thank you very much. Everyone all set? Oh, Representative Comey.
Thank you. Thank you so much for your testimony. You mentioned that they would be licensed clinicians here in the state of Connecticut. We have, we're short of them. We're short of those sort of situation. I guess my question is, how do these sessions get paid for? How do the social workers get paid for? How do the clinicians all get paid for? And what does this run through?
Sure, it's a fantastic question. The clinicians all are Kooth employees, and the offering of hours of operation are typically 6 to 10 p.m. and then on the weekends. And so that's when we offer the clinical sessions, because during the school day, we want the students to be focused in on school. And then the evening and the weekends is when we find that the youth tend to need those sessions and that access the most. And so that's when those sessions are available. So they're Kooth employees and they're paid on an hourly rate by Kooth.
So then you do a hiring
We do.
situation here in the state.
We do.
My other second question was just thinking about the peer-to-peer portion of it and how, I've got teenagers and how the tendency to screenshot and do things like that to suppose, perhaps make fun of folks, or I guess, is that an issue in the way that the actually app works? I'm not clear.
No, there's no opportunity for them to be able to have interaction with each other. And so there's nothing for them really to be able to screenshot. And then there would be nothing to be able to share with that. There's not going to be the video capabilities that they can exchange with each other. There's not the audio. So anything that they would screenshot would be already moderated content that is in the app that would be available to every user anyway.
But I'm sorry, there is a peer-to-peer piece of it, right?
It's the opportunity to respond to moderated content that a peer could
I see.
respond to a discussion question or to a particular story that was created, but never direct peer-to-peer contact.
I see. Okay, thank you for clarifying that. And
Yes.
thank you for coming here today.
Thank you. Appreciate it.
Representative Dauphiné.
Thank you, Madam Chair. And a few questions. I probably have 10 too, but I'll try to wrap it up quickly. A few concerns. So can you elaborate on the ability for parents to be involved? Because as I can see it, a child could be on an app struggling with some mental health and the parents would never necessarily know. That would be a concern. I wondered if you knew the cost of this, how it would be paid for in Connecticut and how many children it would serve. If you could answer those questions, I'd appreciate it.
I can. I'll start with the second question first. The cost of Kooth is $30 per student per year for unlimited access to all of the services that are available. So that's the first question, and then we're looking and exploring some different funding options that would be through the state. So there'd be no cost to the school district, and certainly never to the parents or to the end user. This would be a state-funded pilot that we're looking at. Your first question regarding parent involvement. Again, as a clinician with 30 years of experience, parental involvement is key to any success and to any work with the youth. And so part of our implementation process is really making sure that we're educating parents on who Kooth is, the services that are being provided, the process that's available. As far as the different pathways that are being offered. In Pennsylvania, for instance, age of consent is 14. And so students that are over the age of 14 can access Kooth without the parental knowledge, but they've had all of the information up front. Again, through that implementation process, the webinars, the FAQs that we've sent out, we provide information and collateral to the school district to be able to send out so that they know exactly who Kooth is, what we're providing. And then we also have an opportunity to be able to attend school boards meetings and answer any questions that parents may have, as well as an email address for parents to be able to submit questions if they like. And so that's again where we find that the parents are so very vital. We want to make sure that they have all that information up front.
So the parents get the information about the app, but that doesn't necessarily mean they're going to know their children are using it. They only know that it's available to them and they might be using it. So a child could be suffering from some kind of mental stress on the app and the parents may know nothing about that. So I just wanted to say that. And then with regard to the cost, we're talking about $30 per student. I don't know how many students are in the state of Connecticut, but even though the parents might not be directly paying for it, at some point it's going to come on the taxpayer or it's going to be a mandate to the school districts to pay for it. And I was just trying to get a grip on the kind of cost we're looking at in the state of Connecticut if we do $30 per student, because I'm assuming you're not going to offer it for one town and not for another. I'm assuming that at some point you're going to want the whole state of Connecticut to be able to access, all the students in the state of Connecticut to be able to access. So there would certainly be financial gain to you and your company, Kooth, for implementing this in Connecticut. But thank you for your testimony today.
Well, thank you.
Thank you all very much. And we appreciate your time and we look forward to receiving that. If you could make sure to get the email of Christian Tolarski, our clerk, that would be amazing.
We'll do so. Thank you.
Thank you so much. Then we have Sean Fogel, followed by Blake Waronk. I hope I said that name correctly. Hi, Mr. Fogel. Thank you for being here today.
Yeah, good afternoon. Thanks for having me. Yeah, Sean Fogel. I'm here to talk about SB 215. Members of the committee, thank you for your time and consideration on these matters. My name is Sean Fogel. I'm the Director of Support Services for the Connecticut Rivers Council, which is the Boy Scouts of America. We oversee, it's about 75% of the state of Connecticut. I directly oversee camping operation at 3 outdoor facilities in the state, and I sit on the board of the Connecticut Camping Association. After working in multiple states within the camping space, I can say that the state of Connecticut does an exemplary job of institutionalizing safety for their youth, and we are proud partners of the OEC in their work. My thoughts on the bill are as follows. We support the inspection schedule that prioritizes new camps and 1-week camps. We suggest adding language that would list the nationwide accreditation programs that will be recognized. We fully support the codifying of the Youth Camp Safety Advisory Council within the Office of Early Childhood. We would unite behind the nonprofit camp appointee and would appreciate that sphere of influence within the council. We are concerned with the possible selection of the representative from the Connecticut Parks and Recreation Association to that advisory council because of their exemption from state licensing. We support the provision that non-licensed camps submit a annual report. We also would suggest that all unlicensed camp within the state differentiate from state licensed camp with a public facing disclaimer. And that's kind of the end of my testimony, but I guess I would be remiss to say that all the issues that I heard, just like you all today, the breadth of things is incredible. So this was eye-opening for me. You know, I'm 37, never done this, so I really appreciate the time and opportunity. But also youth camps, and I think my partners in the organization would agree that we could be a resource to the state on a number of levels. Like, for instance, my organization, we host grief camps. We host the DCF, their sibling camps, so we can help in another manner. So just wanted to throw that out there at the end.
Thank you very much. Are there any questions? Did you have a question, madam? Nope. Seeing none. Thank you very much for your testimony. Appreciate your time.
Thank you.
You're welcome. Blake Warnock, please.
Hi. Thank you so much for having me. My name is Blake Warrench, and I am a current Health Policy Masters of Public Health student at the Yale School of Public Health. To note, this testimony is not a reflection of the beliefs or ideals of the Yale School of Public Health and reflects my own beliefs. I'm speaking in enthusiastic support of Raised Bill number 218, an act establishing a task force to study the creation and administration of a statewide program for the delivery of bereavement and grief counseling services to children and families. Almost 15 million people in the US will experience the death of a parent or sibling by age 25, and I am one of those people. 2.5 years ago, my sweet mom, Kelly, died of a rare form of cancer. I found myself immediately thrust into the lonely world of grief. The pain has been unthinkable, and my journey through grief has been heartbreaking, confusing, unexpected, and nonlinear. As a young adult, when I lost my mom, I was able to find and luckily afford the services I needed to support me through my grief. However, these services can be expensive, so I'm very supportive of the requirement in this bill for the created program to provide services free of charge to families. I think it really acknowledges that every child deserves access to the support they need, and that grief knows no bounds to age, race, or socioeconomic status. Children who've experienced a loss need specialized services to support them where they are, since they are still learning to process and identify emotions. So I think it is so important for these services to be thoughtful, community informed, and flexible. Our culture tends to be afraid to talk about death, so thank you to this committee for putting up this bill on this issue. But the current culture that we live in can be especially difficult for children and young people who've experienced loss, because when no one talks about or acknowledges your loss, it can create a serious loneliness, which I have personally felt. As Representative McCurdy highlighted earlier this morning, I also urge the committee to add language to include a person with lived experience on the task force, particularly a young person who's experienced loss as a child, because while subject matter experts and professionals on the task force can provide important clinical expertise and evidence, a young person with lived experience will bring a perspective that's often passed over in discussions on policy on grief and bereavement. I personally have been seeing a therapist since the death of my mom, and while she is amazing, I actually rescheduled a session with her so that I could testify today. But the thing that has helped me most in moving forward with my grief has been finding and building community with other young grievers who can understand what I've been going through in ways that others can't. And in that community, I've heard my feelings on this echoed over and over again. So the task force, I think, should have a member who can provide the kind of perspective that may be more creative and community-based on what grieving children really need. So as someone who has walked the lonely and complicated road of grief, I urge you to support this bill and pave the way for a brighter, more compassionate future for Connecticut's children and families. Thank you for your time.
Thank you so very much. And I really appreciate your testimony. I'm very sorry for the loss of your mom. I too
Thank
lost
you.
my mom. And so it's been coming up on, I think, 9 years now. Still feels like yesterday. So I'm very sorry. And thank you very much for actually not going to your therapy appointment, but don't do that.
We rescheduled for tomorrow.
Okay, good. Are there any questions from members of the committee? Okay, seeing none, your testimony was so wonderful. We don't even have any questions. You
Thank
did a
you so
great
much.
job. I appreciate you being here. Thank you so very much.
Thank you.
Have a great day.
You too.
And being that is our last person coming to give testimony, We will now make efforts to adjourn this public hearing. We're going to move to the date and time of next meeting, and that would be today at 4:15 in 10 minutes. So we will take a quick 10-minute break, and then we will start the JF meeting. Thank you all.